Listening to the audio of these very important 90 minutes of oral arguments before the United States Supreme Court. Karen Tumulty joins us now from Time Magazine, who've been covering this story, it seems like forever, but here is a very, perhaps the pivotal day in this entire thing. I'm curious as to how you feel the political game is going to play out. We have senators from both sides inside. Here you see some pictures from the court itself as people begin to stream out, I'm told. Karen, let's hear from you here.
Well, it really does seem that the reality here is that if the court decides to decide in favor of the vice president, it's just the beginning. And if they decide with Governor Bush, we're talking about the end here. And what is going to be fascinating to watch as we finally get these tapes is to hear the court struggling with the question of the legitimacy of the next president. And in fact, if, as Greta was suggesting a minute ago, they're looking at what the standards for the count ought to be, they're really thinking of, how can we assure that whoever is elected here is going to have a shot at starting his presidency with some degree of legitimacy.
Bill Schneider, our political analyst, also joins us. Bill, this is very much about legitimacy. Legitimacy of the courts, legitimacy of the institutions of government, and of course, and ultimately, legitimacy of the presidency itself. Let me just say, Bill, before you jump in here, the picture that we're going to be showing you from time to time is the shot outside the courtroom right here where these audio tapes are going to be coming. So if you see someone dash by, it's quite likely they're the person, the sort of Paul Revere of the moment carrying the tapes. Bill?
Well, the legitimacy issue was very much the center of the argument that the court had within itself on Saturday when each side accused the other of threatening the legitimacy of the new president. That's where it really got to be bare-knuckled politics. The dissenting minority, the 4 justices, I think Justice Stevens wrote on their behalf, said that if you don't count the ballots, the legitimacy of the new president will be forever in doubt. And right now, Democrats are saying, those ballots are eventually going to be counted under the Freedom of Information Act or the Florida Sunshine Law, and we'll know who really won Florida. I'm not sure we will, but that's what the Democrats are arguing, and therefore it makes no sense not to count the ballots now. On the other hand, Justice Scalia responded to that argument with a scathing argument of his own. Counting the ballots when they are of dubious legitimacy doesn't add legitimacy to anything.
Well, in fact, what he said, if we can steal Scalia's words, he said, count first and rule upon legality afterwards, he wrote, is not a recipe for producing election results that have public acceptance of that a democratic stability requires. I'm told David Boyce, the attorney for Gore and Company, coming to the microphone.
I feel tired. It was a very good argument. The justices were obviously extremely well prepared. They asked a lot of very probing questions. They required a review of the cases and the trial record, and it was a very satisfying argument, but one that required a lot of work.
Do you assume this is the last one you're going to be making in this case?
I'm not sure. Every time I've made a prediction about what the last argument was, I've been proven wrong. So I don't want to say that this will be the last argument, but I think this was an extremely important argument.
Any questions surprised you at all that you...
I'm sure there were questions that I wasn't prepared entirely for. I think there were a lot of questions that I was prepared for. What you had was a 45-minute interrogation, and it was a very, very good bench. Everybody was very well prepared.
Which questions were you not anticipating?
I don't think there was any particular question that I was not anticipating.
No line of attack?
I don't think there was certainly no subject matter that had not been raised before.
Mr. Boyce, the majority opinion.
What was the questions about the unequal standards of the ballots?
I think one of the issues that the court clearly has in mind is whether a standard of the intent of the voter is too general or not. It is, of course, a standard that is applied not only in Florida, but in many, many other states in the country. Some states provide by statute how to define the intent of the voter, although even those states, as for example Texas, also has a catch-all phrase that says if you find the intent of the voter from any other source, you're to give the intent of the voter weight. What you have in Florida is a consistent line of authority that goes back for almost 100 years, that the primary consideration is the intent of the voter and that there is no specific identification of what that means, other than that it has to be determined on a case-by-case basis.
Much has been made of the notion that you would have to try to sway Justice O'Connor and or Kennedy. Did you direct any of your comments at them? Were you sort of looking at them more?
When they asked me questions, I looked at them, and when other justices asked me questions, I looked at them.
Was there any justice who asked you more questions than others?
I think they all asked a lot of questions. Almost all of them asked a lot of questions.
Did Justice Thomas ask any questions this time?
Justice Thomas did not ask any questions this time.
Justice O'Connor seemed to say that the voters should have followed the instructions. She seemed quite emphatic on that.
I think that Justice O'Connor did ask about that. I also think that Justice O'Connor was aware of the Beckstrom case that both sides discussed, in which the Florida Supreme Court reaffirmed 2 years ago that voter error was not a rationale for disregarding a vote. And this, of course, goes all the way back to 1917 in State against Darby, in which the Florida Supreme Court said, even though the voter is told to make an X in a particular place, if the voter makes the X someplace else, but you can tell what the voter's intent was, that vote has to be counted.
How did you feel you did? Can you make any predictions?
Oh, I wouldn't predict about that. The judges will decide what the right decision is. Their job is to decide the case. My job is to make the arguments.
Do you think their reaction was positive or negative towards your argument?
Again, I don't think that you can read into the court's questions what they're going to decide. What they're doing is they're probing both sides. They're trying to figure out what the right way is to decide this case, and they're going to decide that. I'm not going to decide that.
But is it fair to say from the way the state was written that it implies that they were already favoring Bush's argument coming into this discussion?
Well, certainly the fact that the stay was granted, as Justice Scalia noted, means that a majority, 5 justices, found that there was at least a reasonable probability that Governor Bush's side would prevail. However, as Justice Scalia also indicated, he would come into the argument with an open mind. He would listen to the arguments, as I'm sure they all did. They all asked questions, and I think that while it's an uphill battle with respect to somebody that has a point of view, I think they will make an effort to listen to the arguments and make a decision based on the arguments.
Were you surprised, sir, that Justice Thomas didn't ask you any questions at all, since so many minority voters feel as though they've been disenfranchised?
I wasn't particularly thinking about who was asking questions. I was just trying to answer the questions as they came.
Did you define anything from the questions that Justice O'Connor and Justice Kennedy in particular asked?
Not other than that they were very interested in the issues that both sides had raised, and that they had obviously read the cases. Justice O'Connor had a number of Florida cases that she was interested in.
Is it true that this is the first time in the history that the Supreme Court has ever taken a case involving the election in over 100 years?
I think this is the first time that the United States Supreme Court has ever taken a case that would decide the future president of the United States in its history.
Can you envision a scenario in which this is not the final decision, what comes out of this?
Well, we still don't have the votes counted. And those votes, from our position, need to be counted. If the Supreme Court agrees that the votes need to be counted, we'll go back to Tallahassee and count those votes.
And if they agree that they're not to be counted, is that the end?
If the Supreme Court rules those votes are not going to be counted, then the votes are not going to be counted.
Is it a fact that December the 12th?
Mr. Boyce, why do you believe that there is more time, that there is enough time left to do what you are asking than some of the justices seem to be suggesting there is?
Well, first of all, we know that the count was proceeding very, very rapidly and could have been completed in about a day or a day and a half. Whether we can now get it completed in a day or not, I think is open to question. Thank you very much. Thank you very much.
Have you had a chance to speak with the Vice President?
David Boies, the Gore attorney, who was speaking at the microphones very, very quickly, and just a couple minutes remaining, over to Charles Bierbauer at our microphone. He was inside the courtroom. Charles, tell us about your overall sense and what you heard.
Frank, very much more grappling with the intricacies and the mechanics of the Florida voting process, down to the dimples and the chads, and the whole process of counting the votes and the protest and the contest and how that should be judged, and the justices seeming far less informed about the mechanics and somewhat concerned about two elements of the law. From what would favor the Gore perspective, a lot of questions about the need for judicial review. Is there any reason why there should not be some form of judicial review in the Florida courts looking at the legislature, how it has defined the election laws? And from the other side, a point which the Bush attorneys very much wanted to get into this case and succeeded in this matter is the matter of equal protection. The notion that votes were being counted in different ways and in different counties, that there was no uniform standard. Repeatedly, justices from all across the ideological spectrum that this court is purported to have came to this question of equal protection.
Charles,
Justice O'Connor did, Justice Souter did, and just about every one of them.
Charles, let me jump. We have about 30 seconds before the tape rolls. Did you hear any questions or particulars from Justices O'Connor or Kennedy to suggest where they may be headed on this?
Well, Justice O'Connor and Justice Kennedy both very much concerned about the equal protection aspect, this notion of different ways of counting. And Justice O'Connor said, wasn't there a red flag there?
All right, Charles, we've got about 10 seconds or so before we hear this tape, so we're going to go and listen now.
We'll hear argument now on number 00949, George W. Bush and Richard Cheney versus Albert Gore et al. Before we begin the arguments, the court wishes to commend all of the parties to this case on their exemplary briefing under very trying circumstances. We greatly appreciate it. Mr. Olson.
Mr. Chief Justice, thank you, and may it please the court. Just 1 week ago, this court vacated the Florida Supreme Court's November 21 revision of Florida's election code, which had changed statutory deadlines, severely limited the discretion of the state's chief election officer, changed the meaning of words such as shall and may into shall not and may not, and authorized extensive, standardless, and unequal manual ballot recounts in selected Florida counties. Just 4 days later, without a single reference to this court's December 4 ruling, the Florida Supreme Court issued a new, wholesale post-election revision of Florida's election law. That decision not only changed Florida election law, yet again, it also explicitly referred to, relied upon, and expanded its November 21 judgment that this court had made into a nullity.
Can you begin by telling us our federal jurisdiction? Where's the federal question here?
The federal question arises out of the fact that the Florida Supreme Court was violating Article 2, Section 1 of the Constitution, and it was conducting itself in violation of Section 5 of Title 3 of federal law.
On the first, it seems to me essential to the Republican theory of government that the constitutions of the United States and the states are the basic charter. And to say that the legislature of the state is unmoored from its own constitution and it can't use its courts and it can't use its executive agency, even you at your side concedes it can use a state agency, seems to me a holding which has grave implications for our Republican theory of government.
Justice Kennedy, the Constitution specifically vested the authority to determine the manner of the appointment of the electors in state legislatures. Legislatures, of course, can use the executive branch in the state, and it may use, in its discretion, the judicial branch.
And why didn't it do that here?
It did not do that here because it did not specify. It did use the executive branch. In fact, it vested considerable authority in the Secretary of State, designating the Secretary of State as the chief elections official. And as we point out, the very first provision in the election code requires the Secretary of State to assure uniformity and consistency in the application and enforcement of the election law. The Secretary of State, as the executive branch, is also given considerable other responsibilities. And to a certain extent, especially in connection with the contest phase of the election, certain authority was explicitly vested in the circuit court of the state of Florida, which is the trial court.
But you think then there's no appellate review in the Supreme Court of what a circuit court does?
Certainly the legislature did not have to provide appellate review.
Well, but it seemed apparently to just include selection of electors in the general election law provisions. It assumed that they'd all be lumped in together somehow. They didn't break it out.
Well, there is a breakout with respect to various aspects of Florida statute and Florida election law. There's a specific grant of authority to the circuit courts. There's no reference to an appellate jurisdiction. It may not be the most powerful argument we bring to this court.
I think that's right.
Because notwithstanding, well, the fact is that the Constitution was what may have been invoked.
Well, this is serious because it indicates how unmoored, untethered the legislature is from the Constitution of its own state, and it makes every state law issue a federal question. Can you use this theory and say that it creates some sort of a presumption of validity that allows us to see whether this courts or the executive has gone too far? Is that what you're arguing?
No, I would say this with respect. It would have been a perfectly logical, and if you read the statutes, a perfectly logical, especially in the context of a presidential election, to stop this process at the circuit court and not provide layers of appeal, because given the time deadlines, especially in the context of this election, the way it's played out, there is not time for an appellate trial.
I have the same problem Justice Kennedy does, apparently, which is I would have thought you could say that Article 2 certainly creates a presumption that the scheme the legislature has set out will be followed, even by judicial review in election matters, and that 3 U.S. Code Section 5 likewise suggests that it may inform the reading of statutes crafted by the legislature so as to avoid having the law changed after the election. And I would have thought that that would be sufficient rather than to raise an appropriate federal question rather than to say there's no judicial review here in Florida.
I think that I don't disagree with that, except to the extent that I think that the argument we presented and amplified in our briefs is a good argument. It's a solid argument. It is consistent with the way the code is set up, and it's particularly consistent with the timetable that's available in presidential election.
Well, it's pretty close. You can say it could be interpreted that way by the Florida Supreme Court, I suppose. Well, you think it must be? Or is your point that even in close calls, we have to revisit the Florida Supreme Court's opinion?
No, I think that it is particularly in this case where there's been 2 wholesale revisions, major restructuring of the Florida election code. We don't even get close to that question at all. It would be unfortunate to assume that the legislature devolved this authority on its judiciary sub silentio. There is no specific reference to it, but in this case, as we have pointed out, especially the decision of last Friday, there was a major overhaul in almost every conceivable way.
But Mr. Olson, as I understand your argument, you rely on Leeser against Garnett and Hawk against Smith. And is it critical to your Article 2 argument that we read the word legislature as narrowly, I mean, the power granted to the legislature is similar to that granted in Article 5 of the Constitution, as those cases dealt with?
No, I don't think it's necessary.
So you really are not relying on those cases?
Well, I think those cases support the argument, but
except you got to choose one version of the word legislature or the other.
I think in different contexts it's not necessarily the case, and certainly it is true that legislatures can employ the legislative process that might include vetoes by a state chief executive or a referendum when the state deliberately chooses a legislative method to articulate a code. The point I think that's most important and most...
But is it the choice of the legislature, or was it constitutionally limited to this provision? I'm a little unclear on what your theory is. Is it your theory, in other words, that they voluntarily did not permit appellate review of the lower courts in these election contests, or that the Article 2 prohibited them from allowing appeal to the appellate?
No, Article 2, we do not contend that Article 2 would prohibit them from including
Article 5 would have under Leeser against Garnett in those cases, but
in the context of this case, we're saying that they can include the judicial branch when they wish to do so, but under no circumstances is it consistent with the concept of the plan in the Constitution for the state sub silentio, the state legislature sub silentio, to turn over to the judiciary the power to completely reverse, revise, and change the election code in all of the major respects.
With respect to the role of judicial review, you rely very much on the McPherson case. And two things strike me about that case. One is, if you're right on your jurisdiction theory, then should not this court have vacated instead of affirmed the decision of the Michigan Supreme Court in that case, because the Michigan legislature didn't confer upon the Michigan Supreme Court in that case any special authority of judicial review?
That's entirely possible that might be the case, Justice Ginsburg, but the entire text of the McPherson decision and its recitation of the legislative history, or the history of legislation and acts by state legislatures to comply with it, make it quite clear that the power is vested in the legislature itself.
But there was a decision by the court reviewing, which we affirmed. Under your jurisdiction theory, as I see it, there was no role for the Michigan Supreme Court to play, because Article 2, Section 1 gives the authority exclusively to the legislature, and the legislature had not provided for judicial review specially for that measure.
I think the context of that case is different, and that it's entirely possible for the court to have come to the conclusion it did in that case, and we believe that case is compelling for the principle that we're arguing in this case, that there is no, the entire structure of what Florida did, its election code, in its effort to comply not only with Article 2, but with Section 5 of Title III, is such that it did not intend in any way to divest itself of the power to determine how the appointment of electors would be determined in a federal presidential election, and most importantly, the resolution of cases and controversies and disputes with respect to the appointment.
There's 3 times, at least as I counted, in McPherson itself, it refers to what is done by the legislative power under state constitutions as they exist. This is not the most clearly written opinion, and yet 3 times they refer to the legislative power as constrained by the state's constitution.
And I think that's informed. I agree with you, Justice Ginsburg. It's not the most clearly written opinion. But I think that in the context of that case, the relationship of the legislature to the Constitution in that case and the way that power was exercised, that all can be reconciled with what we're urging the court today. That a wholesale revision and abandonment of the legislative authority can't be turned over, especially sub silentio, by a legislature simply because there is a Constitution. There is a Constitution in every state. There's a judiciary in every state. The judiciary performs certain functions in every state. And to go that length, one would assume that the judiciary in every state, under that argument, could overturn, rewrite, revise, and change the election law in presidential elections, notwithstanding Article 2, at will. Now, this was a major revision that took place on Friday.
Isn't that one of the issues in the case, as to whether it was a major revision? The opponents disagree, and I know you rely very heavily on the dissenting opinion in the Florida Supreme Court, but which opinion do we normally look to for issues of state law?
Well, I think that the dissenting opinion and the 2 dissenting opinions are very informative. We're relying on what the court did. If one looks at, for example, the recount provisions, before this revision, under Florida law, manual recount under the protest provisions were discretionary, completely discretionary, conducted by canvassing boards during the protest phase of the election, post-election period, pursuant to legislatively defined procedures as to who could be present, for 7 days after the election with respect to all ballots in a county. That was mandatory and only available, as we heard last week, for tabulation error up until this election. After the decision of December 8th, in this context, those remand provisions, those manual recount provisions became mandatory instead of discretionary, pursuant to judicial rather than executive supervision, during the contest phase rather than the protest phase, even though it's not even mentioned in the statute with respect to the contest phase, pursuant to ad hoc, judicially established procedures rather than the procedures that are articulated quite carefully in the statute.
On ad hoc, judicially created procedures, the point of subsection 8 of 168. Once we get into the contest phase, subsection 8 gives, at least to the circuit court, leaving aside the question of appellate jurisdiction, about as broad a grant to fashion orders as I can imagine going into a statute.
Well, to read that provision, and it's written quite broadly, but to read that, one has to read that in the context of the entire statutory framework. If one reads it the way the Florida Supreme Court did, the entire process is tilted on its head, where there used to be the decision that was in the election officials, it now becomes in the court. All of the limitations on the remand process that existed during the protest phase, where the standards should be lower because it's earlier in the process, are thrown out the window. The timetables are thrown out the window. The process that exists are there. And
what's the timetable in 168?
There's no timetable.
That's right. There is no timetable there, so that seems to undercut your timetable argument once you get into the contest phase from the protest phase.
Well, I think, but that's only if you untether 168 entirely from the statute and the scheme by which the protest phase takes place over a period of 7 to 10 days in the context of this election, and the contest phase occurs over the next 4 weeks.
It may well be, and I'll grant you for the sake of argument that there would be a sound interpretive theory that in effect would coordinate these two statutes, 166 and 168, in a way that the Florida Supreme Court has not done. But that's a question of Florida Supreme Court statutory construction. And unless you can convince us, it seems to me, that in construing 168, which is what we're concerned with now, and its coordination or lack of coordination with 166, the Florida Supreme Court has simply passed the bounds of legitimate statutory construction, then I don't see how we can find an Article 2 violation.
Well, I am hoping to convince you that they've passed far beyond the normal limits of statutory construction. The changing of the meaning.
You've convinced us certainly that there is a disagreement about how it should be construed, and that disagreement is articulated by the dissents in the most recent case. But I don't quite see where you've crossed the line into saying that this has simply become a non-judicial act. It may or may not be good statutory construction, but I don't see it as
we submit an utter revision of the timetables, the allocation
but Mr. Olson, we're back to the time. There is no timetable in 166.
That's correct.
And what your argument boils down to, I think, is that they have insufficiently considered in 168, that they have insufficiently considered 166 in construing 168. And you may be right, but you have no textual hook in 168 to say untethered timetables imply, in effect, a non-judicial act.
We're not just saying timetables. We're saying that it has wrenched it completely out of the election code, which the legislature very carefully crafted to fit together and work in an interrelated fashion. It isn't just the timetable. The fact that there are timetables which are very important in a presidential election. We are today smack up against a very important deadline, and we're in a process.
Yes, you are, but that is a deadline set by a safe harbor statute for the guidance of Congress, and it's a deadline that has nothing to do with any text in 168.
Well, I believe that the Supreme Court of Florida certainly thought that it was construing, it certainly said so this time, that it was construing the applicability of Section 5, and it was expressing the hope that what it was doing was not risking or jeopardizing the conclusive effect.
And it took that into consideration in fashioning its orders under subsection 8.
And we submit that it incorrectly interpreted and construed federal law in doing that, because what they have inevitably done is provide a process whereby it is virtually impossible, if not completely impossible, and I think it is completely impossible, to have these issues resolved and the controversies resolved in time for that federal statutory deadline. Furthermore, it is quite clear. We submit that the process has changed.
Well, if your concern was with impossibility, why didn't you let the process run instead of asking for a stay?
Well, because we said we'd
find out.
Because we argued, and I believe that there's a very firm basis for saying that that process already had violated Article 2 of the Constitution. It was also already throwing in jeopardy compliance with Section 5 of Title III, because the laws had been changed in a number of different respects, and we've recited them. The timetables are important.
Well, and I thought your point was that the process is being conducted in violation of the Equal Protection Clause because it's standardless.
And the Due Process Clause. And what we know is now the new system that was set forth and articulated
in respect to that, in respect to that, if it were to start up again, if it were totally hypothetically, and you were counting just under counts, I understand that you think that the system that's set up now is very unfair because it's different standards in different places. What, in your opinion, would be a fair standard? On the assumption that it starts up missing the 12th deadline but before the 18th.
Well, one fair standard, and I don't know the complete answer to that, is that there would be a uniform way of evaluating the manner in there's Palm Beach, for example.
A uniform way of evaluating. What would the standard be? Because this is one of your main arguments.
Well, the
intent of the voter is not good enough. You want substandards. And what, in your opinion, would be the most commonly used in the 33 states or whatever, or, in your opinion, the fairest uniform substandard?
Well, certainly at minimum, Justice Breyer, the penetration of the ballot card would be required. Now, that's why I mentioned the Palm Beach standard that was articulated in writing and provided along with the ballot instructions to people voting that the Chad had to be
You're repeating then basically Indiana. Is Indiana, in your opinion, or pre- or 1990 Palm Beach, or either of those fair, or what else?
It is certainly a starting point, and
But would the starting point be what the Secretary of State decreed for uniformity? Is that the starting point under the Florida legislative scheme?
I would agree with that, Justice O'Connor.
And what standard did the Secretary of State set?
And she had not set one, and that's one of the objections that we had with respect to the process, that the selective process that existed and that we discussed in conjunction with the November 21st position. Not only was there not a standard, but there was a change 2 or 3 times during the course of this process with respect to the standard that I was just discussing.
I understand that she has the expertise, and let's assume that under Florida state law she's the one with the presumptive competence to set the standard. Is there a place in the Florida scheme for her to do this in the contest period?
I don't think there is. Well, there's no limitation on when she can answer advisory opinions.
Even in the contest?
I think that that's correct. Now, whether or not, if there was a change as a result of that, of the process, whether there would be problems with respect to Section 5, I haven't thought about.
Well, if this were remanded,
go ahead.
I'm sorry. If this were remanded to the Leon County Circuit Court, and the judge of that court addressed the Secretary of State, like it either is or could be made a party, and said, please tell us what the standard ought to be. We will be advised by your opinion. That would be feasible, wouldn't it?
I think it would be feasible. Now, counsel for the Secretary of State will be up in a moment immediately after me. As I understand, however, the election code, she would have the power to respond to that inquiry. In fact, under the very first, as I mentioned, the very first section of the election code, sub 1, she's not only the chief election officer, but has responsibility.
But I'd still like to get your view as to what would be the fair standard.
Well, certainly one that would, I haven't crafted it entirely out. That is the job for a legislature.
But I'd still like to get your opinion insofar as you could give.
I think that part of that standard is that it would have to be applied uniformly. It would have to be, I would think a reasonable standard would have to be at minimum a penetration of the Chad in the ballot, because indentations are no standards at all. There are other procedural standards.
Mr. Olson, was the Palm Beach standard that you refer to in your brief applied statewide and uniformly? You refer to the Palm Beach standard having changed. Was the Palm Beach standard ever applied on a statewide basis?
I believe it was not, Justice Stevens.
And can we possibly infer from the failure of the Secretary of State to promulgate a statewide standard that she might have inferred that the intent of the voter is an adequate standard?
No, I don't think it's a fair inference either way. Remember, in response to the question from, I think it was Justice Scalia the last time we were here, this is the first time we've had a manual recount for anything other than arithmetic tabulation error. This is something that is unprecedented in the state of Florida. That's another change that took place.
Mr. Olson, you have said the intent of the voter simply won't do. It's too vague, it's too subjective, but at least those words, intent of the voter, come from the legislature. Wouldn't anything added to that wouldn't you be objecting much more fiercely than you are now if something were added to the words that the all-powerful legislature put in the statute?
I think we have to distinguish between whether we're talking about a prospective uniform standard as opposed to something that changes the process in the middle of the counting and evaluating of disputes.
But if we're talking about the contest period, and the statute, as Justice Souter pointed out, speaks with amazing breadth. It says that the circuit judge, this is the text, shall fashion any order he or she deems necessary to prevent or correct any wrong and to provide any relief appropriate under the circumstances. I couldn't imagine a greater conferral of authority by the legislature to the circuit judge.
But we submit in the context of the entire election code itself. Now, the intent of the voter standard, the one that's been cited and relied on by our opponents most, is a provision that's contained in the provision of the election code that deals with damaged or spoiled ballots.
Okay, but there's no question that the closest we can come now under Florida law is an intent of the voter standard. Is it your position that if any official, judicial or executive, at this point were to purport to lay down a statewide standard which went to a lower level, a more specific level than intent of the voter, and said, for example, count dimple chads or don't count dimple chads, in your judgment, would that be a violation of Article 2?
I don't think it would be a violation of Article 2, provided that, if the first part of your question, so if we went from the standard that existed before, the dimple chads that had not been a standard anywhere in Florida, if that change was made, we would strongly urge that would be a violation of Article 2.
Mr. Olson, it is also part of your case, is it not, that insofar as that language just quoted is concerned, the power of the circuit judge to prevent or correct any alleged wrong, it's part of your submission, I think, that there is no wrong when a machine does not count those ballots that it's not supposed to count.
That's absolutely correct, Justice Scalia.
When voters are instructed to detach the chads entirely, and the machine, as predicted, does not count those chads where those instructions are not followed, there isn't any wrong.
That's correct. This has been euphemistically referred to as legal votes that haven't been counted. These are ballots where the system created by Florida, both with respect to the initial tabulation and the preferred system for the recount, the automatic recount in close elections, is to submit those ballots to the same mechanical, objective scrutiny that the initial count was done. And those were not counted either because there were votes for more than one candidate, which would make them over votes, I guess they're calling them, or that they read as no vote, which many people do. Many people do not vote in the presidential election, even though they're voting for other offices.
But as to the undervotes, and as to the undervotes in which there is arguably some expression of intent on the ballot that the machine didn't pick up, the majority of the Florida Supreme Court says you're wrong. They interpreted the statute otherwise. Are you saying here that their interpretation was so far unreasonable in defining legal vote as not to be a judicial act entitled in effect, to the presumption of reasonable interpretation under Article 2?
Yes, that is our contention, and that has to be done. That contention is based upon everything else in the Florida statute, including the contest provisions, the manual recount provisions.
What is it in the contest provision that supports the theory that that was a rogue, illegal judicial act?
Because there is no reference to them, even though that process
is
no
definition. There's no definition. Doesn't the court have to come up with a definition?
In the context of the statute as a whole, manual recounts are treated quite extensively as a last resort for tabulation error at the discretion of canvassing officials.
At the protest.
That's correct. And we submit, and I'd like to reserve the balance.
Is it critical to your position that the Florida Supreme Court erred in its resolution of the shall-may controversy in its first opinion?
I'm sorry, I missed.
Is it critical to your position, because you're tying the two cases together, that the Florida Supreme Court made that kind of error in its resolution of the conflict between shall and may in this era statute?
I don't think it's critical to what we're saying is that what the court expanded upon its previous decision that was vacated in this case, it used the time period that it opened up to do this manual recount to then build upon in the December 8th opinion.
Very well, Mr. Olson. Mr. Clark, we'll hear from you.
Mr. Chief Justice, and may it please the Court, if I could start by addressing a question of Justice Souter with respect to the standards. 166 does have time limits. The time limit of 166 is set by the certification, which is 7 days after the election. The time of the contest, there are time limits there as well. You have 10 days to file a complaint, 10 days to file an answer, and in the context of a presidential election, you then, of course, have the December 12th deadline. So therefore, there are time constraints
which is federal, not state, and occurs in the safe harbor statute.
Yes, but
or as a result of the safe harbor statute.
Yes, Your Honor, but this court, in its opinion that it handed down in the initial Harris case, pointed out that it was clear that there was a desire and a wish by the legislature to preserve the safe harbor.
Oh, I thought the Florida court accepted that too in its current opinion.
They did say that exactly, Your Honor.
Mr. Clark, will you refer to the first Harris case? I think we think of it as the first Bush versus Gore case. You're talking about the same?
Yes, Your Honor.
Mr. Clark, will you address Justice Breyer's question of a moment ago? If there were to be a uniform standard laid down, I suppose at this point, by the Leon County Circuit Court or in any other valid way in your judgment, what should the substantive standard be?
I'll try to answer that question. You would start, I would believe, with the requirements that the voter has when they go into the booth. That would be a standard to start with. The voter is told in the polling place, and then when they walk into the booth, that what you were supposed to do with respect to the punch cards is put the ballot in, punch your selections, take the ballot out, and make sure there are no hanging pieces of paper attached to it. The whole issue of what constitutes a legal vote, which the Democrats make much ado about, presumes that it's a legal vote no matter what you do with the card. And presumably you could take the card out of the polling place and not stick it in the box, and they would consider that to be a legal vote. The fact is that a legal vote at the very basics has to at least be following the instructions that you're given and placing the ballot in the box.
Okay, no, we're asking, I think, not what the Florida election law is at this point, in your opinion, but rather if under the Equal Protection Clause, and I'm drawing on your experience as a person familiar with elections across the country, you've looked into this.
Yes, sir.
What would be a fair subsidiary standard applied uniformly, were it to be applied uniformly across all the counties of Florida, including Broward, a fair uniform standard for undervotes? Remember, Indiana has a statute, Michigan has a statute, 33 states have a statute where they just say intent of voter. But in your opinion, because of the hanging chad, et cetera, what is a fair, not necessarily Florida law, but a fair uniform standard?
Without being disrespectful, Your Honor, I think you've answered the question in terms of phrasing the question. There are any number of statutory schemes that you could select from if you were a legislature. But as a court, I don't think that the Supreme Court of Florida, respectfully, or any other court can sit down and write the standards that are going to be applied.
But in your opinion, if you were looking for a basically fair standard to take one out of a hat, Indiana or Palm Beach 1990, in your opinion, would be a basically fair one?
If I were to take one out of a hat, Your Honor, if I was a legislature, what I would do is I would hold that you have to punch the Chad through on a ballot. In those situations where you have a ballot where there are only indentations in every race, you might then come up with a different standard. But the only problem that we have here is created by people who did not follow instructions.
Okay, can I ask you a different question on Florida law?
Yes, sir.
And the question on Florida law is simply this. What the statute, as I take it, the contest statute, lists grounds for contesting. One of those grounds is rejecting a sufficient number of legal votes sufficient to place the election in doubt. And then the circuit judge is given the power to investigate that allegation, just to look into it.
Yes.
So why would it be illegal under Florida law to have a recount just to investigate whether this allegation is or is not so?
The Justice's question assumes that they are legal votes.
There might be some in there that are legal under anybody's standard.
Your Honor, if they are not properly, if the ballot is not properly executed, it's not a legal vote. The only case in Florida that even touches upon this in terms of a machine ballot is the Hogan case from the 4th District Court of Appeal. In the 4th District Court of Appeal, that candidate lost by 3 votes. And he went during the protest phase to the canvassing board and asked for a manual recount to be done, and they exercised their discretion and said no. And in that case, there is a discussion. He raised the argument that there were ballots in there that had hanging chads and this, that, and the other thing. They would hear none of it, and when it went up on appeal, it was affirmed. So the fact of the matter is that the only case that we have that deals with this handles it in that fashion, and I would respectfully suggest that a ballot that is not properly punched is not a legal ballot. And I think also, sir, if you go through an analysis of the Vice President's arguments and supporting what the Supreme Court does, there is sort of an omelet that is created by going and picking through different statutes. For instance, the clear intent standard comes from a statute that deals with a damaged ballot where you have to create, to put through the machine, a substitute ballot. And there are very clear directions as to what to do to preserve the integrity of the ballot. And the Beckstrom case, which you will no doubt hear much about as the argument proceeds, dealt with that kind of situation. There was a manual recount there. The court did not pass on the propriety of it. The issue was if the election officials took ballots and marked over the ballots, instead of creating a separate substitute ballot, they took that ballot and marked it over so it could go through an optical scanner, which the court found to be gross negligence, whether they would discount the votes. That was the issue that was present there. So I think if you look through Florida law, it is relatively clear that there is no basis whatsoever to be able to find that there's not been a change.
If you did have a situation, I know your position is different, where there were some uncounted ballots due to a machine malfunction, for example, would it not make sense to assume that the standard you used for damaged in ballots would be the same standard you use in that situation?
I don't think so, sir.
What standard would you use in the situation I propose then?
Justice Brennan, the difficulty is that under... I'm sorry. That's why they tell you not to do that. The standard that is in 166 is dealing with the protest phase, and it was brought about in 1988.
I understand, but my question is, if you don't use that, what's that standard? What standard would you use for my hypothetical?
The legislature would have to create one, sir. I don't know what standard.
You're saying that they can't interpret a statute in which there is no explicit definition.
What I'm saying is...
They have to throw their hands up.
No, Justice Breyer, what I'm saying is that...
I'm Justice Souter. You better cut that out.
I will now give up. What I'm saying, sir, is this, that you cannot be in a situation of using the word interpret to explain anything that a court does. The word interpret cannot carry that much baggage.
But you go to the opposite extreme and say, it seems to me, that they can't look, as Justice Stevens suggested, to a statute which deals with certainly a closely analogous subject at a near stage. And it seems to me that you, in effect, go to the opposite extreme that you're excoriating the Florida Supreme Court for and say they can't interpret at all.
I think what the Florida Supreme Court should do in that instance is note the very tight restrictions that exist under the protest phase. They require that you find voter intent with respect to a damaged ballot. They also vest it in the canvassing board, and the canvassing board is composed of a defined group of officials, a county judge, the election supervisor, the chairman of the county commission.
But that means that a court apparently cannot define legal vote.
That's correct.
Mr. Clark, I'm Scalia.
Yes, sir. I remember that.
Correct me.
It will be hard to forget.
Correct me if I'm wrong, but I had thought that although you don't take into account improperly marked ballots for purposes of determining whether there will be a manual recount, I had thought that when there is a manual recount for some other reason, and you come across ballots of this sort, that you can count them, that for that purpose you can decide, oh, look, there's a hanging chair, the machine didn't count it, it's clear what the intent of the voter are, we'll count it. Is that not correct?
Yes, Justice Scalia, that is correct.
Okay.
If you have a situation
It's correct that you use the intent of the voter standard in that situation.
Pardon me, sir?
It's correct that you use the intent of the voter situation in that standard in that situation. That's
it is correct that that statute provides that. I think that statute there could be problems under it, but that statute was designed for a very limited situation where there was a problem with the mechanism of voting. It was not designed to handle voter error, and that is absolutely clear, because otherwise, Your Honor, what would occur is the following, that in every election that you have that was close, you would have an automatic recount, and then irrespective of what the canvassing board does, just load all the ballots together and put them on a truck and send them to Tallahassee. Because if there is no standard whatsoever, and in any election contest that you're unhappy with the election, you can send the ballots to Tallahassee, then you have a problem that is created that would not exist under 166.
Thank you, Mr. Clark.
Thank you.
Mr. Boyes, we'll hear from you.
Thank you. Mr. Chief Justice, may it please the court. Let me begin by addressing what happened in the Beckstrom case that Mr. Clark refers to.
Could we begin with jurisdiction first? Yes. The Supreme Court of Florida said that it was cognizant, and the legislature was cognizant of 3 U.S.C. Section 5. And for convenience sake, let's call that new law. That's not exactly the same, but when the Supreme Court used that word, I assume it used it in a legal sense. Cognizance means to take jurisdiction of, to take authoritative notice. Why doesn't that constitute an acceptance by the Supreme Court of the proposition that 3 U.S.C. Section 5 must be interpreted in this case?
I think, Your Honor, and obviously this court and the Florida Supreme Court is the best interpreter of that opinion. But I think a reasonable interpretation of that opinion is to say that what the Florida Supreme Court meant by cognizant is that it was taking into account the desire to get the election over in time so that everyone would have the advantage of the safe harbor. Well, I think that goes throughout the opinion.
The language used in 3 U.S.C. Section 5 is a garden variety language so far as the courts are concerned. We can determine whether or not there is a new law or an old law. That's completely susceptible of judicial interpretation, is it not?
Yes, I think it is, Your Honor.
All right. And it seems to me that if the Florida court and presumably the Florida legislature have acted with reference to 3 U.S.C. Section 5, that it presents now a federal question for us to determine whether or not there is or is not a new law by reason of the various Florida Supreme Court decisions.
Except, Your Honor, what the Florida Supreme Court did, I think, in its opinion, is to say that in terms of looking at how to remedy the situation, it needed to be cognizant of the fact that there was this federal deadline out there that was going to affect Florida's electors if that deadline was not met.
Well, of course, the deadline is meaningless if there's a new law involved. And that's part of the equation, too.
Yes, but what I would say is that whether or not there is a new law, that is, whether there's a change in the enactment, in the language of the statute or the Constitution, is something that has to be decided in the initial instance by the Florida Supreme Court interpreting Florida law.
There are really Mr. Boyes, there are really two parts to that sentence of Section 5 we're talking about. One is the law in effect at the time, and the other is finally determined 6 days before the date for choosing the electors. Do you think the Florida court meant to acknowledge, it seems to me since it's cited generally, it must have acknowledged both of those provisions?
I don't know exactly what was in the Florida Supreme Court's mind, but I think that in general, what the Florida Supreme Court made quite clear is that the thing that was constraining it was the desire to fit its remedy within the safe harbor provision.
So that's the finally determined portion of Section 5.
Yes, I think that's right. And I think it does not reflect a desire to change the law or in any way affect what the substantive law is.
Well,
what
let me ask, could the legislature of the state of Florida, after this election, have enacted a statute to change the contest period by truncating it by 19 days?
You mean by
without contravening the section which says that there should be no new law for the safe harbor? Could the Florida Supreme Court have done what could the Florida legislature have done what the Supreme Court did?
I think that it would be unusual. I haven't really thought about that question. I think they probably could not.
Consistently, because that would be a new law under Section 5, wouldn't it?
Yes, because it would be a legislative enactment as opposed to a judicial interpretation of an existing law. Remember...
And in fact, it would be a new law under our pre-clearance jurisprudence, wouldn't it?
I think not, Your Honor, because if you go back to the State against Chappelle in 1988, where the Florida Supreme Court faced the very question of whether or not that 7-day period was an iron curtain that came down, the Florida Supreme Court said it was not. The Florida Supreme Court said that you had to look as to whether there was substantial compliance. In that case, 3 days was found to be substantial compliance. That was a situation in which there was telephone notice, which was not adequate for certification, that was then followed up.
If we assume the legislature would run contrary to the new law prohibition in the statute, wouldn't the Supreme Court do it if it does exactly the same thing?
Except what I'm saying, Your Honor, is that it wasn't doing exactly the same thing because it wasn't passing a new law, it was interpreting the existing law. If the legislature had said, for example, the legislature has...
If the legislature does it, it's a new law, and when the Supreme Court does it, it isn't.
No.
But both would have to... You have to pre-clear judicial rulings to see whether they're new laws, don't you?
What I'm saying, Your Honor, is that if the Supreme Court had rewritten the law the way you hypothesized the legislature rewrote the law, it might very well be a difference. What I'm saying is that the Florida Supreme Court did not rewrite the law in the way that you hypothesized. What the Florida Supreme Court was confronted with was a statute. And that statute said that, and it was the later passed statute, we get back into the may and the shall, the May statute was the later passed statute, and so what the Florida Supreme Court said is we have to look at what is the criteria by which you decide whether you may ignore and will ignore these returns. And what the Florida Supreme Court said, we're going to interpret that exactly the way we've interpreted it for 25 years. And 12 years before the Florida Supreme Court made this decision, it had made the State against Chappelle decision in which it had approached it from exactly the same policy grounds.
Well, it was quite a different, there indeed telephone notification had been given within the deadline, and the actual written material was not submitted until a few days after. I think that's quite a bit different from extending the period generally and for all submissions for I'm not sure that you and Justice Kennedy are disagreeing on very much. It seems to me you acknowledge that if the Florida Supreme Court's interpretation of this law were not a reasonable interpretation, just not one that would pass normal judicial muster, then it would be just like the legislature writing a new law. But your contention here is that this is a reasonable interpretation of Florida law.
I think the way I would put it, Your Honor, is that if you conclude that the Florida Supreme Court's interpretation of Florida law is either a sham or it is so misguided that it is simply untenable in any sense,
right,
I think at that point, then you can conclude that what it has done has changed the law. But I think the standard is the standard this Court has generally applied in giving deference to state Supreme Court decisions.
But is it in light of Article 2? I'm not so sure. I mean, I would have thought that that bears on the standard, frankly, when it contemplates that it is plenary power in the legislature. Does that not mean that a court has to, in interpreting a legislative act, give special deference to the legislature's choices insofar as a presidential election is concerned? I would think that is a tenable view anyway, and especially in light also of the concerns about Section 5.
I think, Your Honor, that if the Florida Supreme Court, in interpreting the Florida law, I think the court needs to take into account the fact that the legislature does have this plenary power. I think when the Florida Supreme Court does that, if it does so within the normal ambit of judicial interpretation, that is a subject for Florida's Supreme Court to take.
Are responding as though there were no special burden to show some deference to legislative choices in this one context, not when courts review laws generally for general elections, but in the context of selection of presidential electors. Isn't there a big red flag up there? Watch out.
I think there is, in a sense, Your Honor, and I think the Florida Supreme Court was grappling with that.
And you think it did it properly?
I think it did do it properly.
That's, I think, a concern that we have. And I did not find really a response by the Florida Supreme Court to this court's remand in the case a week ago. It just seemed to kind of bypass it and assume that all those changes and deadlines were just fine and they'd go ahead and adhere to them. And I found that troublesome.
Your Honor, if I could, one of the things that was argued from the beginning by Governor Bush's counsel and accepted by the Florida Supreme Court was that the protest statute and the contest statute were very separate procedures. There was a time limit in the protest context prior to certification, but there is no time limit in the contest statute process, which is what we're in now. And I think that the Florida Supreme Court was focusing on this contest period, which is what is really was before them and is before you. And in the contest...
But I thought, and maybe I'm mistaken, but I thought it directed that certain votes that had been tabulated after the expiration of the original certification date were to be included now, without reference to the point at all that their opinion had been vacated. I just didn't know how that worked.
Well, there are three different groups of votes, okay? And with respect, Broward, Palm Beach, and Miami-Dade. With respect to Miami-Dade and Palm Beach, there was a trial. There was a contest trial. It is the appeal from that trial that is before this court. And the petitioners don't really refer to what's in the trial record. But in that trial record, there was undisputed evidence that the votes that were counted there were valid legal votes. Now, whether those votes were counted as part of the certification process or not,
this was
once you know they're valid votes.
This was a trial, Mr. Boyd, in the Circuit Court of Miami-Dade?
Yes. No, in the Circuit Court of Leon County. Because it's a statewide election, the contest procedure takes you to Leon County regardless of where the votes were cast. But what the court found there, and there was undisputed evidence, and Mr. Richard, who was Governor Bush's counsel here, conceded that the Palm Beach board had applied the appropriate standard in identifying votes, the so-called 215 additional net votes for Vice President Gore and Senator Lieberman. What you had there was undisputed evidence. It was found as a matter of fact, and the Supreme Court, reviewing that trial, said you've had these votes identified by Miami-Dade, 168 net votes, by Palm Beach, 215 net votes,
And those votes need to be included, not because they were part of the certification process.
Not only said that, it said that those votes have to be certified.
Yes, Your Honor.
It said that those votes had to be certified, which certainly contravenes our vacating of their prior order.
I think not, Your Honor, because when you look at the contest statute, it is a contest of the certification. That is, the process is the results are certified, and then what happens is you contest whether that certification is right.
I understand, but what the Florida Supreme Court said is that there shall be added to the certification these additional numbers.
But that's true in any contest. Every single contest.
It's not added to the certification.
Yes, of course it is, Your Honor.
You may do a review of the ballots and add more numbers, but as I read the Florida Supreme Court opinion, it said the Secretary of State will certify these additional.
Yes, because the contest procedure is a procedure to contest the certification. What you're doing is you're saying this certification is wrong, change it. That's what every contest proceeding is. And what the Florida Supreme Court was saying after this trial is, yes, you proved that this certification is missing
the certification as rendered by the Secretary of State did not include those additional ballots for your client. And the Supreme Court directed that the certification would be changed to include those.
But Your Honor, that is what happens every time there is a successful contest. The contest is a contest of the certification. You have the certification.
Make any sense to me? You have a certification which is made by the Secretary of State. That is what is contested.
Right.
And here, the certification was directed to be changed.
Does it matter, by the way, does it matter? Does it matter if they said in Palm Beach and Palm Beach and Miami-Dade, the ones that the court said you must certify, if they were thrown into the others, said recount them. If it's uncontested in the trial, I guess that you get to the same place.
I think you get to exactly the same place.
So it doesn't really matter.
I think it doesn't really matter what they say.
Broward might.
Broward
Would you object if they have a different standard to recounting those?
Broward is a different situation.
Yeah.
With respect to Broward, what you have is you have these votes that have been counted and were included in the certification. And if you were to assume that that certification that came in on November 26th is somehow void, then those ballots would have to be considered just like the Dade and Palm Beach ballots. So I think there is a distinction between Broward and...
Do you think that in the contest phase, there must be a uniform standard for counting the ballots?
I do, Your Honor. I think there must be a uniform standard. I think there is a uniform standard. The question is whether that standard is too general or not. The standard is whether or not the intent of the voter is reflected by the ballot. That is the uniform standard throughout the state of Florida.
That's very general. It runs throughout the law. Even the dog knows the difference in being stumbled over and being kicked. We know that. Now, in this case, what we're concerned with is an intent that focuses on this little piece of paper called a ballot. And you would say that from the standpoint of the Equal Protection Clause, could each county give their own interpretation to what intent means so long as they are in good faith and with some reasonable basis finding intent?
I think...
Could that vary from county to county?
I think it can vary from individual to individual. I think that just as these findings...
So that even in one county could vary from table to table? I'm counting these ballots, you're counting those?
I think on the margin, Your Honor, whenever you're interpreting intent, whether it is in the criminal law and administrative practice, whether it is in local government, whenever somebody is coming to government...
But here you have something objective. You're not just reading a person's mind. You're looking at a piece of paper, and the Supreme Courts in the state of South Dakota and in the other case have told us that you will count this if it's hanging by two corners or one corner. This is susceptible of a uniform standard, and yet you say it can vary from table to table within the same county.
With respect, it is susceptible of a more specific standard. And some states, like Texas, have given a statutory definition. Although even in Texas, there is a catch-all that says anything else that clearly specifies the intent of the voter. So even where states have approached this in an attempt to give specificity, they have ended up with a catch-all provision that says, look at the intent of the voter.
But they have ended up with the catch-all provision because, I assume, there may be cases in which the general rule would otherwise operate, in which there is an affirmative counter-indication to what the general rule would provide. But I think what's bothering Justice Kennedy, and it's bothering a lot of us here, is we seem to have a situation here in which there is a subcategory of ballots in which we're assuming, for the sake of argument, since we know no better, that there is no genuinely subjective indication beyond what can be viewed as either a dimple or a hanging chad, and there is a general rule being applied in a given county that an objective intent or an intent on an objective standard will be inferred. And that objective rule varies, we're told, from county to county. Why shouldn't there be one objective rule for all counties, and if there isn't, why isn't it an equal protection violation?
Let me answer both questions. First, I don't think there is a series of objective interpretations, objective criteria that vary county by county.
All right, but on the assumption that there may be, if we were fashioning a response to the equal protection claim, and we assume as a fact that there may be variations, wouldn't those variations on as from county to county on objective standards be an equal protection violation?
I don't think so, Your Honor, because I think there are a lot of times in the law in which there can be those variations from jury to jury, from public official to public official. Yes, but in jury-to-jury cases, we assume that there is not an overall objective standard that answers all questions definitively. We are assuming that there is detail that cannot be captured by an objective rule. The assumption of this question, and I think it's behind what's bothering Justice Kennedy, Justice Breyer, me, and others, is we're assuming there's a category in which there just is there is no subjective appeal. All we have are certain physical characteristics. Those physical characteristics, we are told, are being treated differently from county to county. In that case, where there is no subjective counter-indication, isn't it a denial of equal protection to allow that variation? I don't think so, Your Honor, because and maybe I am quarreling with the premise that says there are these objective criteria. Maybe if you had specific objective criteria in one county that says we're going to count indented ballots and another county that said we're only going to count the ballot if it's punched through, if you knew you had those two objective standards and they were different, then you might have an equal protection problem.
All right, we're going to assume that we do have that. We can't send this thing back for more fact-finding. If we respond to this issue and we believe that the issue is at least sufficiently raised to require a response, we've got to make the assumption, I think at this stage, that there may be such variation, and I think we would have a responsibility to tell the Florida courts what to do about it. On that assumption, what would you tell them to do about it?
Well, I think that's a very hard question.
You tell them to count every vote. You tell them to count every vote, Mr.
I would tell them to count every vote.
Let me ask you, before you answer that question, Mr. Boyd.
I think I would say that if you're looking for a standard, and I say that not because of the particular aspects of this election, the Texas standard, if you wanted to specify something that was specific, gives you a pretty good standard.
May I ask this question, Mr. Boyd? Does not the procedure that is in place there contemplates that the uniformity will be achieved by having the final results all reviewed by the same judge?
Yes, that's what I was going to say, Your Honor. That what you have here is you have a series of decisions that people get a right to object to. This is all going through a process. The people are there. They submit written objections. And then that's going to be reviewed by a court.
Well, that causes me some problems that pertain not just to the equal protection aspect of this, but to the rationality of the Supreme Court's opinion. Because the Supreme Court opinion, on the one hand, said, as you've just repeated, that there was to be de novo review. by the circuit judge in Leon County. But on the other hand, it said that he had to accept the counts that had come out of Palm Beach and Broward counties. It was clear that Broward and Palm Beach counties had applied different criteria to dimpled ballots. One of them was counting all dimpled ballots, the other one plainly was not. How can you at one and the same time say it's a de novo standard as to what is the intent of the voter, and on the other hand say you have to accept, give some deference to, quite differing standards by two different counties? That's just not rational.
Your Honor, I think what the court held was not include both Broward and Palm Beach. I think it was Palm Beach and Miami-Dade, because Broward was not part of the trial, because Broward had been certified. And with respect to Miami-Dade and Palm Beach, I do not believe that there is evidence in the record that that was a different standard. And there's no finding at the trial court that that was a different standard. Indeed, what the trial court found was that both Miami-Dade and Palm Beach properly exercised their counting responsibilities. So I don't think...
What do you mean properly exercised what? Their discretion, right? Is that what he meant by counting responsibilities?
I believe what he meant was discerning the clear intent of the voter, which is what they were both attempting to do.
Was this the trial before Judge Sauls?
Yes, Your Honor.
Well, I thought he ruled against the contestants, said they took nothing.
Yes, that is right, but he did so based on what the Florida Supreme Court held, and what 6 justices of the Florida Supreme Court held were 2 errors of law. First, that we had to prove before he looked at the ballots that there was a probability that the election result would be changed, and second, that we had to prove abuse of discretion.
But the fact-finding phase of that trial before him, you say these were found as a fact. Did he make findings of fact?
Yes, he did.
What did he say with respect to this?
With respect to this, he said it separately with respect to Miami-Dade and Palm Beach, as he found that they had properly exercised their discretion. The Palm Beach chairman of the canvassing board actually was a witness, Judge Burton. He came and testified. And he testified that they used a clear intent of the voter standard.
As opposed to just intent of the voter?
Yes, just intent. They used clear intent of the voter. And the statute, sometime in one section that says clear intent of the voter, that's the one that Petitioner's Counsel was referring to. In 166, it refers in subsection 7B to the intent of the voter. But Palm Beach used the clear intent of the voter and found hundreds of ballots that they could discern the clear intent of the voter from that were not machine read. Now, in doing so, they were applying Florida law. And like the law of many states, it has a general standard, not a specific standard.
Were those dimpled or hanging chads, so to speak?
Well, what he testified is that you looked at the entire ballot, that if you found something that was punched through all of the way in many races, but just indented in one race, you didn't count that indentation because you saw that the voter could punch it through when the voter wanted to. On the other hand, if you found a ballot that was indented all the way through, you counted that as the intent of the voter.
With no holes punched.
With no holes punched, but where it was indented in every race.
That was counted as proper in
Palm Beach.
Palm Beach.
Another thing that they counted was, he said they discerned that what voters sometimes did was, instead of properly putting the ballot in where it was supposed to be, they laid it on top. And then what you would do is you would find the punches went not through the so-called chad, but through the number.
Well, why isn't the standard the one that voters are instructed to follow, for goodness sakes? I mean, it couldn't be clearer. I mean, why don't we go to that standard?
Well, Your Honor, because in Florida law since 1917, Darby against State, the Florida Supreme Court has held that where a voter's intent can be discerned, even if they don't do what they're told, that's supposed to be counted. And the thing I wanted to say about the Beckstrom case is that was a case that used optical ballots. Voters were told, fill it in with a number 2 pencil. Several thousand didn't. They used everything else but not a number 2 pencil. And so the machine wouldn't read it. It was voter error. The Supreme Court in 1998, well before this election, said, you've got to count those votes. And in fact, they counted those votes even though the way the canvassing board dealt with them was to go back and mark them over with a big black marker, which made it impossible to check whether the canvassing board had really just marked over the ballot or had put a new mark on the ballot.
Mr. Boyce, can I come back to this discrepancy between Palm Beach and Broward County? I'm reading from footnote 16 of the Florida Supreme Court's opinion. On November 9, 2000, a manual recount was requested on behalf of Vice President Gore in 4 counties, Miami-Dade, Broward, Palm Beach, and Volusia. Broward County and Volusia County timely completed a manual recount. It is undisputed that the results of the manual recounts in Volusia County and Broward County were included in the statewide certifications.
Yes, Your Honor.
And those statewide certifications the Supreme Court ordered to be accepted. So it is the Supreme Court, while applying a standard of supposedly de novo review of the certifications, is requiring the circuit court to accept both Broward County, which does one thing with dimpled ballots, and Palm Beach County, which does something clearly different.
Your Honor, the de novo review is in the contest phase, and neither Volusia County nor Broward County was a contest file. What the Supreme Court holds is that you've got de novo review in a contest. A contest relates to specific ballots that are contested. The ballots in Broward and Volusia were not contested by any party.
But the determination that the circuit court has to make about whether it's necessary to have a recount is based upon the certifications.
No, it's only based on
which he then accepts.
No, it's only based on the certifications that are contested. In other words, if you're going to order the manual review of the ballots, the issue is what ballots are contested, and second, is there judicial review of those ballots?
You have to know how close the state election was, don't you?
Yes, but
for which purpose you accept the certifications.
Yes, that's true.
And here you're telling him to accept it, not de novo, but deferring to Broward County.
I think what the Supreme Court is saying is you've got a certification. That certification shows a certain vote total. Now you take that certification until it is contested, and it can be contested by either or both parties. You do not have, until it is contested, you do not have contested ballots. Once you have contested ballots, then going back to State against Williams, Nuccio against Williams in 1929, cited in our papers, then it becomes a judicial question. And what the court holds is you then look at that as a judicial matter, and that is why you have going on in Leon County the review of the Miami-Dade ballots under the court's supervision. Now, I would point out that we asked to have the Miami-Dade ballots reviewed. We also asked to have the 3,300 Palm Beach ballots reviewed, but the Supreme Court said no to us on that. They said, yes, you can have the 9,000 Miami-Dade ballots reviewed. They also said, which we didn't ask for, they said as a matter of remedy, we want to review the undervotes all around the state.
Mr. Boyce, one of the dissenting justices in the Supreme Court of Florida said that meant 177,000 ballots. Was he correct in your view?
No, that is a result of adding the so-called undervotes that were mentioned and the so-called overvotes that were mentioned. Either an undervote where no vote registers for president or an overvote where 2 or more registers for president are discarded because you can't vote twice, and if you vote not at all, under either circumstance, your vote doesn't get counted.
If you disagree that 177,000 ballots will be involved in this recount, how many do you think?
It's approximately 60,000, I think, Your Honor. It turns out to be less than that because of the recounts have already been completed. But I think the total sort of blank ballots for the presidency
but Mr.
were about
Boyce, can I ask you this? Does that mean there are 110,000 overvotes?
That's right.
And if that's the case, what is your response to the Chief Justice of Florida's concern that the recount relates only to undervotes and not overvotes?
Well, first, nobody asked for a contest of the overvotes. And the contest statute begins with a party saying that there is either a rejection of legal votes or an acceptance of illegal votes.
But as a matter of remedy, it's ordered a statewide recount in counties where the ballots were not contested. And that's where I'm having some difficulty. And it goes back to, in part, to your answer that you gave to Justice Justice Scalia about Broward County, and in part to the answer you're giving to Justice Stevens now. Why is it that you say on the one hand to Justice Scalia, oh, well, these weren't part of the contest, but now all of a sudden we're talking about statewide that are not, well, all of which are contested, but we're not talking about the overvotes?
Two parts to the answer. The reason that I said what I did to Justice Scalia was that I think that if this court were to rule that there was something wrong with the statewide recounts, that they were being done by canvassing boards as opposed to directly by the court, or because the court was not supervising the particular expression of voter intent, what the court would have done is simply cut back on a remedy that we didn't ask for. The second part is that when you're dealing with overvotes, and remember this is a machine issue, when you're dealing with overvotes, the machine has already registered 2 votes. Now there may be another vote there, a dimpled vote or an indented vote, that the machine did not register. But once you get 2 votes, that ballot doesn't get counted for the presidency.
They gave an example. The example they gave in their brief was there's a punch for Governor Bush, and then there's a punch for write-in. And the write-in says, I want Governor Bush. And so I think their implication is that that would have been rejected by the machine, but if you looked at it by hand, the intent of the voter would be clear. Now, I don't know if there are such votes, but they say there might be.
There's nothing in the record that suggests there are such votes. If anybody had contested the overvotes, it would have been a relatively simple process to test that, because you could have simply tested as to whether the double vote was a write-in vote or was another candidate.
I gathered from the opinion of the Supreme Court of Florida that the Vice President did not ask for as broad a recount as the Supreme Court granted, but that it thought that to do just what he wanted would be unfair, and therefore, out of fairness, they granted the wider recount. Am I correct in that?
I think that's right. I think that's where I would interpret it, Mr. Chief Justice.
Mr. Boyce, I have one other perplexity about the scheme that's been set up here. There's a very, as you point out, there's scant statutory provision concerning the contest. There's quite detailed statutory provision concerning the protest period. And it tells everybody how to act and time limits and all of that. Why would anyone bother to go through the protest period, have these ballots counted by the canvassing boards, have them certify the results? Why go through all that when the whole thing begins again with a contest? There's no once a contest filed, the certification is meaningless. What advantage is there to win the protest?
It's not meaningless. It becomes the baseline. And in every contest that has ever taken place, including this one, that has been the baseline that has determined 99+% of the votes. And what is contested are simply those ballots that during the protest phase have been identified as disputed ballots. So that the protest phase solves 99% of the election or more. What is left over are those ballots that one side or the other has contested. And that's what the contest deals with.
My concern is that the contest period, as we've been talking about, requires the setting of standards, judicial review, and by reason of what I take it to be your earlier position in the litigation, this period has been truncated by 19 days, causing the time frame of which we're also conscious, making it difficult for appellate review. And it seems to me, and we're getting back to the beginning of this, that the legislature could not have done that by a statute without it being a new law. And that neither can the Supreme Court without it being a new law, a new scheme, a new system for recounting at this late date. I'm very troubled by that.
But, Your Honor, leaving aside the prior case about the extension of the time for certification, which I think at this stage you have to leave aside, because at the contest stage, what you're doing is you're contesting specific ballots, whether or not they were included in the certification. It's absolutely clear under Florida law that that's what the contest is about. So at the contest stage, the only question is, can you complete the contest of the contested ballots in the time available? Everything that's in the record is that we could have, and indeed we still may be able to, if that count can go
including
forward.
Appeals to the Supreme Court of Florida and another petition to this court?
Excuse me, Your Honor?
I said, after the circuit judge says the contest comes out this way, surely there's going to be an appeal to the Supreme Court of Florida and likely another petition to this court. Surely that couldn't have been done by December 12th.
Your Honor,
could it?
I think the appeal to the Florida Supreme Court could have, and indeed the schedule that was set up would have made that quite possible. There is about another day or so, except for 4 or 5 counties. All of the counties would be completed in about another day. And maybe even those counties could be now, because as I understand it, some of them have taken advantage of the time to get the procedures ready to count.
Just a minute, Mr. Boyce. Wouldn't the Supreme Court of Florida wanted briefs, and wouldn't the parties have needed time to prepare briefs?
Yes, Your Honor, but as we did in this court, we have done in the Florida Supreme Court a number of times, and that is to do the briefs and have the argument the next day and a decision within 24 hours.
After the counts are conducted in the individual counties, wouldn't the Leon County Circuit Judge have to review those counts? After all, the purpose of the scheme is to have a uniform determination.
To the extent that there are contested or disputed ballots, right. I think that may be so, Your Honor.
Well, wouldn't that take a fair amount of time? And is that delegable? I assume he'd have to do that personally.
We believe that it could be done in the time available. We also believe that we have available to us the argument that says, you finished what we contested. Although the Supreme Court has said as a matter of remedy, it would be a good idea to do these other things that nobody asked for. That if it gets down to the point where you have done the contest and you simply have not completed all of this other remedy under 168 subsection 8, that we are still entitled under settled Florida law to have our votes counted.
The Supreme Court said you had to do it all in the interest of fairness.
No, I think that
I thought you agreed with me on that a moment ago.
I did, Your Honor. I think that what they were saying is that as a matter of remedy, this is the fairest way to do it. I don't think they were saying that it would violate fundamental fairness to only take into account what you could get done in the time available. There's nothing in the Supreme Court opinion that would suggest this.
Mr. Boyce, would you explain to me again how the protest and the contest fits in? You said let's assume that my complaint that I want to protest is the failure to do undercounts to those ballots that were undercounted, okay?
Right.
That's my protest.
Right.
Why would I ever bring that in a protest proceeding? Why wouldn't I just go right to the contest? Because it doesn't matter whether I win or lose the protest proceeding. It's de novo at the contest stage. What possible advantage is there to go through the protest proceeding?
If you've identified the ballots, you could presumably wait and do it at the contest phase. There's no particular advantage to doing that. The fact
I thought the advantage might be, as described in the Florida case Boardman versus Esteva, saying that the certified election returns, which occur after the protest period, are presumptively correct. And they must be upheld unless clearly outside legal requirements. I thought that was Florida law.
Your Honor.
Which would make it important to have a protest.
I think that's right. I think that is right. I would point out that
I think the Florida court has sort of ignored that old Boardman case.
Your Honor, I think the Boardman case relates not to the counting of votes. It has nothing to do with the standard in terms of the intent of the voter. The Boardman case, the language that you're referring to, is at page 268 of the Southern Reporter report of that case. And what is clear from that page and that discussion is it's dealing with the issue of whether or not, because the canvassing board threw away the envelopes from the absentee ballot so they could not be checked, whether that invalidated the absentee ballots. And the court says, no, it doesn't, because it's important to count all these votes, and because we assume that what they were doing was proper. That does not, I respectfully suggest, at all deal with the question of deference to the voter intent determination, which the court has repeatedly said is a matter for judicial determination. And the other thing that I would say with respect to intent is I know the court is concerned about whether the standard is too general or not. Some states have made specific criteria their law. Other states, not just Florida, 10 or 11 of them, including Massachusetts and the Delahunt case that we cited, have stuck with this very general standard.
All right,
There's a sense in which that may be an Article II issue.
Mr. Boies, let's assume that at the end of the day, the Leon County, Florida judge gets a series of counts from different counties, and those counties have used different standards in making their counts. At that point, in your judgment, is it a violation of the Constitution for the Leon County judge to say, I don't care that there are different standards, as long as they purported to follow intent of the voter, that's good enough?
I'll extend your time by 2 minutes, Mr. Boies.
Yes, I do not believe that that would violate the Equal Protection and Due Process Clause. That distinction between how they interpret the intent of the voter standard is going to have a lot less effect on how votes are treated than the mere difference in the types of machines that are used.
Then the fact that there is a single judge at the end of the process, on your judgment, really is not an answer to the concern that we have raised.
No, I think it is an answer. I think there are two answers to it. First, I think that the answer that they did it differently, different people interpreting the general standard differently, would not raise a problem, even in the absence of judicial review of that. Second, even if that would have raised a constitutional problem, I think the judicial review that provides the standardization would solve that problem. The third thing that I was saying is that any differences as to how this standard is interpreted have a lot less significance in terms of what votes are counted or not counted than simply the differences in machines that exist throughout the counties of Florida. There are 5 times as many undervotes in punch card ballot counties than in optical ballot counties. Now, for whatever that reason is, whether it's voter error or machine problems, that statistic, makes clear that there's some difference in how votes are being treated county by county. That difference is much greater than the difference in how many votes are recovered in Palm Beach or Broward or Volusia or Miami-Dade. So that the differences of interpretation of the standard, the general standard, are resulting in far fewer differences among counties than simply the differences in the machines that they have.
Thank you.
Thank you very much.
Mr. Olson, you have 5 minutes remaining.
Thank you, Mr. Chief Justice. I would like to start with a point or two with respect to the equal protection due process component of this case. The Florida Democratic Party on November 20th was asking November 20th of this year was asking the Florida Supreme Court to establish uniform standards with respect to the looking at and evaluating these ballots, a recognition that there were no uniform standards and that there ought to be. Last Tuesday in the 11th Circuit, unless I misheard him, the attorney for the Attorney General of Florida said that the standards for evaluating these ballots are evolving. There is no question, based upon this record, that there are different standards from county to county.
When there are different ballots from county to county, too, Mr. Olson, and that's part of the argument that I don't understand. There are machines, there's the optical scanning, and then there are a whole variety of ballots. There's the butterfly ballot that we've heard about and other kinds of postcard ballots. How can you have one standard when there are so many varieties of ballots?
Certainly the standard should be that similarly situated voters and similarly situated ballots ought to be evaluated by comparable standards.
And you'd have to have several standards. Well, county by county.
You're certainly going to have to look at a ballot that you mark in one way different than these punch card ballots. Our point is, with respect to the punch card ballots, is that there are different standards for evaluating those ballots from county to county, and it is a documented history in this case that there have been different standards between November 7th and the present with respect to how those punch card ballots are evaluated. Palm Springs is the best example. They started with a clear rule which had been articulated and explained to the voters, by the way, as of 1990. Then they got into the process of evaluating these ballots and changed the standard from moment to moment during the first day, and again they evolved from the standard that the Chad had to be punched through to the so-called dimpled ballot standard, indentations on the ballot. There was a reason why that was done. Because they weren't producing enough additional votes, so that there's pressure on to change the standards. And that will happen in a situation where the process is ultimately subjective, completely up to the discretion of the official, and there's no requirement of any uniformity. We now have something that's worse than that. We have standards that are different throughout 64 different counties. We've got only undercounts being considered, where an indentation on a ballot will now be counted as a vote, but other ballots that may have indentations aren't going to be counted at all. The overvotes are in a different category, and in this very remedy, the ballots in Miami-Dade are being treated differently. Some of them have been all examined, and the balance of the process, the remaining 80%, will be looked at only in connection with the undercounts.
Mr. Olson, do I understand that your argument on the equal protection branch would render academic what was your main argument that's troublesome, that is, that we must say the Florida Supreme Court was so misguided in its application of its own law that we reject that and we, the Supreme Court of the United States, decide what the Florida law is?
I'm not sure I know the answer to that question, and whether that would render academic the challenge. There is a clear constitutional violation in our opinion with respect to Article 2, because virtually every aspect of Florida's election code has been changed as a result of these two decisions.
But the Florida Supreme Court told us that it hasn't been changed, and just looking at one of the cases that you cite frequently, the O'Brien against Skinner case, this court said, well, maybe we would have decided the New York law differently, but the highest court of the state has concluded otherwise. It is not our function to construe a state statute contrary to the construction given it by the highest court of a state.
The only thing that I can say in response to that is that what this court said 1 week ago today, that as a general rule, the court defers to a state court's interpretation of a state statute, but not where the legislature is acting under authority granted to it by the Constitution of the United States. The final point I would like to make is with respect to Section 5. It is quite clear that the court in both the earlier decision and in the decision last Friday was aware and concerned about compliance with Section 5. It construed Section 5 in a way that allowed it, by labeling what it was doing as interpretation, to change in dramatic respects the Florida election law, and we submit, because it did so, misconstrued the applicability not only with respect to finality, but the other part of Section 5 requires a determination of controversies pursuant to a set of laws that are in place at the time of the election.
If you start with the premise, a clear intent of a vote should count, where there's a clear intent on the ballot, it should count as a vote, can't you reasonably get to the majority's conclusion?
I don't believe so, because we know different standards were being applied to get to that point, and they were having different results.
Thank you, Mr. Olson. The case is submitted.
The case is submitted, and the arguments are heard at the United States Supreme Court in Bush v. Gore. in a case which may well determine the 43rd President of the United States. Now, in these arguments, we heard a number of questions visited and revisited. Principal among them, why should the United States Supreme Court be involved in this? What is the federal question? They spin from two basic premises here, surrounding issues of due process and equal protection under the law. Fundamentally, we heard questions asked and asked again about whether the Supreme Court of Florida wrote new law or merely interpreted law. Did it pay the special deference that it must to the legislative branch, that is the Florida legislature, with respect to selecting the electors who fundamentally and officially picked the President of the United States in this country, as you well know by now. Now, our senior Washington correspondent, Charles Bierbauer, was in the court throughout this hour and a half of arguments. Charles, an extraordinary hour, and some skepticism we heard, tough questioning from all the justices, but especially of a special interest, really, Justices O'Connor and Kennedy.
Well, yes, Justices O'Connor and Kennedy, Frank, are always considered the flexible middle, and where they go, there goes the majority of this court. Right off the bat, with both attorneys, Mr. Boies and Mr. Olson, Justice Kennedy said, where is the federal issue here? And he seemed to find one. He seemed to be very much of the view that there was an equal protection matter here arising out of the Constitution. That is to say that if all votes are not treated equally, there is a concern there that the equal protection standard would not be met. At one point, Justice Kennedy was saying there are not only different standards from county to county in counting ballots, but from table to table as those ballots are being counted. We heard the same federal question arise from several justices, including, I might point out, Justice Souter, who's generally considered one of the liberals on the court and one of the justices who at least did not want to stay the counting. Justice Souter, too, voiced concerns about the equal protection matters here as to whether one judge, in this case the Leon County judge, after all the ballots and the returns were brought back to him, whether he could make that kind of a judgment. So the federal issue very much there, and this is something that the Bush attorneys wanted before this court. This would give them that kind of authority. The other thing I would point out, Frank, is the question of judicial review, raised most notably by Justice Ginsburg, but also by others, to say what role should the Florida Supreme Court play? How can there be no judicial review? How can it simply fall all upon the legislature? So therein lies probably the second balance point, and that would be one that would fall much more into what the Gore attorneys would want to hear, that there would be some sense on this court that the Florida Supreme Court did have a role to play. Frank?
Charles, looking here at my notes and some of what I heard from Justices Kennedy and O'Connor in particular, Justice O'Connor referred to as troublesome that the Florida Supreme Court did not respond to their remand of those vacated votes. In other words, they added those votes on. We heard that a fair bit in the discussion with Mr. Boies.
We heard that a fair bit. Justice Scalia also raised the point about bringing votes back in that had been excluded by virtue of this court vacating the Florida court's order, and yet they seem to gauge that the Florida Supreme Court said, oh, bring those votes back into the tally. This court did not like that. These justices do not like that the lower court has not responded to them on their motion, on their order vacating the earlier ruling. Now, how much of that is court-to-court peak, I'm not quite sure, but they expected more from the Florida Supreme Court than they got. Frank?
All right, over to Roger Cossack now. Roger Cossack, Greta Van Susteren, and Charles, all three of you in the court. Roger, you were in the entire time as well. Look, here's what we heard. We heard them asking about the intent of the voter, about the jurisdiction of the Florida Supreme Court, about the standards by which you were going to determine what is a legal vote, and the intent of the voter. We heard them talking about the time that was left. Your impressions as to where this court may be headed?
Well, those are exactly what the issues are, and we know that there is at least five members of the United States Supreme Court that are concerned enough and feel that the standard that they're probably going to reverse the lower court, that they took this case. It was sharp questioning for David Boies. The notion that there are no standards raises, as several of the justices pointed out, an equal protection argument. There came that moment when both Justice Souter as well as Justice Breyer kept pointing out that there's 67 counties. Could there be 67 different standards or different ways to count? and could it even be tabled to table? And David Boyce kept saying, Your Honor, well, it's the intent of the voter, and it's up to these people to find what the intent of the voter is. And remember, under a contest statute, a judge in Leon County would then have a chance to review what these standards are, and if they were reasonable, then that's what the intent of the voter is. But it is clear from the questioning that I heard, the entire questioning, that they are very, very concerned with those issues. Is there a federal question? And there was a little bit of pique, I felt, from Justice O'Connor in particular, who several times said, you know, we didn't get much from the Florida Supreme Court. We asked them, and we just didn't seem to get much. So it was a tough argument. You wonder, and you look at those swing voters, and you wonder if they've changed their mind. And I'll be honest with you, Frank, I have no way of knowing.
Greta Van Susteren, to you, you were in for that very interesting exchange when several of the justices engaged Ted Olson on the subject, the possibility of sending this thing back to Florida, to Leon County Circuit Court, having the judge turn to the Secretary of State of Florida and coming up with some standards.
You know, Frank, this whole business about the standards a little bit perplexing. The fact that the court, and I heard the court in the audio, I was there for the first half, but I heard the audio on the second half, was very hard on David Boyce about whether or not there should be a standard or not, is not something that I think necessarily tells us much, other than that they were questioning David Boyce. I mean, if you take a look at it, if you broaden out across the country, there's a different standard in probably every state in the union. I mean, this is just the first time the court has had to grapple with that issue, whether we, in essence, need a national standard. But remember that the Florida legislature, under the Constitution, has the obligation to set the manner by which electors are chosen. And the Florida legislature has created a contest proceeding which says that the judicial officer is to determine the voter's intent. And so it may just very well be, even though they grilled David Boyce on this issue and they asked a lot of questions of Ted Olson on behalf of the governor, it may just very well be that they say, look, there is a standard. The standard is that the person who has the job to look at the ballot must determine the voter's intent. You may not like that standard. It may not be a scientific approach, but that's what the standard is under the law. So while the questions are tough and aggressive, it may just very well be that the court takes another whole approach to it than what we sort of discern or distill from the questions. One other thing that I might add is this remand issue is that Justice Breyer asked whether or not, or Justice Souter rather, asked whether or not the case should be remanded so that it could be considered for the Secretary of State issue this letter or state of the law on intent. That's an intriguing concept, and maybe they'll do that. They sent the last case back to the Florida Supreme Court, so maybe they'll send this one back to the county court.
Greta, having been there for that first portion, having heard the tapes, and we'll bring Roger and Charles in on this a little bit later, but for now, just with you, do you have different impressions? Do you hear something conveyed through the court? Granted, they can do anything they want here. Not anything, but obviously we don't know what they're going to do. But do you walk away with some overarching impression here?
Yes, that we need cameras in the courtrooms so that the American people get more than a late audio tape, so that the Americans aren't looking through my eyes to try to determine whether a justice who makes a face or asks a question might be giving out some idea. Rather, the American people can see for themselves. Putting that aside, the one thing I'm confident is that these justices were ready for this, and I can't pick apart their questions to give any deliberate message, because justices always play devil's advocate. They test out their own theories on the lawyers, even some with whom they might not agree. So I can't determine anything other than I wish the American people could have seen it for themselves so they don't have to look through my eyes.
Okay, Greta, we're going to be touching back with you and with Roger Cossack. A burden of proof will be coming up shortly. We're going to take a quick break, though. We want to hear from both the camps, Gore and Bush, because ultimately this case involves them and all the rest of this country as we await the 43rd President of the United States.
Hot tippers, midnight surfers.
Confusion among senior Democrats at this hour. Ed Rendell, who is the general chairman of the Democratic National Committee, already being quoted on another network as saying it's time for the vice president to concede. In reaction to that, Joe Andrew, who is the chairman of the party, the day-to-day chairman of the party, sending word to our Jonathan Karl through his spokeswoman saying that Mr. Rendell does not speak for the Democratic National Committee, and that if he is calling on the vice president to concede, he is speaking in a personal capacity, not on behalf of the party. Now, Now, again, the Gore campaign team and Democratic strategists huddling to decide what to do next. Their reaction quite pessimistic, but already some consternation from the Democratic Party chairman that Ed Rendell is already out there and speaking in his role as the general chairman of the party quickly saying, though, he is speaking for himself. So a disagreement among the Democrats as all this plays out in a very confusing, a very tense, and obviously very high-stakes political environment for the vice president.
It's classic a case of the right arm not knowing what the left arm is up to, as we've seen. Now, Charles Bierbauer, you were at the Supreme Court. You've had, in the fullness of time, an opportunity to digest what the court is saying. What can you tell us now?
Well, what we seem to be coming to is a concurrence of our own here, Judy, and that is that the majority of this court, as you put the numbers together, certainly 7 of the justices found considerable problems, and 5 of them discerned that there was not a good remedy at this point, and that in fact what they are saying to the Florida Supreme Court in vacating and remanding is that there is a safe harbor provision which the Florida legislature has sought to maintain. That safe harbor meaning the terminology under which the choice of the electors is unassailable, and that they should stay in that safe harbor. Don't venture forth onto the rough seas of trying to construct something in these waning days. Here it is now, December 12th, and December 18th is the date for counting. I sense that there is that slimmest of margins there where they say you would have to have a counting procedure that would be uniform across the state, and then they lay out some of these concerns about voting machines and tabulating and bringing it back before the court itself, so that they have said that the window out of the harbor is so narrow that you probably shouldn't try it. And that seems to be the strongest message that they convey. Of course, the message that, yes.
I was just going to ask, going back to the 5-4 split that provided us with the stay that called a halt to that manual recount on Friday, these are the same 5 who have decided against the feasibility of a recount today, right? I mean, we're really looking at the same outlines from the court.
These are the same 5. Chief Justice Rehnquist, Justices O'Connor, Kennedy, Scalia, and Thomas, with the partial addition of Breyer and Souter saying, yes, there are problems, but Breyer and Souter think that they can be fixed, and Ginsburg and Stevens don't think they should have gotten into this at all.
All right, Charles Bierbauer.
Roger Cossack, what's the latest with you?
Well, I think that I agree, of course, with Charles Bierbauer and with what Jeff said earlier after my review of now reading it and looking at it. That's clearly what happened. The same 5 ended up with the same 5. That is, they have decided that it was constitutional. Once they made that finding of the safe harbor, it pretty much was all over because there is really no way around it. Now, there's going to be great cries of hypocrisy which said, look, there's no way around this because you stopped us from doing this count a couple of days ago. If you'd have let us finish, everything would have been all right. But then there's that equal protection argument and the standard argument. It's almost, when you read this, you see, you almost feel the frustration of the 4 dissenters in their inability to really crack that center that we've talked about, to get either Justice Kennedy or Justice O'Connor to come over to their side. But nevertheless, once they find there's a safe harbor and the date is December 12th, well, you know, what room is there? You know, we talk about wiggle room for the Florida legislature or Florida Supreme Court, but I don't think there is any, because there's been a finding by the Supreme Court that it's been the intent of the Florida legislature to get within that safe harbor. Therefore, you end up with that December 12th date, and I'm afraid it just doesn't look very good for Vice President Gore.
Roger, what gives you the sense that there's a strong frustration on the part of the 4 who couldn't sway their colleagues?
Well, first of all, from the stay that we saw the other day, very rarely do you see a stay in which there's 2 opinions that were written so diametrically to each other that was need to be published, with a need that each side come out and say what was on their mind. So right from the beginning, you had this sense of strong divisiveness. And here you have an opinion which is a per curiam opinion, where you have 3 of the most conservative members of the court writing a dissent and saying there's just no way around it. The per curiam, therefore, because we don't hear from the other 2, has to include, as I said, O'Connor and Kennedy. There's the 5. And then you see these 4 other in each way fighting, Ginsburg saying, we shouldn't be involved in this in the first place. Breyer and Souter saying, there could be a recount. We could do the Florida court could do this, and this Stevens with this absolute frustration of our votes. There are people who have voted who will never have their votes counted. Well, and you just sense that frustration.
And Roger, I'm looking at one note. Justice John Paul Stevens was very blistering in his attack.
Right.
He called the Bush legal appeal a, quote, federal assault on the laws of the state of Florida.
That's right. And that whole notion that you saw, and you can see, Bernie, that notion of votes not being able to be counted really offended Justice Stevens. And you see that he feels, I think, then at least my sense is that the four who were in the dissent in this just have a real sense that the five who took over just clearly stopped, just swung the election in some ways and just stopped something from going forward, which is sacred, which is vote counting.
I was just going to say, Bernie and Roger, if you don't think there's some strong opinions here, let me just read you the first two sentences of Justice Breyer's dissent. He said flatly, the court was wrong to take this case. It was wrong to grant a stay. It should now vacate that stay and permit the Florida Supreme Court to decide whether the recount should resume.
We're standing by very shortly, we're told, in Tallahassee, Florida. James Baker, representing Governor Bush's team there in Tallahassee, will be making a statement. When he does, we'll take it live. Jeff Greenfield in New York.
One of the things we're learning is that doing legal analysis on the fly ought to be an Olympic sport with a degree of difficulty of 10. But one of the keys you can always tell about what a majority is saying when it's confusing is look at what the dissenters are objecting to, as Judy just did and as you just did, Bernie. It turns out that all of the things we were looking at the very top, what would be required to have a fair and constitutional recount, is what the majority of the court was saying couldn't be done in time. And that's why Justice Ginsburg says the court assumes that time will not permit orderly judicial review of any disputed matters that might arise. And then she says, and I think we quoted this earlier, the court's conclusion that a constitutionally adequate recount is impractical is a prophecy the court's own judgment will not allow to be tested. Such an untested prophecy should not decide the presidency of the United States. So that's the frustration, I think, that Roger was talking about. The dissenters are saying you guys aren't letting the Florida Supreme Court come up with any solution, even though in past years we've had certifications of electors, as in Hawaii, that went on way past December 18th, but you will not allow it to happen. And the more I look at this, the more it seems to me that what we said a few moments ago is it. There is no way out for Al Gore, according to 5 of the 9 justices of the Supreme Court.
And just to buttress what you just reported, Jeff, listen to Justice Souter now, dissenting. Unlike the majority, I see no warrant for this court to assume that Florida could not possibly comply with this requirement before the date set for the meeting of electors December 18th. To recount these manually would be a tall order. But before this court stayed the effort to do that, the courts of Florida were ready to do their best to get that job done. There is no justification for denying the state the opportunity to try to count all disputed ballots now. I respectfully dissent.
Right, and that's my point, is that all these dissenters are objecting very strenuously, some of them, to the clear majority of the court, this 5-person majority that is saying not only was the Florida Supreme Court wrong to order those manual recounts, but it must stop now. And this is, it seems to me, at least for 5 of the 9 of them, a final decision. There's nothing you can do about this. Forget the idea of trying to do a recount. December 12th is the date. That's it. And I think that's why John King's report of all that pessimism in the Gore campaign is only going to get stronger.
Mm-hmm. Okay, Jonathan Carl.
Yeah, as a matter of fact, there's a little bit of a stampede effect going on along within in the Gore campaign and among Democrats friendly to the vice president, saying this is a conclusive defeat. Perhaps it's time for the vice president to concede. You had Ed Rendell, the general chairman of the Democratic National Committee, out there saying on MSNBC that he thinks that it's time for Gore to concede. You also had Larry Tribe suggest the same thing. Larry Tribe, of course, the attorney who argued the first case for Gore before the Supreme Court. But within the legal team, they are poring over for this this decision. Some are saying it looks pretty bleak, but one member of the legal team told me, look, it's a long, complicated opinion. It's a very fractious opinion. We are going to take our time with this. We're not sure exactly what this means. It's being remanded. Is there some wiggle room? Is there an open door to go to the Florida Supreme Court and say, yes, a recount under these terms can be done? So the Gore legal team not ready to wave the white flag yet, even if some very prominent Democrats are. As a matter of fact, another member of the legal team saying, look, it is simply too important to rush. We are going to take our time.
Do it. Okay, thank you, Jonathan Carl. Judy.
All right, and we want to go back now to Austin. CNN Candy Crowley in touch with the Bush camp. Candy.
Judy, what we know is that the legal team gathered in Tallahassee, along with some of the political members of the Bush camp, have gone over this, as the Gore camp has, page by page. And their preliminary reading, and I'm sure we will hear the final reading from James Baker soon, is that this is a victory for the Bush team. They think further that the vice president has exhausted his legal avenues. So there is a very preliminary reading, but one that has a sense of confidence that this is indeed a victory for George W. Bush in Florida. And as we all know, that would mean, of course, assuming that the Gore camp also reads it that way, and we go through the various steps, that Florida, of course, would give George Bush the presidency. The governor himself is in his mansion. He's been there all day. We know that his campaign headquarters is up and working. They also talking to their team in Tallahassee. We will get the first definitive word from James Baker. Judy?
It was 5 weeks ago tonight that CNN and other networks took the state of Florida out of the Al Gore column, put it into the too close to call column. It appears that exactly 5 weeks later, at about 11 o'clock Eastern time, we are saying that Florida we're taking it out of the grasp of Al Gore, at least by all appearances, and not into the too close to call, but pretty firmly into the grasp of Texas Governor George W. Bush.
And Martin Savage is in Tallahassee. Marty?
Well, Bernie, we've been waiting to see if there was going to be any reaction to this from the Florida Supreme Court, whether the podium, which is usually an indication, might come out of the building. No indication of that. However, we were told that when Craig Waters left the court, he's the spokesperson for the court earlier this evening, he was told to keep his cell phone on. Now it's clear exactly why. I want to bring in David Cardwell. We want to talk about, in the hour that is left, if they say they must is 45 minutes, is there anything the Florida Supreme Court could possibly do?
They could issue an order if they could get them all together, but if they issue an order, there's no way that it can get out to all of the counties and all of the supervisors of election and all of the canvassing boards and say recount by midnight tonight. If what the Supreme Court said was it's got to be within the safe harbor provision, they can't do it tonight.
Well, and here's the issue of the safe harbor is that obviously the Supreme Court can't meet it tonight. The Florida legislature is not going to meet it. The Senate is going to be debating it tomorrow. They may vote on it tomorrow. They may be voting on it on Thursday. They are beyond the realms of the safe harbor.
That's right. A good point. The safe harbor seems to be merely something that's in federal law that says if you have your electors chosen by December 12th, 6 days before when they vote, then they're conclusive. Nothing. It does not say that that's a hard and fast deadline. In fact, as you point out, the Florida legislature is saying we're moving right past the safe harbor. We're not going to act to the 13th or 14th. And so they already are anticipating that they're going to be past the safe harbor. So the Supreme Court putting all the reliance on the safe harbor provision tonight, in their opinion, seems to be something that's not being followed by the Florida legislature and something that is really beyond what the statute seems to say. Because the statute, as I read it, says if you're in by the 12th, you're conclusive, you can't be challenged. But you got to the 18th, and at the time that you vote, to actually have your slate of electors picked.
Now, is the Supreme Court essentially saying that the electors that were in place, that were certified back on the 14th, are they the ones that now are going to be the official electors?
Good question, because the ones that were selected under the current certificate were signed by Jeb Bush, the governor, were done based on the now vacated ruling of the Supreme Court, which went back up to the U.S. Supreme Court, and they haven't ruled on that yet. So there wasn't sort of an asterisk to that said if there was still a challenge, we could go back to the original certification that was right after the election of November 7th. Right now, and that's why the legislature is saying they've got to now pick a slate of electors, there's a question as to whether or not the slate that's already been sent up there is valid or not. So once again, we're in uncharted waters.
So the legislature moves forward. They come up with their own slate or affirm the slate that exists now. Essentially, 2 lists go up to Washington, D.C., and probably, maybe, a challenge coming out of Congress over the vote.
Well, there's going to be a challenge, we know, from the Democrats to the special session that's going on now. So I don't think the legal maneuvering is over yet. There's going to be a challenge to the slate that comes out of the special session, and there may be a challenge to the slate that's up there now on the grounds that the U.S. Supreme Court has not yet reinstated the Florida Supreme Court decision that was vacated based upon, that was the basis for that original certification. If you're confused, I'm confused. If you're not confused,
so that's
the way it goes.
Bernie, one of the things pointed out there is that the Democrats do plan to challenge that special session, and it will be in court.
Okay, thank you very much, Marty, David. And we remind you, our viewers around the world, that former Secretary of State James Baker will be making a statement in Tallahassee on behalf of Texas Governor George W. Bush. Looking at the clock, it could come up any moment. When he speaks, we'll report it live. Judy?
Bernie, we're also getting some word that there may be a statement coming from the Gore camp. We have no more details than that, but of course we wouldn't be surprised if that were to come along. We do know that both camps are poring over this decision line by line to make sure they understand the full implications of it. CNN political analyst Bill Schneider is here with us in Washington. Bill, whether the justices wanted to wade in to the presidential election or not, they have weighed in, and their ruling may well be determinative.
Yes, it has. Yes, it is. And I have read this per curiam brief, which is the decision that the whole court has agreed on with all the dissents around it. And I tried to make political sense out of this as a political analyst. And it makes a certain amount of common sense. It's a delicate political compromise. What the court has said is no recount the way it was being done, the way it was ordered by the Florida Supreme Court. That much is clear. It said the idea of a recount is fine. They didn't want to dismiss the idea that you shouldn't recount the ballots by hand. They said that is a fine idea, but it must be done right. Florida does not have the procedures in place to do it right. Adequate statewide standards are needed that are uniform for the entire state. They're not there. And they said there has to be a procedure for orderly judicial review of those standards. Now, the key sentence that I read is on page 11 when they said, it is obvious that the recount cannot be conducted in compliance with the requirements of equal protection and due process without substantial additional work. Without substantial additional work. So it sent it back to the Florida Supreme Court and said, we think what you wanted to do is fine, but you don't have the procedures in place to do it. You're going to have to do a lot of work to put those procedures in place, and it has to be done within the safe harbor provision, which my reading says really is by December the 18th, not the 12th, which would be absurd. But the question is, could it even be done by then? Is it at all practical? That's a political reading of what they've said.
And Bill, the bottom line politically is that 5 of the justices have determined that it is virtually, practically, whatever word you want to use, impossible for Al Gore to get the recount that he needs.
Well, they've sent it back. They've remanded it to the state Supreme Court, and I think their reading is that it cannot be done within the safe harbor provision, which is a way of saying, you know, we agree with the principle that the Florida Supreme Court was trying to impose, namely that you should have a recount of the ballots, but it simply cannot be done as a practical matter. The procedures are not in place in the state of Florida.
But of course, to Al Gore, it's the practical effect of it that matters.
That is exactly why all those Democrats are putting pressure on Gore. You might as well concede this cannot be done.
Well, the Associated Press right now is quoting a Gore attorney. W. Dexter Douglas is saying, quote, it sounds like we lost. What else can we do? He said, it means we can't do the recount, unquote. Charles Bierbauer remains outside the United States Supreme Court, where he has been reading this ruling that came down about an hour ago. Charles?
Well, Bernie, we've gone through it a couple of times. I'm sure there's a lot more in there that we haven't pulled out yet. This question of whether this is a judicial or a political ruling, it is, of course, first and foremost a judicial ruling. There will certainly be those who say it is political on the part of the justices here, and the stinging dissents from Justice Ginsburg and Justice Stevens, who suggest that the country has paid a price for this ruling. But there is also in the per curiam opinion itself, these lines. It says, none stand more in admiration of the Constitution's design to leave the selection of the president to the people through their legislatures and the political sphere. But the justices go on to say, when contending parties invoke the process of the courts, contending parties, the Bush and Gore campaigns, it becomes our unsought responsibility to resolve the federal and constitutional issues the judicial system has been forced to confront. And the justices found very clearly in their minds that there was a constitutional issue here, that there was an equal protection matter. And even beyond that, in the concurrence of the three justices, Justice Rehnquist, Scalia, and Thomas, additional concerns about the constitutional provisions of Article 2 as to the way in which the electors are being chosen. So it would seem that there is a very conscious awareness of the burden that this court has had placed upon it, and that it assumes with this in this highly political arena. Bernie?
Charles, please stand by. We're looking at a live picture. This is the podium at which former Secretary of State James Baker will appear very, very shortly, and he will react to this Supreme Court ruling. Jeff Greenfield, as we wait, back to you in New York.
Just to make this as clear as I think the court tried to do, it may seem what Bill Schneider said in terms of a political overcast is sound, but the court specifically looked at Justice Breyer's proposal that, in fact, they do create a recount provision that would go to December 18th, and the majority of the court said that would violate the Florida election code and could not be part of an appropriate order authorized by state law. So the five-member majority in this opinion specifically said, forget December 18th, the deadline is December 12th. Yeah, you might be able, in theoretically, to come up with a constitutionally sound recount provision with judicial review and all those things, but you can't do it by December 12th, because this is December 12th, so forget it. That's why, in looking at this opinion, the more you look at it, the bleaker it looks for Al Gore. The language at times suggests they're trying to come up with a remedy, but in fact they're saying, you know what, there is no remedy that fits the safe harbor.
2-minute warning.
So,
if you could, all cell phones and pagers off. 2-minute warning.
Jeff, that's, as you can tell, that's James
sounds like
Baker
a 2-minute warning to me, Judy.
As we listen up for James Baker, let me just further underline just how bleak the news is for the Vice President and how good it is for Governor Bush. In his concluding his dissent, Justice Breyer, quote, I fear that in order to bring this agonizingly long election process to a definitive conclusion, we have not adequately attended to that necessary check upon our own exercise of power, our own sense of self-restraint. Justice Breyer, he said, he's quoting Justice Brandeis, once said of the court, the most important thing we do is not doing. And Justice Breyer concludes, what it does today, the court should have left undone.
Exactly. Exactly. And what you're hearing is four justices who are thought of as relatively activist telling the five judges who are normally thought of as strict constitutionalists, you guys exercised your power to shut off a presidential election.
We're going to listen up now for James Baker.
Good evening, ladies and gentlemen. I've just spoken to Governor Bush and Secretary Cheney. They are, of course, very pleased and gratified that 7 justices of the United States Supreme Court agreed that there were constitutional problems with the recount ordered by the Florida Supreme Court. They wanted me to once again express their appreciation to the fine legal team and the hundreds of volunteers who have worked here in Florida on their behalf for the last 35 days. This has been a long and arduous process for everyone involved on both sides. Thank you and good evening.
Mr. Baker, do you feel it's over now?
A surprisingly brief statement by James Baker, but maybe not so surprisingly, his last words, it's been a long and arduous process for everyone involved on both sides. He started out saying he had just spoken to Governor Bush and to Dick Cheney, and he said they are very pleased, in his words, that 7 justices agreed that there were constitutional problems with that recount ordered by the Florida Supreme Court.
Roger Cossack, you continue reading this document, as do we here in the studio. What do you have?
Well, I just wanted to sort of respond to what David Cardwell said earlier. You know, the notion that the 18th, there may be some room to get to the 18th, I really don't think there is. And the reason is there was a finding by these 5 members, this majority, that the safe harbor date means December 12th. And since the United States Supreme Court took jurisdiction in this case, and we just heard Jeff talk about and Charles talk about things that perhaps what the dissenters say that perhaps they shouldn't have, but they did. And we all say the Supreme Court can do what it wants to. And they have defined it as, we have taken jurisdiction. The Florida legislature intended to be in the safe harbor. The safe harbor ends December 12th. Yeah, and 7 of us believe there's constitutional problems. There is no way to set up a recount because you have nothing in place to set that recount up. And they just defined away whatever the problems are. I think that there is very little room, and I don't see what the Florida Supreme Court could do. I think the Supreme Court has effectively cut them off.
All right, Roger Cossack. Now back to Austin, Texas, to Candy Crowley.
Judy, just an observation about what we heard from James Baker, Bush's point man in Tallahassee. It reminds me very much of where we were last week leading up to the Florida Supreme Court decision, which many people thought would go Bush's way and would end it. What we saw then in the days leading up to that was a very definitive backing off of claims of victory, of, Al Gore should give it up, of any of that. And what they were trying to do at that time, and what I think they're trying to do here, we did not hear from Baker any claim of victory, any claim of it's now all over, just well, we're really happy with this decision from the 7 justices that there were constitutional problems, and the governor and Dick Cheney want to thank everybody. What we did not hear were the words, this is a victory and we've won. I think what they want to do is clear the stage and leave the Vice President some breathing room here to make up his own mind about what he's going to do next before the Bush team does anything about publicly pushing anybody to do something. And I think that's what we're seeing now is the beginning of the kind of backing off stage and giving Al Gore some room to figure this out.
All right, Candy Crowley. Bernie.
Bill Schneider.
Quick comment about James Baker, and it just really agrees with Candy. What he was doing was very clearly saying, look, this is not our decision here. This is Al Gore's decision. He's read this opinion. We think that the justices have supported our side. We're not claiming victory. We're not pressuring anyone. We're not demanding any concession. We simply feel a simple statement. Al Gore now has to make his decision, and we're not going to comment on it. We're not going to recommend what he should do. But they believe clearly that the court and what it's mandated, and if the reading is correct that it is, in fact, December the 12th is the deadline, that is half an hour away. They're not going to recount the ballots in the next half an hour. So clearly, they see no way out, and they're simply waiting for Gore to recognize the inevitable without appearing to put any pressure on him and without appearing to be triumphant in celebration of this decision.
Thank you, Bill Schneider. Jonathan Karl.
Well, the Gore team also wants to make sure they get some breathing room from fellow Democrats. As we mentioned earlier, Ed Rendell, general chairman of the party, coming out and saying it's time for Gore to concede. Well, Joe Andrew has hastily come forward. Joe Andrew is the chairman of the Democratic Party, and saying no official statement yet. That is not the words of the Democratic Party. So the Vice President's legal team very much poring over this. He's been on the phone with Ron Klain, his lead lawyer on this down in Tallahassee. They've been going over this. To a person, the people on the legal team say, look, it looks bleak. Somebody said this would be Herculean for us to get over this, to be able to pull this off. Clearly a sense to a person on the Gore team that this is a bad decision for them, but they are falling far short of saying it is over.
John, do you get a sense that William Daley might be making a statement tonight on the Vice President's behalf?
Well, we had heard that there would be a statement coming from the Vice President's camp, a statement not from the Vice President himself. It would be, it's all speculation at this point, but given the late hour, it would be very surprising in my mind to see them come out and say something definitive tonight, perhaps something,
Oh, I don't mean definitive.
Yeah.
But we've seen Governor Bush's man come out and make a statement, and we know what that's about.
Right.
The newspapers tomorrow morning are going to press right now. And that's very important. They want that picture there. They want that text there. And I was just wondering.
Absolutely. And we had been advised earlier there would be a statement imminently coming from the Gore camp. We have not seen anything yet. They're very much in a state of I don't want to say confusion, but they're trying to figure out what's going on with this decision, trying to sketch out their options under extremely high-pressure situation here.
Thank you. Judy.
All right, we want to go down once again to Tallahassee to CNN's Mike Betcher, who for the last several days has been keeping a close watch over the Florida legislature. There today, the Florida State House of Representatives voted to accept a slate of electors committed to George W. Bush. Any sense, Mike, at this late hour, how what the United States Supreme Court has done might affect what the Florida legislature does, or does it make it null and void and unnecessary now?
They're going to go ahead. Lawyers down here are looking at this, trying to figure out how they should proceed. But you have to look at this with the backdrop of all this legislative activity. There is still uncertainty. All of us aren't sure what's going on. They're not sure what's going on. And that's the reason the legislature will proceed. But with the backdrop of all of this legislative activity is the potential of a legal challenge from the Gore campaign to this new resolution by the legislature of Florida naming those 25 electors for Bush. This, as Jonathan Karl has reported over the last few days, is the most secret aspect of the Gore campaign legal challenge. What they will do in terms of trying to challenge this in court. And this is something that they are planning.
Mike Betcher?
Yes.
I need to interrupt you,
Yes, sir.
however rudely. We want to go quickly to John King. John?
Bernie, anyone looking for a resolution of this tonight from the Vice President's camp will not get it. Let me read you a statement just sent to me, and excuse me for being awkward. I need to look down to read this on my pager. This is a statement from William Daley, the Gore campaign chairman. He says, quote, Al Gore and Joe Lieberman are now reviewing the decision issued tonight by the United States Supreme Court. The decision is both complex and lengthy. It will take time to completely analyze this opinion. We will address the court's decision in full detail at a time to be determined tomorrow. Now, we do know this statement being issued, not yet released publicly, being issued after a conference call involving the Gore legal team and the Gore political team, and we're told from several sources, some speaking to myself, some to Jonathan Karl, some as well to CNN's Chris Black, some on that call very pessimistic about the legal terms in this decision, but we're also told some of the operatives on the ground in Florida saying they believe the Vice President should hang in there and fight and at least take this back to the Florida Supreme Court one more time and see if they can convince the Florida Supreme Court to go ahead with another recount, accepting and adopting the standards, the very hard standards they acknowledge, set in tonight's Supreme Court decision. We're told the Vice President is at home with just his family. He did participate in some of the conference calls with his staff. And again, this statement we've just received from the campaign chairman, Bill Daley, indicating their full and official reaction won't come until tomorrow.
John, might William Daley deliver the statement you just quoted him as having made? Will he deliver that in person before cameras?
I don't know the answer to that, Bernie. I asked them to rush me a statement as soon as they could get one. They sent it to me via email over my pager, and I rushed in here. They do know we are quite interested in hearing from them, of course, but Mr. Daley, among those on the conference calls that continue, we know the Vice President was sent a copy of this decision, Senator Lieberman as well. Then you have a larger conference call involving all the lawyers, many smaller discussions among the political and legal advisors. Again, some very pessimistic. They've read this decision. They're using terms like bleak, devastating, confusing, but not encouraging. But we're also told by those who have been on the ground fighting for more than a month now, some of them are recommending do not fold until we can go back into the Supreme Court, they argue, and see what the Florida Supreme Court says after it reviews this decision.
And to repeat briefly, William Daley's essential reaction in the statement you just quoted.
He says this is a very complex and lengthy decision. He makes no characterization, doesn't say positive, doesn't say negative. Secretary Baker, who we heard from, obviously was encouraged by this. No such characterization from the Gore campaign. They are just saying tonight, at least initially, that they view this as a complex and lengthy decision. They will analyze it tonight and offer a new and more full and thorough reaction tomorrow.
Thank you, John King. Judy.
Well, to Jeff Greenfield in New York. Jeff, it sounds to me as if the United States Supreme Court has put the equivalent of a political Mount Everest in front of Al Gore and said, here, try to climb it if you will, but you're going to have to do it very quickly. You're going to have to meet certain standards, and otherwise, forget it.
I think that's the optimistic view from the Gore camp. As it happens, I spent this morning with one of the most prominent folks involved in the Gore campaign, and I asked him, was there any time in the last 35 days you thought you might actually win this thing? And he thought for a minute. He said, yeah. For about a minute and a half after that first Florida Supreme Court ruling that extended the certification deadline, and I was cheering and thinking we were going to win, and as soon as I heard the deadline, I stopped in my tracks and said, you know, there won't be enough time for that count. Except for that minute and a half, he said, he was always looking at this as, at best, an uphill battle. He also said to me, think about Al Gore, who believes not only that he may well have in a sense, won in Florida, but that if he lost, it was because of some of his key supporters in Duval County and Palm Beach, confused by the ballot, thousands of votes, not because of any conspiracy, but because of a bad voting practice, instructed in one case by Gore supporters to vote, as it turned out, incorrectly. Imagine how, if you're Al Gore, you're thinking you lost the presidency by that narrow a margin. And he said to me, he said, you know, people think of Al Gore as a man of government, which he is. He's also a man of faith. And I think the only thing that may be sustaining him now is the feeling that this must be happening for some bigger reason.
Jeff, is there any consolation for the Vice President in that the Supreme Court of the United States seems to be so, I don't want to say bitterly divided, maybe that's too strong a word, but vigorously divided in their opinion?
Well, I don't know. There's an old saying, and I think it's true in politics, that close only counts in hand grenades and horseshoes. And the fact that Al Gore won the popular vote and lost the electoral vote so close, and it was a one-vote margin in the Supreme Court, and instead of being president of the United States, he almost certainly will be a private citizen. Would you find consolation in that? I don't know. I know how I would feel, and it would not be in a very consoled mood.
Okay. All right. Jeff Greenfield in New York. And we are going to, when we come back in just a moment, we're going to take a short break. When we come back, we're going to sum up some of the truly extraordinary events of this evening. The United States Supreme Court ruling about an hour and a half ago that a recount most likely cannot take place, setting down very difficult standards and guidelines for such a recount to take place. We'll be right back.
This is a CNN.
Your call will be answered by the next available operator. Please stand by.
Your service reps are overwhelmed with customer calls, faxes, and emails. Integrate the internet into your call center and go from providing customer support to creating customer delight. Discover all that's possible on the internet. Cisco Systems, empowering the internet generation.
Is it their impeccable timing that counts?
Their know-how? How far they go?
Or just the freedom to relax? Yes, exactly. Lufthansa, there's no better way to fly.
Can your business afford downtime due to bad power? Can your enterprise avoid power disruptions? Who ensures availability for more networks worldwide? APC. Power management solutions wherever data is created, transmitted, or stored. For a free downtime analysis, go to iwantapc.com.
Well, what are you doing?
Cleaning up in here.
No, this is the backbone of our entire financial plan. Statement, top 100 mutual fund. Statement, tech, still sizzling.
Oh, is it? Honey, this is from 1997.
Want a little guidance? Introducing the personal financial consultant from Quick & Riley, a Fleet Boston financial company.
I was the first to go global and set up a worldwide distribution network. I didn't get where I am today by sitting around by the fire.
Need a new look? Get the mouse. It doesn't just sand,
It also scrubs, removes, and polishes. It's a whole new breed of tool. The Mouse, built by Black & Decker.
The United States Supreme Court justices have ruled in Bush versus Gore. CNN's Charles Bierbauer is outside the High Court. Charles?
Bernie, the bottom line of this ruling, which came to us around 10 o'clock this evening, was that the judgment of the Supreme Court of Florida is reversed, I'm reading, and the case is remanded for further proceedings, not inconsistent with this opinion. After that, it gets complex. The justices found that, as they put it, the recount cannot be conducted in compliance with the requirements of equal protection and due process without substantial additional work which they judged could not be completed within the provisions of the calendar and the federal election laws that require electors to be named by December 12th rather, so that they can vote by December 18th. That is called the safe harbor provision. And the justices found in this ruling for the court here that the Florida state legislature intended to meet that safe harbor provision. And while there seems to be the narrowest, infinitesimally small crack that says try it if you can, but we don't think you can do it, the caution is to stay within the safe harbor. The language gets strong when you get to the dissents of Justice Stevens, for example, who says that although we may never know with complete certainty the identity of the winner of this year's presidential election, the identity of the loser is perfectly clear. Justice Stevens says it is the nation's confidence in the judge as an impartial guardian of the rule of law, and he dissents. But Chief Justice Rehnquist, in a concurring opinion, says this inquiry does not imply a disrespect for state courts, but rather a respect for the constitutionally prescribed role of state legislatures. The attorneys for Governor Bush sought to find a federal case, a federal reason for this court to be involved. These justices felt there was one, that the Constitution has not been complied with, and they have so instructed the Florida courts, in essence saying, you can't go to the recounts, you've got to take it as it is, and that seems to point with very slim options to George W. Bush being named the winner of the Florida count. Bernie?
Thank you, Charles Bierbauer. Judy?
And now to John King, who can tell us what he's hearing from the camp of Al Gore. John?
Well, Judy, as we said, that statement now out in public from the campaign chairman, William Daley, saying that Senator Lieberman and Al Gore are reviewing this decision tonight, and they will not have any official and full reaction until tomorrow. Already, though, we're getting the sense now of the mounting pressure on the vice president. I spoke a short time ago to a senior Democrat in the House who said, look, we trust that the vice president is getting very good advice. We know the people around him. We know that they would not do anything too risky here, and we believe that if their advice to him is that it is over, that he will accept that advice. And this from a top aide to a Democratic senator who has been keeping quiet these past couple weeks, but who has been on several occasions ready to step out and tell the vice president he believes it is time to concede. The top aide to this Democratic senator telling us the situation is now, quote, desperate, saying that if they throw a Hail Mary tomorrow, people will start to bail. Again, this top aide to a Democratic senator saying the general mood among nervous Democrats, Democrats up, say, in 2 years, Democrats from states and or districts carried by Governor Bush, saying, quote, this is over. But the general mood is to let him make his statement. If he wants to fight on, then he will face trouble from within his own party. So mounting pressure among Democrats here as they read this decision, and they too share the pessimism of many of the vice president's legal advisors. But as we reported earlier, some disagreement within the Gore campaign, some of his political people on the ground in Florida suggesting he fight on, suggesting he at least send his attorneys once more into the Florida Supreme Court and see what the mood of those justices is after they review the Supreme Court decision.
From John King to Candy Crowley in Austin, Texas for the Bush camp's reading. Candy.
Bernie, privately, someone close to the Bush legal team in Tallahassee tells me that they consider this, have looked at this page by page, that preliminarily they believe this is a complete victory. They believe that the vice president has run out of options. We got the public answer from James Baker, who is Bush's point man in Florida. What we did not hear during that statement was any word of victory.
Good evening, ladies and gentlemen. I've just spoken to Governor Bush and Secretary Cheney. They are, of course, very pleased and gratified that 7 justices of the United States Supreme Court agreed that there were constitutional problems with the recount ordered by the Florida Supreme Court. They wanted me to once again express their appreciation to the fine legal team and the hundreds of volunteers who have worked here in Florida on their behalf for the last 35 days. This has been a long and arduous process for everyone involved on both sides. Thank you and good evening.
Mr. Baker, do you feel it's over now?
Once again, nothing from Baker claiming a legal victory or any other kind of victory, and with this purpose in mind. They do sense that this is now drawing to a close, but they do know that this is Al Gore's decision. They know that there may be some legal outs, perhaps, that the Gore legal team might find, so they need to leave that out there as a possibility. But more than that, what the Bush team is doing now is backing off the stage and giving Al Gore some room, free of any public pressure from the Bush campaign, to do what he's going to do. Bernie?
Thank you, Candy Crowley in Austin, Texas. Joining us now, New Jersey Democratic Senator Robert Torricelli. At this late hour, 15 minutes before midnight Eastern Time, what's your read of this situation?
Well, the Supreme Court has obviously been deeply divided on whether there was a remedy to what had a larger group in the court, and that is the question that there was an equal protection problem as the votes were being recounted in Florida. They may have sent this case back to the Florida Supreme Court, but they did so giving the court absolutely no latitude to do anything, in my judgment, but to certify the election as it now stands. That leaves Al Gore with a, I think, predictable but very difficult decision to make.
You think he should get out?
Well, I'm not going to try to make the judgment for him, and I don't think any of us in the Democratic Party or its leadership should speak to that before he does. But this is a man, on a human basis, I think all of us have to feel some compassion. He fought long and hard for the presidency. He has served his country with great distinction for a number of years. But it is clear that the electoral situation now for him has become legally extremely difficult.
You just used the word predictable. You said he's going to have to do the predictable. What is that?
Well, it is that for several days, I think to many of us in the Congress, it has been clear that the legal situation was precarious and that without some intervening event, this election was headed for the floor of the United States Congress. And while I may be disappointed with this result, I wanted Al Gore to succeed, I feared something more than Al Gore's defeat, and that was a potential deadlock and a straining of our constitutional system if this election was sent to the House and the Senate.
We just heard our John King reporting a few moments ago, Senator, that some of the Vice President's people in Florida, his supporters, are saying to him, in effect, hang in there, fight if you possibly can, see what you can do, think about taking this back to the Florida Supreme Court. Is that appropriate in your view?
We all have the partisan instincts who have fought for a long time to always go that extra mile in a fight. But in the end, it's the country we care about, and it's the constitutional process. The Supreme Court of the United States, and what they did today, may be debated for years. Some of us may deeply disagree with it, but it is the law of the land. And this judgment of the court does not appear to me to leave any latitude to return to the Florida courts and get any different decision than what was rendered tonight. It appears that the last vote in Florida has now been counted.
Senator Torricelli, if Vice President Gore loses, is it important how he loses?
I think it is important how he deals with his statement tomorrow. George Bush comes to the presidency under extremely difficult circumstances. Never in more than a century has a president's legitimacy been challenged in this country. Has there been an issue of their authority or their right to serve in office? All of us, not simply members of Congress, but all Americans have a responsibility not to revisit this election again. What has happened is past. We can regret it. We can debate the aspects of law, but the nation's going to have a new president. And that president has to succeed, and all of us have an obligation to make his administration work.
Did I just hear some news? You said in his statement tomorrow Do you know for a fact that the Vice President is planning a statement tomorrow?
I don't know. I think it's simply a good assumption that something would be said tomorrow. One way or another.
That's what you sense?
One way or another, the Vice President is going to have to clarify his intentions tomorrow.
But just to be very clear, before we thank you, Senator Torricelli, you said it appears to me the last vote has been counted in Florida.
Well, reading the Supreme Court judgment tonight, they say they disagree on the vote counting on equal protection basis, and by a 5-4 vote, they see no remedy. Given the deadline of the 12th of December having passed, they do not believe it is lawful to make any other changes in the counting of the votes. It appears to me that no matter anybody's intentions, the Supreme Court is not going to tolerate any new vote counting in Florida.
Senator Robert Torricelli of New Jersey, thank you very much. I appreciate you joining us. And across the studio from where Bernie and I are sitting, John Carl has been talking to other Democrats on Capitol Hill. John?
Yeah, we've been trying to take the temperature of Democrats on Capitol Hill. Also, our producers up there, Dana Bash and Ted Barrett, working the phones very strong. First thing, Dick Gephardt, the House Minority Leader, his office is saying that he will not make a statement today, and that in fact he has no plans to talk to the Vice President tonight, and he will wait till tomorrow to see what take his cue from the Vice President. But some other Democrats, one Southern Democratic senator telling CNN that the quote's very short, it's over. That from a Southern Democrat who's not going to come out publicly and say that. There's also another Democrat from the West who's saying very much the same thing, that if the Vice President tries to go for this discussion that this Democrat had with John King, tries to throw a Hail Mary here and go for it, that he's going to lose support very, very quickly. But Mark Fabiani, the spokesperson for the Vice President, I asked him about this reaction and also about what Senator Torricelli is saying, which is essentially, you just heard Senator Torricelli say the last vote's been counted in Florida. Well, the Gore team's not ready to say that, and they have a response to those like Senator Torricelli within their party who are coming out and getting ahead of them on this. The quote from Mark Fabiani is, reasonable people are going to give Gore the time to read the Supreme Court's decision before making his own decision. Fabiani goes on to say, but in every party there are people who would rather get on TV than be fair and reasonable. So the Gore campaign not happy with what they've been seeing, with some Democrats coming out privately and even publicly and making these statements. The one that most perturbed them was the statement by Ed Rendell, the general chairman of the Democratic Party, who came out and said it's time for Gore to concede. That prompted a hasty response from Joe Andrew, the other chairman of the Democratic Party, saying that Ed Rendell speaks for himself. He does not speak for the Democratic Party. Bernie.
Thank you, Jonathan Carl. We have on the telephone Professor Lawrence Tribe, legal advisor to the Vice President. Professor, your basic and brief read of this ruling tonight.
Well, Bernie, let me actually say the principal thing that I wanted to say, and that was I understood that someone on CNN had reported that I was advising the Vice President to concede, and I simply wanted to make sure that it was understood that was incorrect. I certainly have not offered that advice. What I have done is read this opinion quite carefully, and it is a complicated opinion. The Supreme Court of the United States, rather than itself taking responsibility for the conclusion that this election is over, attributes to the Supreme Court of Florida an interpretation of what the legislature of Florida would want in these circumstances. It's a very convoluted hypothetical thing, and it simply needs closer analysis. I know that everyone wants closure, but I would think that an overnight period of careful study and reflection is at the minimum what the Constitution and the country deserve.
But Professor Tribe, it's Judy Woodruff. You know these issues very well. You've been dealing with this day in and day out for the last number of days, and even though you didn't argue for the Gore team before the court yesterday, what window is there for Al Gore to get the recount that he's been asking for? It's not clear to a growing number of people that there is a window.
First of all, I'm not insisting that there is a window, and there are some important paragraphs in the opinion that if I were teaching a law class, I would point to right now and say, look at this, look at this. But I don't want to do that on the air because I don't think that's fair to the Vice President or fair to your viewers. The fact is, and this is the important thing that I think anybody reading this opinion can notice, the fact is that the opinion pins everything in the end on the fact that the Supreme Court of Florida has made some statements about the intentions of the state's legislature about this safe harbor that we've heard so much about. And reading through all the technical jargon, what they are saying is the highest court of Florida believes that the Florida legislature would rather have it all over with by December 12th to take advantage of the safe harbor than to take some extra care and possibly get it right by December 18th. It may be that the Supreme Court of Florida thinks that that's what the Florida legislature believes, but it may not. And I'm not suggesting that as a result of that, the right course of action is to move on legally. Those are decisions that I'm not going to be making. But I just don't want people to think that, A, I believe this opinion is definitive, or B, that I've recommended that the Vice President concede. Those are political judgments ultimately, and I don't pretend to be making them.
Professor, when you were referred to here on CNN, we did not report that you were advising the Vice President. We quoted your remarks in an interview that you made to NBC and MSNBC. Do you recall what you said?
Well, I obviously don't have a transcript in front of me.
Well, I think the gracious thing is to accept, even if one disagrees with the decision of the Supreme Court, quoting Tribe, and I'm reading to you from Reuters news service. I'm sure that Vice President Gore has the kind of reverence for the Supreme Court as an institution that he will really not undertake to be less than complete and gracious in his acceptance of this result, unquote.
Now
the headline
right.
from...
That's certainly right, but in context, I'm talking about his acceptance of the result once he has analyzed it, and not prematurely. Mm-hmm. I certainly think that if, upon reading this decision and reflecting on it, the Vice President concludes that it closes the door legally, that he would not undertake to let his disappointment with that somehow overtake his willingness to move on. But I don't think that means that he should prematurely conclude that this opinion is definitive.
Professor, Correspondent Charles Bierbauer is still outside the Supreme Court reading this decision, and he has a question for you. Charles?
Professor Tribe, I just wanted to try and be as clear as we can as to whether there is any window out of the safe harbor provision, which the court seems to be saying that Florida is bound to stay within, and how wide or how...
Excuse me, Charles, the court isn't saying Florida is bound to stay within the safe harbor.
Well,
it is saying, and I'm looking at page 12 of the court slip of paper.
Yes, so am I.
It's saying that it believes that the legislature would want the state to stay within the safe harbor, and it simply doesn't address the question of what the legislature would do if the choices were safe harbor or something else. In other words, the choice of staying within the safe harbor, that's a desired thing. The legislature would want that if possible. But if it were told the only way you can get that is to leave potentially tens of thousands of votes uncounted, the court is not saying, and it would be hard to say, that the Florida Supreme Court believes the state legislature would want to leave those votes uncounted as the only way of staying within the safe harbor. Now, that's the way I would teach this in a class on constitutional law. I would ask students to dissect it, but I really want to draw a sharp line between that and what the Vice President should do, what anyone should do in these circumstances, which are more political than legal in character.
And would you judge, Professor, that they have made the hurdle so high as to be insurmountable to conduct any kind of account at this point?
They've made it extremely high. Extremely high. I can't say that it's literally insurmountable, but certainly they have tried as hard as they could to create a hurdle that couldn't be surmounted without coming out and saying themselves that they wish to bring this to a close. That is the remarkable thing in a way. There are many remarkable things about the opinion, but one is that the court is punting. It's not really accepting responsibility. It's saying, here are all the things that have to be done. We don't think you could get them done by midnight tonight. Big surprise.
Well,
and we think the legislature would want it done by midnight tonight.
Professor Trott, I think it's Judy Woodruff. I think what we're basing our assumption here on is that the dissent in several of the dissents, the language is very clear that the dissenting justices are expressing regret that the majority doesn't agree with them, that there's a way to get this done by the 18th.
Well, having taught hundreds of these opinions, though none quite as momentous as this, one of the things I observe very often is that dissenters quite powerfully dramatize and sometimes exaggerate what the majority has wrought, hoping to peel off a member of the majority or hoping to speak to history in terms that are maybe more apocalyptic than justified. It's not unusual for the dissenters to say the sky is falling as a result of the majority opinion, when in fact there are silver linings around some of the clouds.
Professor, you just told our audience that you believe the highest court in this nation is punting. In your words, it's not really accepting responsibility. My question is this: what does this ruling do to this court's integrity?
No, I don't think that I am arrogant enough to render that kind of verdict. I think that history will have to render it. I do know that it is going to be hard for many people to teach this opinion without raising questions about the court's institutional performance. But it's much too soon to talk about what the page will look like when the ink is dry.
Professor Tribe, this is Roger Cossack. Are you at all surprised about the notion of the United States Supreme Court's majority in this case dictating to the Florida Supreme Court what the intent of the Florida legislature was? That is, coming back and saying that the legislature obviously intended to be part of the safe harbor. Isn't that more of a state question than a federal question?
Well, it's certainly ordinarily a state question. Here, there is the excuse that they are quoting from the state court's from the highest state court in an opinion that it rendered, referring to the desire of the legislature that the state participate fully in the election process. And so they are interpreting that language as a kind of judgment by the state's highest court of what the legislature wants. But it's a pretty amazing thing. It's also quite remarkable for the U.S. Supreme Court to be telling the state that if it is to revisit the matter and try to come up with some solution before the 18th, it must do so on the basis of oral argument. That is, detailed micromanagement of the way in which the state's system deals with a matter is not characteristic of a court that believes in states' rights.
Professor Tribe, do you think that this Supreme Court will be called, and I do not mean disrespect, but it's the word that comes to mind, hypocritical, in the sense of what they did was stay the count that was going on, continue it in a way until a decision comes down on December 12th, and then come back and say, you must then complete your action by December 12th, and since you can't do it, you won't be able to do it. If they had never put that stay in, they would apparently have been able to do it.
It's tempting for me to take advantage of this opportunity to slam the court because I'm so distressed by its result. It's tempting to compare it to that famous statement in Casablanca, where the guy walks in and says, I'm shocked that there's gambling going on in this establishment, when it was, after all, known all along. But that really wouldn't be fair to the court, because the fact is that even if they hadn't stopped the count that was going on a couple of days ago so precipitously, their conclusion that there were equal protection problems with the way it was going on would have required that part be redone. And so it's not as though the only reason time is basically out is that they stopped the process before it could get completed.
Professor Lawrence Tribe, one of Vice President Al Gore's legal advisors, we thank you very much for joining us on the telephone.
Thank you, Judy.
Geniuses. Get inside the Actors Studio sweepstakes by calling 1-866-ACTORS-1 for a chance for you and a guest to fly round trip to New York with hotel accommodations for 3 days and 2 nights and exclusive Bravo merchandise, plus tickets to attend a taping of Inside the Actors Studio where you can see firsthand that their performance is art. Sponsored locally by your Southern California Jaguar retailers who bring to you the art of performance. Jaguar. Engineered with character, passion, and distinctive style.
Burden of Proof. Weekdays, 12:30 Eastern on CNN.
This is a CNN Election 2000 special report. The election without end approaches its final hour. 60 minutes from now, Al Gore addresses the nation, one night after the Supreme Court dealt a fatal blow to his White House hopes. George W. Bush will follow with his own primetime remarks.
See what happens. Thank you.
His first chance to appear without challenge as the president-elect. As the players prepare to write Election 2000's final chapter, not everyone wants to close the books.
He'll be the president legally, but he does not have moral authority because his crown did not come from the people, it came from the judges.
We look ahead to the next American president and survey the 5 weeks just passed to see how history will judge this election and its dynamic ending. Reporting now from Washington, anchors Bernard Shaw and Judy Woodruff. And in New York, senior analyst Jeff Greenfield.
Good evening. We are 1 hour away from what could be the biggest speech in the political career of Albert Gore Jr. A speech bigger than any concession speech that we in the news media and even the Vice President himself thought he would give more than a month ago.
Gore's address is expected to close out Election 2000, an election that went from being just a tight race to an eye-opening civics lesson, and then, at times, a heart-wrenching legal battle.
At one point, more than a dozen lawsuits were unfolding across Florida and in federal courts in Atlanta and the nation's capital.
And that's not to mention the election night confusion that humbled many of us in the news media.
Our colleague Jeff Greenfield joins us now from New York. Jeff?
You know, Bernie and Judy, in 1824, Andrew Jackson lost the White House to a son of a president, John Quincy Adams, even though he won the popular vote. 4 years later, in a rematch, Jackson won the White House. In 1888, President Grover Cleveland lost the White House to a grandson of a president, Benjamin Harrison, even though Grover Cleveland won the popular vote. 4 years later, Cleveland won the rematch. If Al Gore, who has lost tonight to the son of a president whom he beat in the popular vote, wants a rematch in 4 years, what he says tonight and how he says it will be a key first step in that potential rematch. Folks.
We'll be coming back to you a lot during this evening. Well, Vice President Gore will have plenty of time to think about his political future, but today he spent part of the day tying up loose ends from Election 2000. CNN's Jonathan Karl joins us live from the Naval Observatory, where the Vice President lives. Jonathan?
And believe it or not, Judy, the Vice President has spent much of the night here tonight entertaining guests at his home at the Naval Observatory, a long-scheduled holiday party, obviously scheduled long before we knew we'd still be in the middle of this election battle and on into the day of his concession speech. The Vice President, though, has written that speech, we are told, and all the pieces are in place for what some of his supporters are saying will be the biggest night of his political life.
The battle finally over. The Gore team is packing its bags. Lawyers, political strategists, and volunteers closing their makeshift headquarters in Tallahassee. At about noon, behind closed doors, the Vice President gave his first farewell speech of the day via speakerphone to his legal team, thanking them for creating, quote, the greatest virtual law firm in history. During the call, the Vice President invited members of his legal team to a holiday party at the Vice Presidential residence, and then jokingly told them, quote, my house is the one with the people out front yelling, get out of Dick Cheney's house. Gore's aides are using words like gracious and statesmanlike to describe the Vice President's speech tonight. As one top advisor said, quote, this is about helping people heal and moving forward. Republicans have the same hopes for the Vice President's speech.
I've seen other senators say that the most important speech, perhaps, at this juncture will be the one that is made by the loser rather than the winner. And I expect he will be magnanimous. I expect he will ask the American people to join him in supporting the next President of the United States.
Most senior Democrats agree that it is time for Gore to concede, although some, expressing outrage at the Supreme Court decision, are suggesting he should fight on until the Electoral College votes are actually cast and counted.
Well, the man has gone through a lot, and for those people who say that he should withdraw, they should walk in his shoes. I think it's a personal decision, it's a political decision, and we have to recognize it just doesn't concern him. It concerns our Constitution. Constitution, and it concerns the feeling of the American people.
And Jesse Jackson held a rally in Tallahassee protesting what he called an illegitimate victory for George W. Bush. Afterwards, in an interview on CNN, Jackson said Bush will be a president without the moral authority to lead.
He'll be the president legally, but he does not have moral authority because his crown did not come from the people, it came from the judges.
One top Gore aide said the vice president will talk about the principles he fought for during this recount period, but will say that he will respect the rule of law and also talk about how it is time for Republicans, Democrats, and independents to get together because the country's problems, the country's challenges are too great for partisanship. Judy.
John, how many of the people around the vice president would agree with Jesse Jackson that a President Bush will not have the moral authority to lead?
Well, Judy, several people around the vice president, although the vice president has been very direct in telling his aides that he does not want to see people on his staff, people associated with him, questioning either the legitimacy of the Supreme Court, questioning the wisdom of its decision, or questioning the legitimacy of George W. Bush. That said, there are several of his top aides that, in fact, are very upset even that George W. Bush is giving a speech tonight. Several aides that I've spoken to have said this should have been Al Gore's night, and they think it's inappropriate that an hour after Al Gore gives his speech that George W. Bush will come out and do the same.
All right, John, Carl, thanks very much. The fight continues in some ways. Bernie.
Governor Bush remained relatively quiet this day out of courtesy to the vice president, saving his comments until after Gore addresses the nation. Joining us with some reaction to this day's events from the Bush camp, CNN senior political correspondent Candy Crowley. Candy.
Bernie, this is in effect tonight George Bush's debut speech as president-elect. He has been hoping and waiting for this moment for 36 days now. He no longer has to hope. He has only a couple of more hours to wait. He is the man of the hour, just not this hour.
Nice to see you all.
The Bush family has taken political and personal blows in the past, says a friend, and the governor now wants to give the vice president room to do things his way.
Welcome up.
So George Bush was seen but not heard to say much as he waited out the evening speech of Al Gore. What follows will be the first speech of the second Bush era. The governor says a senior staffer will deliver a tone-setting speech. He will talk about seizing the moment and using it as an opportunity to bring people together, to put national interest above partisan ones.
I want him to make a very positive, unifying sort of speech. He needs to reassure the American people. I think he needs to ask for their help and their support. And I think he'll need to make some commitments of his intentions.
There will be talk of general goals, but no specifics, no word on a cabinet or the senior staff. Bush has had his national security team and senior staff largely locked in and waiting to go, but the announcements will wait a bit longer. Coming together, says an aide, is the most important message tonight, and it stands alone. Bush will use the Democrat-controlled House chamber of the Texas legislature as the backdrop for his address. He will be introduced by the House Speaker, a Democrat. Message: some of my best friends are Democrats. I have worked with them, and we got things done. For Bush, reaching out will mean going an extra mile. His campaign says the governor hopes to meet with the vice president, among others, during a visit to Washington, now sooner rather than later. Bush often flashed his bipartisan credentials during the campaign, but this is not about politics or even philosophy. This is now about practicality. George Bush will need to move this nation forward, but first, he must pull it together. Bernie?
Candy, the Bush camp is using this theme, coming together, but in reality, politically, during the campaign, this was a candidate who said he was out to restore dignity to the White House.
Absolutely, and there were many times during the campaign that, in fact, there was a tone, if you will, that was harsh. That it was it was the heat of the campaign, and a lot of things were said on both sides. And whenever George Bush was asked about that, he said, "This is about politicking, and governing is something else again." Look, what they know is just the reality of it again. That if he wants to get anything done, if there is to be success in this administration, it has to be done with both Democrats and with Republicans. And in fact, tonight, Bernie, much of this speech is about reaching out to Democrats. It's not about reaching out to his own party. It's about reaching across that aisle already and going for Democrats, because that's the only way he's going to be able to lead.
Candy Crowley waiting for the speech in Austin. Thank you.
And joining us now for some insight on this remarkable evening, CNN's senior White House correspondent, John King, in Washington. John, we keep hearing that the Vice President is going to be gracious, that there's not going to be certainly any bitterness in the speech. But maybe I'm projecting, but it seems to me if I had lost a presidential race under these circumstances, there'd be a tremendous amount of regret, even anguish about it. Are you hearing anything about that from his aides as to where he is, the Vice President, privately?
Well, privately, we hear there's regret, there's frustration, there's anger. We know he's called home to Tennessee to ask friends in the month long we've been waiting for this to be over, how did I lose my home state? We know that he's questioned others about the legal strategy they have pursued down in Florida. We should note, of course, though, that he made all the difficult final calls in the end. Those decisions on legal strategy were his. But go back to your point, Jeff, at the beginning of the show. This is a man who must decide in the next several months whether he plans to run again. So for tonight, he needs to put all that aside. He needs to explain to the American people why he did what he did, why we went through this the past 30-plus days, and why he believes it is critical now for Democrats to embrace Governor Bush as the legitimate president of the United States. He must do that. His aides say he understands if he is to leave this process with credibility, enough credibility to perhaps mount a comeback. And some evidence he's thinking about that. Among the phone calls today, a thank you call to John Sweeney, the head of the AFL-CIO, a very powerful man in helping the vice president get to the nomination and in turning out labor voters on Election Day. So you get a sense here, everyone says he hasn't made up his mind, hasn't thought about it, wants nothing more than to get a vacation in after another week or so, but you also get the sense that he's certainly thinking about it.
So does that suggest that in this speech that he gives tonight, he's going to remind people of some of the issues on which he ran, or is that the sort of thing that's just not the right time for that now?
What we are told is he will give a general sense, as Jonathan Carl mentioned, that it's time for the nation to come together because there are problems that need to be solved. Education, Social Security, health care. No, we will not get a campaign speech from the vice president tonight. But this is a man who wants the American people to remember him fondly, who wants the American people to think that he fought for a good cause as he steps aside here. And he is a person, remember, most of all, if he is to run again, that would have to first go through a Democratic primary that would be much more competitive next time. He will not get the pass he received this time. So most of all, he wants the Democratic base out there to think that he fought for them, that this fight was for them, and that he will forever be their friend, and that perhaps he might be calling them again a year or two down the road.
Just one quick last point. My experience is that aides are always willing to be more publicly, or at least in communication with someone like you, more open about their anger than the principal. Are you hearing from the aides a little more anger at the way this ended than from Al Gore?
Oh, certainly. They're scathingly critical of the Supreme Court. They believe the Supreme Court stopped the recount on Saturday and then said last night, you know what, we have to call this off because there's not time enough to finish the recount by midnight tonight. They're scathingly critical of the conservative majority of the court. And let's step back and remember there's a bit of a Hatfields-McCoy nature to all of this. It was Bill Clinton and Al Gore who ran George Bush out of the White House 8 years ago. George W. Bush, an enforcer in his father's White House, was furious at the time. Now he will come to Washington next week, sit down with President Clinton for a courtesy call, sit down with the vice president for a conciliation meeting, perhaps even lunch, we're told. Then he will prepare to move into the White House that his family believes was stolen from them 8 years ago.
John King, who will be covering the first battle in the Iowa caucuses of 2004 in about a week and a half. Thanks very much. Judy.
And you may be prescient, Jeff. Well, for some more insight on this incredible election, we're joined by CNN senior political analyst Bill Schneider. Bill.
It's our 864 of election night, and we're still here. It's the longest election night on record. What we're waiting to hear from Al Gore, I think, tonight is, will he use the word concede? That's the interesting word. It's often called a concession speech, but to say, I concede is a way of saying, I lost the election. He doesn't believe he lost the election. He knows that he didn't lose the popular vote. He's beating George Bush by about 300,000 votes nationwide, and he honestly believes that he won the state of Florida, but they just won't count the votes. And eventually they may count the votes because they are public property, and there are several news organizations that have applied for permission to count the votes, and they can under Florida law. So he thinks eventually he'll be shown to have won the state of Florida. So he doesn't want to say he lost. His campaign found a new principle, a new cause in the post-election period. Every vote must count. He's rallied Democrats to that cause, and he doesn't want to give it up.
Bill, can he not set a tone in tonight's remarks without actually using the words, I concede?
I think he can. Essentially, he wants to make it clear he's not challenging the legitimacy of George Bush's claim on the presidency. He's going to withdraw his own campaign, but he doesn't want to say he lost. He has to make it clear to Democrats that they shouldn't challenge the legitimacy of Bush's campaign. Otherwise, I think he will be seen as what some Republicans have already been saying, a sore loser. And that is no way to have a future in American politics.
All right, Bill Snyder, thanks very much. And Bernie.
Next, election 2000's place in history.
Perspective from historian Robert Dallek when we return. And why African Americans continue to carry the fight for Al Gore.
Later, Greta Van Susteren dissects the Supreme Court's ruling on Election 2000.
And a preview of the speeches by Al Gore and George W. Bush with experts on political communication. You're watching a CNN special report.
Open up our doors, peek around the corners at all the great stores. The ones you look for, names you know, a few to discover. You want selection? We got that covered. Grab a friend, bring the family, bring yourself and see all that shopping can be. Shopping with Simon. Simon is waiting for you.
Malls, centers, and shopping from Simon. Simply the best shopping there is.
What's the word I'm thinking of?
Is it no?
No.
No.
Okie doke.
Whoa.
No.
Want banks to compete over you? At LendingTree, fill out one simple form and get up to 4 offers.
Thank you. Thanks for coming.
When banks compete, you win at LendingTree.com.
One reason you work so hard is to enjoy the good things in life. And if you're getting financial advice you can trust, your biggest worry should be whether or not the fish are biting. At Raymond James, we have no products to push or sales quotas to meet. So our only interest is in helping you maximize your financial success. So instead of waiting for your ship to come in, you can already be on board. Raymond James, committed to your financial future.
That snowball is a great way to tell customers Staples has technology gifts.
Greetings, handhelds make terrific gifts. So do digital cameras.
Nice price.
Excuse me, could you tell me about the scanner fax copier?
No.
But I want to get it for my brother.
Get him a cell phone.
No, he really wants one of these.
He can't have her. I love her.
What?
No. Weeping.
It's okay. We found you someone else.
Oh.
For technology gifts they really want, it's Staples.
Years before America's electric cooperatives forged the nationwide alliance, Touchstone Energy, neighbors built their own electric utility to power lives and communities. Now Touchstone Energy cooperatives serve millions of homes and businesses. Customers large and small get state-of-the-art technology and affordable service. From the one-room schoolhouse to the communities and businesses of tomorrow, trust Touchstone Energy, the power of human connections. We are America's electric cooperatives.
There'll be more conspiracy theories arise out of this to make the single bullet theory look very solid.
Well, this election clearly is one for the history books. After 5 weeks of legal and political battles, George W. Bush, who came out behind in the popular vote, as we mentioned, will move into the White House. Such a situation is not unheard of. In fact, 3 previous presidents won the election without winning the popular vote. The first time, 1824, Andrew Jackson got the most votes from the people and the Electoral College, but not a majority of either vote. The election went to Congress, and the presidency went to John Quincy Adams. In the 1876 election, the calendar turned to the next year before Rutherford B. Hayes was declared the winner. His challenger, New York Governor Samuel Tilden, won the popular vote, but 3 states sent competing slates of electors to Washington, and a special congressional commission recognized the Hayes electors, giving him the presidency by 1 electoral vote. In 1888, President Grover Cleveland won the popular vote, but Benjamin Harrison captured the state's richest in electoral votes, and he won handily in the Electoral College. What does this mean for the present circumstances? We'll try to find out by talking with presidential historian Robert Dallek from Boston University. Professor Dallek, I noted at the outset that John Quincy Adams and Benjamin Harrison lost the next time out to the people they'd beaten. Rutherford Hayes didn't even bother to run again. Does this suggest anything about George W. Bush's political future?
Oh, these historical analogies are imperfect.
And of course, this is the great challenge now to George W. Bush, that a crisis like this presents an opportunity, and he can rise above it and be an effective president, and he could win a second term. On the other hand, he could fall on his face the way Rutherford B. Hayes, I think, did, and the way Harrison did. So it's an open question, and this is, I've got to be on his mind. I think the understanding of the odds against him of getting a second term. After all, he's lost the popular vote. This will be the biggest deficit of any entering president, any president-elect in American history, 337,000. Before that, Tilden won that election over Hayes by 264,000. Of course, it was a much smaller population, but still to lose by 337,000 votes and then end up in the White House, that's a pretty difficult number to overcome.
Well, one thing, though, that those 19th century presidents didn't have that George W. Bush will have is something called television.
Yep.
And we do remember that in 1960, John Kennedy more or less tied Richard Nixon. There are some people who think he actually lost the popular vote. And pretty quickly, through the medium of television, he established himself as the president. Doesn't this suggest that the President-elect Bush, if we can call him that, does have one big advantage in trying to establish his power as president?
Jeff, he does, but there's a big difference between 1960 and 2001. In 1961, John Kennedy faced an international crisis. There was all this discussion of the missile gap, the threat from the Soviet Union, Castro in Cuba, and foreign affairs is a unifying issue. It's something you can rally the country around. And George W. Bush doesn't have anything like that. And so even with television, although I think you're quite right, indeed, my guess is that tonight, from everything I'm hearing, this will be a masterful performance. He's going to speak in the well of the Texas lower house. He's going to be introduced by a Democratic Speaker of the lower house. It's very shrewd politics, and it's going to be orchestrated on television in a very effective way, and that will help him, I think, launch his presidency. But there's a difference between this and 1961.
For sure. But one of the things that happened when John Kennedy was elected by this very narrow margin was the day after he was elected, his first two appointments were reappointing J. Edgar Hoover as head of the FBI and Allen Dulles as head of the CIA as a way of saying continuity, unity, and also probably a way of saying I don't have the mandate to change this even if I wanted to. Does that suggest that what we've heard about already, the idea that President-elect Bush will have to reach into the Democratic Party for some of the people in his White House staff is now a political necessity?
Yeah. Well, I think he might have done some of this anyway, because, you know, there's an irony in this election. The way I see it is that Bush's one great strength has been, at least in Texas, has been that he, as is described himself, a unifier. He was someone who was very accommodating to the Democrats. And he's going to enter the White House now with this strength of being a unifier and accommodator, and he needs to do that. And, of course, it's going to depend on who he puts in place. If he picks some minor Democrats in minor positions, it's not going to help him very much. He needs one or two, I think, prominent Democrats who can give him a kind of credibility with folks on the other side of the aisle.
All right, Professor Robert Dallek, thank you very much for joining us, and we'll see whether or not these prognostications come true in the next 4 years. Back to Washington.
Right.
And up next, some thoughts from CNN's Wolf Blitzer on where the Gore team is assigning blame. For those of us in our line of work, the answer may hit a little bit too close to home.
When you were sad and lonely, you know you want me. Back off, he's a killer.
No longer be a silent witness to my own kids' education.
I will no longer sit and watch the system fail my kids.
I will no longer let them use my tax dollars.
My tax dollars to tell me where to send my kids to school.
I will no longer let them put the system's needs above my kids' needs.
I will no longer let freedom and choice be the American way in everything.
Except their education.
I want to have choices.
I want to have a voice.
I want to decide where to send my kids to school.
If
Your bag's been in your possession since you packed them.
Did you know your company's stock just jumped 13%?
No.
Did you know Geldman got food poisoning and can't make the meeting?
What?
Sir, I'm going to have to ask you to check your email before you board.
How?
Here. It's the Sprint PCS Wireless Web for Business. You can access your company's network, use email, share information in real time. And the calls are clear.
Thanks.
Thank him.
The Sprint PCS Clear Wireless Workplace. Because business can't wait.
Yeah, it was amazing. Whole different world. You were a volunteer? Yeah. I saw a world that wasn't so fortunate. They needed help. In business, I see a world full of opportunity. Sales like how you don't do more. To help me take advantage of those opportunities, I invest in international funds with T. Rowe Price. I chose them because they work with analysts all over the world. See, I know what a difference being there can actually make.
T. Rowe Price, helping people invest with confidence for over 60 years.
A year ago, these internet whiz kids were riding high. Today, they're out on the street and picking up the pieces. Willow Bay asked some .com casualties what they learned, and would they do it all again? The Moneyline News Hour, tomorrow on CNN.
Once he saw her.
Fixing to get me in trouble.
You are in trouble.
Once he loved her.
I know the old man likes you. That don't mean he's gonna sit still for you courting his daughter.
He'd risk everything for the woman he was forbidden to love.
I have to see you.
I can't. I made a promise.
Academy Award winner Matt Damon.
I'm gonna love you till the day I die.
All the Pretty Horses. Rated PG-13. In theaters everywhere Christmas Day.
No matter what Al Gore does today, the Democratic Party is committed to making sure that the public knows who actually won in the state of Florida.
Joining us now with more insight into Election 2000's endgame, CNN's Wolf Blitzer. Normally you'd see him in the anchor chair at this time of the evening. He covered Al Gore as part of the White House beat for 7 years. Wolf, the anger inside the Gore team, where's it directed most?
You know, there's obviously a lot of anger at the Supreme Court justices, at some people in Florida, Republican officials in Florida. But I have to tell you, for these past 5 weeks, I've spoken to a lot of the Gore people on an almost daily basis. And the theme, a lot of them, most of them, keep hitting directly at me, is that they think this would have been a totally different situation these past 5 weeks if the TV networks had not called George W. Bush the winner shortly after 2 a.m. that day during our election coverage. For 45 minutes, we were all speculating about the Gore presidency. They think the dynamic of these past 5 weeks would have been totally different if we had said that night, you know what? We don't know who won Florida. It's just simply too close to call. They're going to have to take a closer look at the ballots. And as a result, they're really angry at what we did. And they say, and perhaps rightfully, that we're going to have to take a real close look at our role in how this unfolded because of the mistakes that we made that night.
Well, institutionally, CNN already is doing that. Another subject. Any second guessing about not turning to Bill Clinton for help?
You know, surprisingly, there isn't a whole lot of second guessing on that. You would have thought some people, especially Bill Clinton fans, said, well, you should have used Bill Clinton more. He was so popular. He had a base. But among the inner circle of the Gore folks, they're not second guessing that much. They're saying that he would have been too divisive. And the fact that they carried swing states like Pennsylvania and Michigan, which were critical to the election, that was in part because they didn't highlight Bill Clinton. They highlighted Al Gore. So on the Bill Clinton front, I don't think there's a whole lot of second guessing.
So what are they second guessing?
I think they're second guessing. I think John King touched on this earlier. They're second guessing themselves, and Al Gore is second guessing himself in not carrying his home state of Tennessee. But even on a relatively minor, what they thought at the time situation, not spending more time in a state, let's say a traditionally Democratic state like West Virginia. Those 5 electoral votes in West Virginia, if you add them to the 267 electoral votes that Al Gore did have, would have made all the difference. Traditionally, West Virginia goes Democratic. They didn't spend a lot of time there. George W. Bush went to West Virginia in the final days of this campaign, and it obviously had an impact.
Thanks, Wolf. We'll see you in a few hours hosting that special post-speech report, the special report at 11 p.m. Eastern, a full hour.
Thank you, Bernie.
Welcome, Judy.
All right, and after the break coming up, legal analyst Greta Van Susteren takes a long, hard look at yesterday's ruling by the highest court in the land.
extra cash for the holidays? Don't charge it on your credit cards. Get a second mortgage with no closing costs from ditech.com. With a second mortgage, you can consolidate all your existing high-interest debts, get the cash you need for the holidays, and end up with one lower monthly payment. A second mortgage with no closing costs is smart money from ditech.com. Log on now for fast online approval or call us at 1-800-71-FIX.
There was a time you only met your customer face-to-face. Not anymore. Blue Martini software provides the information to make the sale wherever you meet. On your website, at your call center, on a wireless device, and other places you've never imagined, allowing you to be everywhere at once. Everywhere is good.
It's seeking out companies with accelerating earnings, for we believe they have the brightest futures. It's hand-selecting the best of those companies, one by one. It's trusting in a process that can deliver solid, long-term results. The American Century Ultra Fund. It's what we call American Potential. American Century Investments. Contact us or your investment professional.
Join Bill Press and Tucker Carlson in the Spin Room by phone, chat room, or email. Tonight at a special time, midnight Eastern on CNN.
If television was like the internet, you'd probably never watch it. But what if the internet could be more like TV? It is. With At Home, the internet is always on.
You're always connected. You're always on. You never have to dial up. You'll never get a busy signal with At Home.
There's no way I would ever go back to a dial-up service.
Call today to join more than 1 million subscribers and get the most complete internet service available for your home. Call now to order.
It's Sit and Sleep's gigantic year-end clearance sale. Buy now and ho the payments with no deposit, no interest, and no payments till 2002. Save up to 40% off Simmons, Sealy, Serta, Spring Air, Stearns & Foster, Chatham & Wells, and Miralax mattresses, plus get free local delivery. And ho the payments till 2002. Call 800-675-3536. Sit and Sleep will beat anyone's advertised price, or your mattress is free.
Burden of Proof, weekdays 12:30 Eastern on CNN.
The last few weeks have been exhausting, I think, for the entire court. But in a lot of ways, it shows the strength of our system of government.
Comments today from Justice Clarence Thomas, who, with the other justices of the Supreme Court, 22 and a half hours ago, Greta Van Susteren handed down a decision that brought this presidential election some finality. We now know who the president's going to be, and it's directly related to what the justices did. Greta Van Susteren, a legal analyst, joining us now. Why couldn't this have been a simpler decision? Why did it have to have so many dissents, so many different pieces to it?
Well, primarily because there are 9 people making the decision, and this is such a volatile issue, and 2 people looking at a particular issue may have a different view. I mean, take the simple issue of the hand counts, which is were the hand counts constitutional or not. And one of the big things that bothered the majority is that there were differing standards from county to county to county. But Justice Stevens said, well, wait a second, no, there was one simple standard. That's the voter's intent set by the legislature in Florida. Both views are frankly defensible. The problem is more people thought that it was unconstitutional than thought it was constitutional. So when you have lots of decision makers, you're going to have this problem.
Greta, why did the dissents in this opinion from 4 justices seem so much more strongly felt than did the majority opinion, or what we could see of it?
Because of the passion. This is democracy. This is voting. You know, so many people marched in my lifetime for the right to vote. Some of these justices have been very passionate about the right to vote. Justice Stevens thought that the majority was disenfranchising voters, people's right to speak, the right to choose, which makes America different than many other countries. Justice Ginsburg was concerned that we were stripping the states of their rights, that the states get to make the decisions. I mean, these are important issues, and they knew that America was watching. They knew so much because they actually, for the first time, stepped out of what they usually do and let us have audio tapes. They were well aware that America was watching, how important it is to each one of us.
Was it Justice Felix Frankfurter who wrote about beware of getting into a political thicket? And yet that's precisely what the justices have done with this ruling. Is this setting an important precedent for the court to have done this?
Well, certainly, I mean, they are oftentimes called to deal with unpopular matters such as this, where there's huge disagreement. I mean, it certainly was unprecedented that we got the audio tapes. It was not unprecedented that they got involved with this case. Look, there's going to be a lot of criticism that this is a political decision. But remember, each member of the court was appointed by a politician, but when he or she dons the robes, you're supposed to abandon that.
Greta, over your shoulder, we're seeing pictures of the motorcade with Vice President Al Gore arriving at the Eisenhower Old Executive Office Building here in Washington, D.C., just a matter of a couple of miles from the Vice President's residence. Sounds like there are some supporters, maybe government employees out there who are maybe work for the Vice President, cheering as his motorcade pulls into that building, which sits immediately adjacent to the White House. This also happens to be the building where the Vice President has his office. He has sort of a token office in the White House where he presumably spends time, but his main work, we're told, is done. And that's where most of his staff has an office, in the old executive office building.
Can I add one other thing why there's so much passion? Remember, this is a virtual tie. The American people are divided. So it doesn't seem so unusual that the United States Supreme Court would have a virtual tie. But fortunately, we have an uneven number of justices so that at least someone usually wins. It's usually 5-4. We don't often have 3-3-3, but at least that's one of the points of every 9 people so that we can break the tie.
One other thing, Greta, you were talking about this just before we went on the air. What's the significance of the body of this opinion being so-called per curiam, meaning there are no names on it?
You know, that actually sort of distresses me. You know, the body of the opinion is per curiam. The justices didn't sign on and say, me too, I'm for it. We know that it represents the court. And I actually think it's sort of extraordinary that these civil servants, that's what they are, and who make such an important decision sort of don't step up to the plate and say, I'm deciding this. When you look at the opinion, you have the per curiam, which is the decision of the court. You then have what are called concurring opinions and dissents. And 2 justices' names don't appear there at all. Justices O'Connor and Justice Kennedy. And if you remember, those are the 2.
They were the ones who were the swing.
They were the swing. Now, some people say their fingerprints are all over this decision. I don't see them. I want to see their names. I want to see who voted, how, when, and where. And actually, that surprises me that the court seems to have sort of, I use the term hidden. I think a lot of people disagree with me, but I think step up to the plate and be accounted for in such an important decision. Get rid of that per curiam. Sign on.
All right. Greta Van Susteren, thanks very much. We appreciate it. We'll see you a little later. Bernie.
And still ahead on this special edition of The World Today, questioning the legitimacy of this election. Some Florida voters say they were disenfranchised, and that made the difference. What they plan to do about it, next.
Open up our doors, peek around the corners at all the great stores. The ones you look for, names you know, a few to discover. You want selection? We got that covered. Grab a friend, bring the family, bring yourself and see all that shopping can be. Shopping with Simon. Simon is waiting for you.
Mall, centers, and shopping from Simon. Simply the best shopping there is.
Can buyers and sellers find pricing on millions of products anywhere in the world? An impossible feat? Not at all. Become a member today at pricesaroundtheworld.com and see how we make it possible. Does the world know your price?
Jewelry, leather, crystal, cashmere. Shop the world's finest brands for the holidays. LuxuryFinder.com.
Dudley, get the paper.
A clean, crisp newspaper delivered to your printer automatically.
That's my final offer. That's my final offer. That's my final offer.
Mr. Tyler, we're right here.
Want banks to compete over you? At LendingTree, fill out one simple form and get up to 4 offers.
Thank you, Mr. Taylor.
Mr. Tyler. When banks compete, you win at LendingTree.com.
Your nest egg. You've managed it well. But what happens after you retire? T. Rowe Price's unique retirement income manager will help you plan wisely. No matter how the market turns. So when you tap into your savings, you'll know you've planned well for the future. T. Rowe Price Retirement Income Manager, planning to last a lifetime.
I believe that there should be a concession speech. As difficult as it is, I believe that George W. Bush at this point is the winner and Al Gore is the loser. Now, you know, that's difficult for some to accept, but that's the fact.
No matter what Al Gore says this night, there won't be those who do not rally around the new president. Those who say the events of the past 5 weeks put the legitimacy of a Bush administration in question. Among them, many African-American voters in Florida who say they were denied their legal right to vote. CNN's Bill Delaney has more.
On the march in Tallahassee, Florida, and promising more to come all over the country, voters.
We want justice! We want justice!
Led by Reverend Jesse Jackson, minorities, union members. Who say George Bush will be president because they weren't counted.
There should be a recount because America can do better.
It's going to scare the African-American vote a lot because we see that justice was not due to all and justice was not given to all. They would not come out and vote.
No peace! No justice! No peace!
Tens of thousands of African-American votes, protesters said, were not counted in Florida alone because machines didn't work or because registered voters' names weren't on official lists at polling places. Jackson said the loser won.
Driving while I'm black and now voting while I'm black. The election was essentially taken and stolen. You must get your votes in the public booth, not the private chambers of judges who are your political allies.
Jackson called for a continuing series now of nonviolent protests against what he called an illegitimate election.
Anger over the vote is not limited to Florida. In other places, too, there's a lingering sense an historic turnout for minorities has led to an historic injustice.
In Newark, New Jersey, with the 19th largest African-American population in the country, a sense of history, that the long struggle to enfranchise blacks had come to this.
A lot of people laid their life down just for this right, the right to vote, the right to have a county. For them not to go into those counties and make sure that each vote was counted is outrageous. And the rest of the world was looking at this.
As George W. Bush begins his presidency, African Americans will be watching and listening with particular intensity. Many say if they'd been heard on Election Day, he wouldn't be there at all. Bill Delaney, CNN, Tallahassee, Florida.
And CNN senior political analyst Bill Schneider now with some elaboration.
Well, Bernie, the Bush campaign was simply shocked to discover on election night that they were carrying less than 10% of the African-American vote nationwide. That is worse than Bush's father did in 1988 or 1992. It is worse than Bob Dole did among African-Americans in 1996. In fact, George W. Bush, the governor of Texas, got only 5% of the African-American vote in Texas. Why did Bush do so poorly among African Americans after he made a display of his outreach to them and that he wasn't a traditional kind of a Republican who had problems with African American voters? I think the answer is not so much with Bush, but with Bill Clinton, who was a hero to African American voters. They identified very closely with him in his persecutions, and Gore was Clinton's man. All of that was before the contest phase, which came about after the election. What happened then in the last 5 weeks is that somehow this turned into a civil rights issue. That's very mysterious to a lot of Americans who can't understand what this had to do with race or civil rights. But there are allegations that voting machines in minority districts in Florida were not good quality machines, and they kept a lot of blacks from voting properly. And also, Gore staked his campaign on the claim, every vote must count. That claim has a lot of resonance among African American voters. They struggled for 200 years for the right to vote. And when Gore defined his campaign as about the right to vote and to count every vote, that resonated deeply among black Americans. Bernie?
Thank you. Bill Schneider.
Well, taking a look now at some other news, the bomb-damaged USS Cole returned for repairs today to the Mississippi shipyard where it was built. A shroud covered the gaping hole in its side as it arrived atop a transport ship. The Cole was damaged in an October 12th suicide bombing in a Yemen port. It killed 17 sailors. In the stock markets, today's news about the presidential election appeared to boost blue chips moderately. At the closing bell, the Dow Industrials finished up 26 points at 10,794. On the NASDAQ, profit warnings and investment downgrades sent the composite index sliding 109 points to 2822. And to learn more about last night's United States Supreme Court decision and to talk with others about it in our chat room, we invite you to visit our website at CNN.com. Bernie?
Moneyline Update is brought to you by Fidelity. All the expertise, service, and technology to help you see yourself succeeding.
Do you remember my client, Mr. Foley?
Yeah, he wanted to retire and go into teaching.
Asia Solodusky.
Pre-retire. He had a pretty substantial portfolio.
This was my first day of school.
So we worked together to restructure with the goal of providing income so he could become a teacher.
I'm loving this. I really am. I'm going to make you
Not bad, huh?
like this class, and you.
To invest, call, click, or visit Fidelity.
Bush, keep fighting and get the presidency. He belongs there.
And just ahead, those all-important speeches tonight from Al Gore and George W. Bush. Two experts offer their suggestions when this CNN special report returns.
No two eyes see the same world. No two businesses are identical. And now, one company creates internet solutions unique to you.
Fujitsu. The possibilities are infinite.
Now this is the fear snake, the most venomous snake in the world. One bite from him and it's all over. No! Ah! No worries, mate. Luckily, we've had the anti-venom sent from America via FedEx. In my line of work, if you're not absolutely sure, you're absolutely dead. Oh, crikey. It appears we've used a different courier who hasn't arrived yet. It's okay because...
Need a new look? Get the mouse. It doesn't just sand. It also scrubs, removes, and polishes. It's a whole new breed of tool. The mouse, built by Black & Decker.
Is it their impeccable timing that counts?
Their know-how? How far they go?
Or just the freedom to relax. Yes, exactly. Lufthansa, there's no better way to fly.
As you can see, the terms are good. The rate is low. There are no points.
But...
Yes?
Can't you come down a little on the interest?
It's a very good offer.
Okay, then.
Great.
Thanks anyway. Next!
Want banks to compete over you? Come to LendingTree.com. Fill out one form and get up to 4 offers within hours. When banks compete, you win at LendingTree.com.
Bolla Wines of Italy. Open up.
It's not just the most important speech to Al Gore, it's probably one of the most important speeches in the history of our country, because what he says tonight is going to set the tone probably for the next 4 years.
Al Gore will address the nation tonight at 9 p.m. Eastern, to be followed at 10 p.m. by George W. Bush. These are extremely important speeches for both men, not just in content, but in delivery as well. And joining us tonight in Washington to talk about that, former Clinton White House spokesman Joseph Lockhart. And in San Francisco, Kenneth Kachigian. He's a former speechwriter for Presidents Nixon and Reagan. Gentlemen, let's talk first about Al Gore. Joe Lockhart, you know the man pretty well. How tough is this for him tonight?
Well, this is very tough. I mean, I think he's worked most of his adult life toward the point to become president, and to have it sort of slip away in the way it has is very, very difficult. But I think overriding that is this is also an institution, the government, that he's been involved in all of his adult life and that he grew up in. And I think he understands the stakes. I think he doesn't need to be told that he has a role in moving the government forward and legitimizing this election, and I think that's what he'll do.
Ken Kachigian, from the perspective of the other side, the other team, what does Al Gore need to do tonight?
Well, oddly enough, even though it's a very hard speech to give, I think this is an easy speech to write. The American people are very generous, and I think that while they were tough on him during the contesting period, they'll be sympathetic with him right now. So he needs to understand that he should not give the stump speech, and he should not be pious about anything, but I think he should look forward. More than anything else, he should look forward. There's two audiences out there, the audience for today, the supporters who feel like this is all over with and are discouraged, but it's the audience of tomorrow, and he needs to think about that if he has a political future. I think he ought to show some humor as well. Abraham Lincoln told a great story about losing an election, and he said, reprised the story of the boy in Kentucky running to see his sweetheart who stubbed his toe, and he said, I'm too old to cry, but it hurts too much to laugh.
But Joe Lockhart, whether he shows humor and is gracious and all the rest of it, he's run a very tough campaign. Can he just drop all the points he was making during the campaign and mention none of that tonight? No,
I think that would be a disservice, both to himself and to all the people who supported him. Campaigns and politics are supposed to be about ideas and at times conflicting ideas. And so much of that has gotten lost both in this campaign and especially in this last 35, 36 days. So I think he has to pay some tribute to the people who've supported him and talk about the ideas and how the battle of ideas in politics goes on. There'll be differences between the parties, but I think the overriding point he'll have to make is that the country comes first and that this is a legitimate result.
And Ken Kachigian, if he does that, if he harks back to the ideas that he talked about during the campaign, is that going to be like rubbing salt in a wound?
No, I don't think so. I don't disagree with Joe. When I say don't give the stump speech, I think he can talk in very high-toned sense about the principles he adhered to, and I don't think he should say that he wanted the honor of the job as well, but also that there were important principles he stood for, and that I think, frankly, while he wouldn't be taking advice from me necessarily, I think he ought to set the stage. If he has a political future, he can do it now by looking forward and being very generous and gracious about the day while being the warrior that he was.
Greenfield in New York, guys. So this may be heresy from one ex-political operative to two ex or current political operatives, but you know, Richard Nixon gave the worst, most graceless concession speech in history probably in 1962. You won't have Nixon to kick around anymore. 6 years later, he was president. Bill Clinton gave a dreadful nominating speech for Michael Dukakis. 4 years later, he was president. And his Monica Lewinsky speech was a failure, and he rode that out. Could we be putting too much emphasis in this post-oratorical age on how important a speech is to Al Gore?
Well, I think it may not be that important. I think the Bush speech, as far as where the country goes, is more important tonight. But I think for Gore, this is a very personally important moment, and he will have the stage, the country looking to him tonight. And I think he should do, I mean, he's gotten a lot of unsolicited advice today. I think he's probably rightfully ignored all of it. And I don't see this as sort of a make or break.
I see it as an opportunity for him to talk about why he did what he did, and you know, the intellectual underpinnings of all of that.
Ken Kachigian?
Well, you know, while I agree with the notion about the American public overlooking Richard Nixon's last press conference, the fact is they still remember it and they still refer to it. I think Al Gore has the opportunity tonight to give a speech that people will just remember in only positive ways. And we do have short memories in this country, but we do have memories.
All right, Ken Kachigian, Joe Lockhart, and we'll be talking to you all in the next hour after we hear from the Vice President to look ahead to the speech from George W. Bush. We're going to take a break in our special coverage as we are just minutes away, 5 minutes away from the address by Al Gore. We'll be right back.
Closed captioning provided by USSearch.com. Find out if anyone you know has a criminal record. One of over 50 information products now available at USSearch.com.
Join Bill Press and Tucker Carlson in the Spin Room by phone, chat room, or email. Tonight at a special time, midnight Eastern on CNN.
Enjoy Cox Digital Cable and Disneyland this holiday season. Right now, Disneyland Park, the merriest place on earth, is transformed into a holiday fantasy world. With zillions of lights and Believe in Holiday Magic, a new fireworks spectacular celebrating the beauty and joy of holiday memories. With the grandest of all finales, snow every night. Treat yourself to Cox Digital Cable this holiday season. Call today for a free upgrade and be sure to ask about passports to Disneyland.
You know, The Doctor, your Volvo specialist, is the largest independent Volvo repair center in Orange County. We provide Volvo service the old-fashioned way. We do it right the first time. For all you new Volvo owners, you can maintain your Volvo's warranty with our service department. AAA approved and smog check certified. We also offer high-quality, reconditioned, guaranteed Volvos for sale. For confident, friendly, and one-day service, come to The Doctor, your one-stop Volvo shop, located in Fountain Valley at Euclid and the 405 freeway.
Jim doesn't realize it, but that persistent pressure might be a heart attack. Getting expert help is the best thing Jim can do. Thankfully, he's near the Chest Pain Center at Mission Hospital. Here, on-site heart specialists can quickly and accurately evaluate his chest pain. If it is a heart attack, Jim will have immediate access to the widely respected Mission Regional Heart Center. And if it's not, Jim's right back in the game. The Chest Pain Center at Mission Hospital Regional Medical Center.
Diamonds have been the ultimate symbol of love, romance, desire, passion. A partner for life, like a fingerprint. An ID number is laser inscribed into your diamond, making it unique and distinguishable. Feel confident in your purchase. Insist on the IGI certificate, an independent, objective analysis of quality. Let experts give you peace of mind. Remember, a commitment like a diamond's quality is forever.
Get to the bottom of the day's issues with Greta Van Susteren, weeknights at 8:30 on CNN.
I believe that we will come together and rally behind Bush. I think that shadow of doubt will always be cast over that, but we'll come together.
At the top of the hour, Vice President Al Gore will step before the cameras to deliver an address to the nation. That will be followed by CNN's Larry King Live. He joins us now. Larry.
Thanks, Bernie and Judy. We're going to have two editions of Larry King Live tonight. Following the Gore speech, we'll be talking with former Senator Sam Nunn and Bob Strauss, the former DNC chairman, and Senators Hatch and Breaux and McCain and Lawrence Tribe, Bob Woodward and Norm Ornstein. And then following the speech by Governor George W. Bush, we'll have Bob Dole and Jesse Jackson and Barry Richard and Bob Woodward and our own Jeff Greenfield. Lots of wrap-ups coming. So we'll have two editions of Larry King Live. The first one follows the address ahead. Bernie, Judy.
Thank you, Larry. And as we await the address, CNN has learned that Vice President Al Gore has telephoned Texas Governor George W. Bush to say that he is withdrawing from this race.
That phone call, Bernie, the second time in 36 days that a call of concession, if you want to call it that. Of course, we don't know what words the Vice President used. He made the call early in the morning hours of November the 8th. But then an hour and so later, he called back and said, I'm going to have to take that back because the votes coming in from the state of Florida are very close, and I'm not ready to concede after all. So here we are 36 days later.
Bill, Jeff, in a word, what will you be listening for tonight?
I want to see if George Bush... Oh, sorry, go ahead.
Tone, you say, Jeff?
I'm going to be listening for tone. I'm going to be listening for whether or not the Al Gore, who we've heard about so often from his friends and colleagues, who can be funny and eloquent in private, so often seems less than that in public. And I'm going to see whether or not he can acknowledge, as Ken Kachikian said, a certain sense of hurt. I mean, a man who at 7:50 on the night of November 7th thought he'd won the White House, who then at 2:18 in the morning was told he had lost it, then 3 different times his candidacy seemed to be revived by votes in Florida, perhaps, by the Florida Supreme Court, and then through 36 days of this to be told, guess what, it was what you thought happened at 2 o'clock in the morning on November 8th is still true, you have lost. Whether he can at least acknowledge to us that there is some personal pain in all this.
Well, you know, we asked people around the country what they thought of the Supreme Court's decision, and what we found was that a majority of Americans, but only a bare majority, agrees with what the Supreme Court did, and that follows the vote very closely. Did this make people lose confidence in the United States Supreme Court? 2/3 of Americans said no, it did not. But in the speech we're just about to hear, the question is, should Al Gore concede that he lost the election, or should he withdraw from the race without conceding? By 2-1, Americans say he should concede that he lost the election. But among Democrats, there's a very close division on that issue.
This is the ceremonial office, and Judy, we understand that Tipper Gore and their children are there, as well as the Liebermans and their daughter.
24 years after entering public office, Al Gore Jr. prepares to leave public office. The Vice President of the United States.
Good evening. Just moments ago, I spoke with George W. Bush and congratulated him on becoming the 43rd President of the United States. And I promised him that I wouldn't call him back this time. I offered to meet with him as soon as possible so that we can start to heal the divisions of the campaign and the contest through which we've just passed. Almost a century and a half ago, Senator Stephen Douglas told Abraham Lincoln, who had just defeated him for the presidency, partisan feeling must yield to patriotism. I'm with you, Mr. President, and God bless you. Well, in that same spirit, I say to President-elect Bush that what remains of partisan rancor must now be put aside, and may God bless his stewardship of this country. Neither he nor I anticipated this long and difficult road. Certainly neither of us wanted it to happen. Yet it came, and now it has ended, resolved as it must be resolved through the honored institutions of our democracy. Over the library of one of our great law schools is inscribed the motto, not under man, but under God and law. That's the ruling principle of American freedom, the source of our democratic liberties. I've tried to make it my guide throughout this contest, as it has guided America's deliberations of all the complex issues of the past 5 weeks. Now the U.S. Supreme Court has spoken. Let there be no doubt. While I strongly disagree with the court's decision, I accept it. I accept the finality of this outcome, which will be ratified next Monday in the Electoral College. And tonight, for the sake of our unity as a people and the strength of our democracy, I offer my concession. I also accept my responsibility, which I will discharge unconditionally, to honor the new president-elect and do everything possible to help him bring Americans together in fulfillment of the great vision that our Declaration of Independence defines and that our Constitution affirms and defends. Let me say how grateful I am to all those who supported me and supported the cause for which we have fought. Tipper and I feel a deep gratitude to Joe and Hadassah Lieberman, who brought passion and high purpose to our partnership and opened new doors, not just for our campaign, but for our country. This has been an extraordinary election. But in one of God's unforeseen paths, this belatedly broken impasse can point us all to a new common ground. for its very closeness can serve to remind us that we are one people with a shared history and a shared destiny. Indeed, that history gives us many examples of contests as hotly debated, as fiercely fought, with their own challenges to the popular will. Other disputes have dragged on for weeks before reaching resolution, and each time both the victor and the vanquished have accepted the result peacefully and in a spirit of reconciliation. So let it be with us. I know that many of my supporters are disappointed. I am too. But our disappointment must be overcome by our love of country. And I say to our fellow members of the world community, let no one see this contest as a sign of American weakness. The strength of American democracy is shown most clearly through the difficulties it can overcome. Some have expressed concern that the unusual nature of this election might hamper the next president in the conduct of his office. I do not believe it need be so. President-elect Bush inherits a nation whose citizens will be ready to assist him in the conduct of his large responsibilities. I personally will be at his disposal, and I call on all Americans. I particularly urge all who stood with us to unite behind our next president. This is America. Just as we fight hard when the stakes are high, we close ranks and come together when the contest is done. And while there will be time enough to debate our continuing differences, now is the time to recognize that that which unites us is greater than that which divides us. While we yet hold and do not yield our opposing beliefs, there is a higher duty than the one we owe to political party. This is America, and we put country before party. We will stand together behind our new president. As for what I'll do next, I don't know the answer to that one yet. Like many of you, I'm looking forward to spending the holidays with family and old friends. I know I'll spend time in Tennessee and mend some fences, literally and figuratively. Some have asked whether I have any regrets, and I do have one regret, that I didn't get the chance to stay and fight for the American people over the next 4 years, especially for those who need burdens lifted and barriers removed, especially for those who feel their voices have not been heard. I heard you, and I will not forget. I've seen America in this campaign, and I like what I see. It's worth fighting for, and that's a fight I'll never stop. As for the battle that ends tonight, I do believe, as my father once said, that no matter how hard the loss, defeat may serve as well as victory to shake the soul and let the glory out. So for me, this campaign ends as it began, with the love of Tipper and our family, with faith in God and in the country I have been so proud to serve, from Vietnam to the vice presidency, and with gratitude to our truly tireless campaign staff and volunteers, including all those who worked so hard in Florida for the last 36 days. Now the political struggle is over, and we turn again to the unending struggle for the common good of all Americans and for those multitudes around the world who look to us for leadership in the cause of freedom. In the words of our great hymn, America, America, let us crown thy good with brotherhood from sea to shining sea. And now, my friends, in a phrase I once addressed to others, it's time for me to go. Thank you, and good night, and God bless America.
With brevity, Vice President Al Gore describing how he feels. He said, now the United States Supreme Court has spoken. Let there be no doubt. While I strongly disagree with the court's decision, I accept it. Prior to beginning his remarks, he said he called Governor Bush and congratulated him, and he used the C word. I offer my concession. And the Vice President promised to be personally at the disposal, at the new President-elect's disposal, and he called on all Americans to unite behind our next president.
Bernie, he, as you say, it was a concession. He did acknowledge disappointment, a little bit of humor, but Jeff Greenfield, there also was a word to those people he said he's sorry he won't get a chance to fight for. He said those especially who feel their voices have not heard. He said, I heard you, and I will not forget.
Yes, I think there are a couple of interesting notes in that. One is that there were, on 3 occasions, there were very graceful bits of humor appropriate to the occasion. When he said, I called Governor Bush and I promised him I wouldn't call him back this time, a reference to that retracted concession phone call. When he said, I'm going to go back to Tennessee and mend some fences, literally and figuratively, that was a nice way of referring to what John King told us earlier, a real sense of regret that he failed to carry his own state, which would have given him the presidency. And at the very end, instead of reaching for very high-flown rhetoric, he quoted a line of his from his 1992 vice presidential acceptance speech aimed at Republicans. It's time for them to go, and he said, it's time for me to go. And I thought that, you know, there was not a trace of bitterness in this speech. It was, I think, actually a more low-key and personal rhetoric than we heard from him a lot during the campaign. A very nice set of touches here.
John King, one of the touches I heard, majesty.
A bit of majesty, Bernie. This vice president, not known for his rhetorical skills. Here, a very delicate balance to bestow legitimacy on a man he was first to call president-elect in an official capacity, George W. Bush, but also a way for the vice president, as Jeff mentioned, to jokingly say, it's time for me to go, but to also leave the suggestion that perhaps he might be back in some capacity. Will he run again? He said he doesn't know. He wants to take a vacation with his family. But what did he say? There will be time enough to debate our continuing differences. They're not all settled, even as he hands off and promises to cooperate with Governor Bush. And he said he will remember those he regrets that he won't be here to fight for, especially for those who need burdens lifted and barriers removed, especially for those who feel their voices have not been heard. Translation, perhaps their votes not counted. Bernie?
Thank you.
And Candy Crowley, listening to all this in Austin, Texas, where Governor Bush is, we heard Al Gore say in that same spirit, he said, I say to President-elect Bush that what remains of partisan rancor must now be put aside.
It is hard to imagine that the Bush campaign at this point, when certainly feelings are still raw, this must have been an extremely difficult speech for the vice president. Hard to imagine that Bush campaign could have expected much more. It was a generous speech, and it was really a very clear speech. There was a discussion about whether he would use the word concession, about, you know, perhaps he would at the last minute say something that left you wondering. There was no wondering about this. He called on his supporters to put aside the partisan rancor. Just a little bit of news in terms of that phone call. I'm told it lasted less than 2 minutes. From the Bush team point of view, the governor thought it was a very gracious phone call from Al Gore. The two will meet on Tuesday in Washington, I am told, and agreed to that. The governor said he was very glad for that hospitality. So the two face-to-face on Tuesday. Judy?
All right, Candy Crowley in Austin. Bill Schneider's here with us in the Washington studio. What did you hear, Bill?
Well, I heard an irony when he said, he jokingly at the end, it's time for me to go. When he made that speech as vice president nominee at the Democratic Convention in 1992, the people whom he said about it's time for them to go was President Bush, George Bush's father. So in a way, events have come full circle. I also heard him say the word that he used throughout this campaign over and over again, fighting. He always called himself a fighter. He said, I didn't get the chance to stay and fight. This is worth fighting for, and it's a fight I'll never stop. He fought for this. He fought throughout the campaign. He fought after the campaign, and the message is clear. He intends to keep on fighting. He went down fighting.
As we've said, Al Gore is the 4th presidential candidate to have won the popular vote but lost the election. Out of more than 100 million votes cast on election day, Al Gore won 50,158,094. George W. Bush won 49,820,518. Gore led the Texas governor by more than 300,000 votes.
George W. Bush is the first person to win the presidency despite losing both New York and California, the two states with the largest number of electoral votes. But it was Florida that became the focal point of this election. After a flurry of lawsuits, recounts, and Florida's legislature stepping in, it was Bush who finally grabbed that state's 25 electoral votes. So the final tally, Bush 271 to Al Gore 267. And now we turn our coverage of this historic evening over to CNN's Larry King. Larry.
Judy, thank you, Bernie. We'll be with you for 2 segments. There'll be 2 editions of Larry King Live tonight. This one, and then following the President-elect speech, President-elect George W. Bush of Texas will follow that with another Larry King Live. And we started off with 2 two major names on the American scene. They're both in our Washington, D.C. bureau. They are Sam Nunn, the former senator from Georgia, who served as chairman of the Senate Armed Services Committee, and Robert Strauss, always good to see Bob, the former chairman of the DNC. He was the Middle East peace negotiator. He served the Bush administration as well as ambassador to the Soviet Union and later to Russia in 91 and 92. Senator Nunn, what did you make of Gore's speech?
I think anyone who criticizes that speech must have a measurement of perfection, because I thought it was a very fine speech. I thought he did everything that could have been expected of him. I thought he did it with style and with humor, and I thought that he, most importantly, did everything that he could do in this setting to convey legitimacy on President-elect George W. Bush.
Ambassador Strauss, your thoughts?
I thought he was not just good, I thought he was very good. I share Sam's view. I thought he was gracious. I thought he sounded real. I thought he sounded, set the tone that America wanted to have him set. He spoke of the future, not the past. I thought he did real good.
Senator Nunn, of that kind of attitude, there'll always be some who say, boy, he should have showed that more during the campaign. Do you agree, or is that unfair?
Well, I'm sure that it's difficult in a campaign. You're in a different setting, you're in a different set of circumstances. It would have certainly gone down as a great kind of a message, but only in these circumstances. I think it would have been hard to duplicate in a campaign. I think that Al Gore, when people know him personally, he does have much more of a sense of humor than is displayed sometimes, but frankly, I think he rose to the occasion tonight when it had to be the most difficult speech he's had to make, barring none in the campaign. It's tough when you go through what he's gone through, and his family and what they've gone through, and his key supporters, so he is a fighter, and this was a time he rose to the occasion.
And Ambassador Strauss, do you think those who followed him in this long trek will come aboard and end the kind of anger we've seen the past 5 weeks?
I think we have a tendency, Larry, in this country, a great tendency to overreact and overstate everything. And while this country's been divided, and while certainly we were split 50-50 in this election, I think it's a bit overdrawn how difficult it is to put it back together. And I think that I think it will come together, and I think it'll come together towards the center. I think that the president-elect has his strengths and his weaknesses, and one of his strengths has been his ability to work with people and reach out and attract people. I suspect he will start doing that tonight when he goes on tonight, and he'll continue, and he'll do it well.
Speaking of attracting people, Senator Nunn, it's been rumored that you are one of those Democrats that President-elect Bush will be very interested in, possibly for Secretary of Defense. Are you interested?
I haven't had any conversation with President-elect Bush about that subject, and I have made it clear that I want to stay in private life. I do not have interest in going back into government, but I've also made it clear that I would join with others like Bob Strauss and Howard Baker and Jack Danforth and Warren Rudman and David Boren and a lot of other people I could name who've been in government to do everything we can to help the President-elect from my private sector position. And that means advice. It means doing all I can to get the Democratic leadership and the Democratic Party to understand and make clear to the American people explicitly that they believe this president deserves our support, deserves our prayers. He is our president, and we can have only one leader, and I think we all, Democrats and Republicans, need to put citizenship ahead of partisanship.
Ambassador Strauss, do you expect to see Democrats in this cabinet?
Yes, I think there will be Democrats in this cabinet. I know that the Bush people intend to reach out and try to attract Democrats. And I hope they're able to do that, to get people who are articulate and who have strong feelings and who can work with others and get that kind of person in. I think, as for me, you didn't ask me the same question you did Sam, but when I mature a bit and get a little age on me, I might consider going back into government. But for the time being, I'm going to stay out.
What we're viewing now, as Ambassador Strauss was speaking, is Al Gore leaving the Eisenhower Executive Building and about to leave and heading back to the Vice President's home. We're talking with Sam Nunn and Robert Strauss in edition number 1 of Larry King Live. There will be another one following the Bush speech at 10 o'clock. Senator Nunn, what's the future for Al Gore?
I believe that with the speech he made tonight, if he has ambitions to get back into politics at some point in the future and run another race, he'll have a lot of support. No one can predict the future, and I certainly would not do that tonight. And but he is clearly a fighter, and he clearly has the public service and public policy in the depths of his soul, and his family does also. So if he wants to run again, I think he'll have a lot of support out there.
And how, you said, Ambassador Strauss, you expect healing. Do you expect that largely to be up to the president-elect? Is he the one that has to bring it together?
I think he has to take the lead in it, and just as, and I expect him to do so, and I think the people will follow. He may have trouble with the extremes in his own party as well as the extremes in our party, but the public generally is tired of confrontation, and they're ready for a reconciliation and for people to work together. And I suspect that the president-elect will, as he reaches out, will find Democrats and Republicans, the moderates in that group, prepared to rally around and work with him. Interestingly, there have been about 30 members of the U.S. Senate, I think about 2/3 Democrat and 1/3 Republican, who've been meeting and working together and talking, discussing issues in common, just finding out just how much they have in common and how little they have apart on many of these issues. That's a constructive, good start.
Will moderation, Senator Nunn, be the rule of the day, you think?
I think so, and I think what Bob has said is exactly right. I believe that the president-elect has the ability and the inclination to work from the center. If he had had a runaway victory, he probably couldn't have done that. His own party would have demanded a degree of philosophical rigidity that would not have allowed him flexibility. I think he's got more flexibility in some paradoxical way now because he's got to govern from the center. Everybody that looks at the reality of the 50-50 Senate and the closed House realizes that, and he can move from the center to the outward rather than from the fringes toward the center. I think that's enormously important and gives him a chance to do what he may very well have an inclination to do anyway.
And Ambassador Strauss, as we see Vice President Gore leave after making his speech tonight to the plaudits of his followers, we asked Senator Nunn, what do you think of Al Gore's future?
Well, I think Al Gore has, interestingly, while he sometimes has fallen short in his public appearances, he seems to have the ability to rise to the occasion when crisis comes, and I thought tonight was a key time for him. I thought he did more than rise to the occasion, and in doing so, I think the future is open to what he can do. It's hard to predict, but he certainly can't be written off, that's for sure, not after tonight.
What do you think is going to be the first issue on deck, Senator Nunn?
In terms of the new president's administration, I would think that education would be right up front. I think that's a subject that the president-elect is comfortable with. I think he's been a leader in that arena in his own state. I think he's put together bipartisan coalitions in his own state on that, and I think he will find a receptive audience given his dedication toward education. I also think he can tackle some of the tough issues. Strangely enough, you may be able to tackle tough issues that other people would have not dreamed of with a divided Senate if you can put together the kind of coalition that Bob Strauss has alluded to. Issues like Social Security reform and Medicare reform, I think those are important. I think you can put together a coalition on trade. I believe that you may have a better chance to do that. And most importantly, I also think you can begin to do as former Senator David Boren penned this week in the Washington Post, and that is put together a leadership council on both foreign policy and a separate one on economic policy with Democrats and Republicans. That's something that I have felt was in order for a long time on foreign policy, and now I think he has a clear chance of doing that.
Thank you very much. Thank you, Sam Nunn. Thank you, Bob Strauss. And as you see, the people applauding outside the Eisenhower Executive Office building in Washington, applauding Vice President Al Gore and Senator Joe Lieberman. They're both in that building. And we are expecting, and there you see him now, as Al Gore leaves. A lot of people out on a cold night in Washington to bid him good wishes. He spoke for about 7 minutes. And again, Governor Bush, the president-elect, will be speaking about 37 minutes from now. You'll see that. And we'll be back with another edition of Larry King Live. When we come back, Senator Orrin Hatch and Senator John Breaux, two powerful members of the United States Senate, Senator Hatch is the chair of the Judiciary Committee, a committee that Al Gore once sat on, will be our guest as Al Gore now leaves and heads back to the vice presidential residence. Said, we're not seeing the end of the political life here tonight. This is a very young man, and Ambassador Strauss says, with a unique ability to, in his career, bounce back. First most difficult task of his life was when his father, the late senator, spoke out against the war in Vietnam. Al Gore thought that it would be best if he would go to the service and go to that war to help his father. His father would subsequently lose that election. There's Tipper Gore right in front. Sometimes in defeat, people gain more popularity, and apparently that is happening to Al Gore tonight. And I think it'd be safe to say that that speech will be heralded tomorrow, even by his severest critics during this campaign, as a gracious, classy, at times funny, timely concession speech. Chanting something, I can't hear it. They're saying Gore in 4, I am told, meaning Al come back in 4 years to run again. He's in the car, waving goodbye, and as he waves goodbye, we'll take a break. And then come back with Senator Orrin Hatch of Utah, Senator John Breaux of Louisiana. This is Larry King Live, Part 1. Don't go away.
Larry King Live is brought to you by Citracal. Do what's right for your bones. Take Citracal.
It's about absorption, staying strong, and getting the most out of your calcium supplement. It's about the Citracal difference. In a recent study of leading brands of calcium, Citracal was better absorbed. So do what's right for your bones. Take Citracal.
This is all the information on your site. The content is up to you. Blue Martini software allows you to share any of it or all of it freely with resellers, brokers, partners, anyone who can use that information to sell your product. They're happy because their site is easier to take care of. You're happy because your message is everywhere.
Lots of people want lots of information some of the time, but not everyone. Some just want general news about yesterday. A few need business news about today. But energy professionals need energy news now, in real time. Introducing Williams, EnergyNewsLive.com, the only real-time energy news network. It's not news for everyone, just everyone in energy.
What's the word I'm thinking of?
Is it no?
No.
No.
Okie doke.
Whoa.
No.
Want banks to compete over you? At LendingTree, fill out one simple form and get up to 4 offers.
Thank you. Thanks for coming.
When banks compete, you win at LendingTree.com.
Beginning Monday, a dynamic new hour on CNN. At 8, Wolf Blitzer reports on the day's big stories on location, featuring the best of CNN's reporting, and Wolf going one-on-one with key newsmakers. At 8:30, get to the point with Greta Van Susteren as she takes on important issues in depth in her own feisty style to explain the problem and explore solutions in a way we can all understand. Wolf Blitzer and Greta Van Susteren, beginning Monday at 8 Eastern on CNN.
We're back, and we now welcome to Larry King Live Part 1, Senator Orrin Hatch of Utah, Senator John Breaux of Louisiana. Senator Hatch, a member of the opposition to the candidacy of Vice President Gore. What did you make of his speech?
I wish I could write a speech like that. It had humor, it had humility, it had, I think it had spirituality, and frankly, it was a very good speech. We've been very fortunate to have 4 really fine men running in this race for president. No matter who won, we were going to get good people. And 4 really fine wives and families. I just have to commend them all, and I commend Vice President Gore. I thought that was a very, very eloquent speech. It meant a lot to, I think, this country, and he called for all of us to unite behind President-elect Bush, and it was gracious. It was just about everything I think it should have been.
Senator Breaux, did it surprise you?
Larry, it did not surprise me. A concession speech is the hardest speech that a political candidate can ever give. A victory speech is a lot easier and it's a lot more fun to give. But a concession speech is about who you are. A concession speech is about your character. It's about what you're really made of. And I think tonight we saw an Al Gore who has devoted his life to public service, see that political life ending, at least for the time being. Yet he was eloquent. He was gracious. He was very helpful to this country, and I think he was particularly helpful to President-elect George Bush.
And do you think, Senator Hatch, all this talk of bipartisanship and this kind of mood can continue?
Well, I think it has to continue. The American people are tired of this rancor that's been existing in Washington. It's time really to change it, and I think people like John Breaux and myself, we can get together, and a whole raft of others who are looking forward to trying to do what's right for this country. I think we've got to do it. But let me tell you something, we can't let the fringe elements in either party dictate what goes on here. We've got to heal our land. I think that's what Vice President Gore was calling about. He talked about burdens lifted and barriers removed. I think George W. Bush has a reputation for lifting burdens and removing barriers, and I think he's going to do a great job as a Republican and as somebody who will work with both parties to do exactly that, and we're going to help him. I got to tell you, we're going to help him.
Senator Breaux, does President-elect Bush get a honeymoon?
Well, I think Al Gore has talked about the fact that it's time, Larry, to quit arguing about the past and now time to start talking about the future. And I think that in the Senate, even though it's 50-50, it's a rare opportunity as far as I'm concerned. We're going to work together whether we like to or not. I mean, bipartisanship is not going to be political theory. It's going to be a political necessity. We've already reinvigorated our centrist coalition in the Senate. Our first meeting had almost 30 members of the United States Senate, Republicans and Democrats, who sat in the same room, talked to each other, and made a commitment to work together for the good of this country. I think that's new, it's exciting, and I think it's very, very promising.
Why this sudden, Senator Hatch, turnaround from the partisanship of yesterday?
Well, I think we all know with a 50-50 basic split in the presidential race, 50-50 split in the Senate, almost a 50-50 split in the House, we've got to work together. We can't get anything done without working together. I was happy to see those 2 great Democrats, Sam Nunn and Ambassador Strauss. And I'm glad to hear that Ambassador Strauss is maturing so that maybe he can help us in this administration. I hope Sam can too. But we've got to work together. If we don't work together, we're not doing what's right for this country. And I think this is a great opportunity. This is not an impasse situation. This is an opportunity to make a difference in our country in ways that haven't been made up till now. And I'll tell you, I'm prepared to link arms with John Breaux and others and get this done.
Senator Breaux, would you be interested in serving in this administration?
Larry, I am very, very happy serving in the United States Senate. I mean, what a challenge to be in a legislative body that is literally tied with a 50-50 vote. That's where I think the action is going to be. I'm certainly willing to talk to President-elect Bush if he would want to do that. I mean, that would certainly be something I think anyone would owe it to a new president to speak with them. But I can tell you that I think the action and the excitement is going to be in the United States Senate. And I think what is different this time is that essentially we've had a tie election. I mean, the election for the presidency was almost a tie. The Senate, in fact, is tied. The House of Representatives is almost a tie. And the message from the American people is not a policy directive, but rather a message for us to get our own house together and to start working together for the good of this country.
Yeah. Senators Orrin Hatch and John Breaux, and by the way, they both will be back following the speech by President-elect Governor George W. Bush of Texas. That's coming up at the top of the hour when we have part 2 of Larry King Live. We'll take a break, and when we come back, Senator John McCain, who's had a battle or two this year, gives us his thoughts tonight. Don't go away.
Join Bill Press and Tucker Carlson in the Spin Room by phone, chat room, or email. Tonight at a special time, midnight Eastern on CNN.
Mercedes-Benz, designed to be the finest in the world, built with an uncommon attention to detail, and chosen by the most discriminating buyers. Mercedes-Benz of Laguna Niguel, also designed to be the finest in the world, also built with an uncommon attention to detail, and also chosen by the most discriminating buyers. Mercedes-Benz of Laguna Niguel. It's no wonder they call us the Mercedes-Benz of Mercedes-Benz Centers.
It's model year-end clearance time at Allen Oldsmobile. So we're offering special finance rates and generous factory rebates to lower your payments on every Oldsmobile in stock. Get super low payments on the sporty Alero, the luxurious Intrigue, the Bravada Sport Utility, and the Silhouette Minivan. Get a great deal and take advantage of all Allen Oldsmobile has to offer. Business workstations, children's playroom, and a comfortable reading room. Allen Oldsmobile in Laguna Niguel. Our family serving your family since 1947.
Get to the bottom of the day's issues with Greta Van Susteren, weeknights at 8:30 on CNN.
Your call will be answered by the next available operator. Please stand by.
Your service reps are overwhelmed with customer calls, faxes, and emails. Integrate the internet into your call center and go from providing customer support to creating customer delight. Discover all that's possible on the internet. Cisco Systems, empowering the internet generation.
Need extra cash for the holidays? Don't charge it on your credit cards. Get a second mortgage with no closing costs from Ditech.com. With a second mortgage, you can consolidate all your existing high-interest debts, get the cash you need for the holidays, and end up with one lower monthly payment. A second mortgage with no closing costs is smart money from Ditech.com. Log on now for fast online approval or call us at 1-800-71-FIXED.
Only Hilton Honors rewards guests with both hotel points and airline miles. And now, the Hilton Honors family has grown to include places like Hampton Inn and Homewood Suites by Hilton. Introducing the new Hilton Honors family. Over 2,000 hotels and resorts where you'll receive both points and miles for the very same stay. Come, discover just how rewarding and can be. Stay with us.
Welcome back to Larry King Live, and you now see President-elect George W. Bush. That's his limousine taking him to the House chamber of the Texas legislature in the distinguished, beautiful building. We were there recently in Austin, Texas. He will deliver his speech coming up in about 22 minutes from the House chamber. That's President-elect George W. Bush, who will address the nation shortly. And as we see this, let's check in with a former opponent of Governor Bush, Senator John McCain, Republican of Arizona, coming to us from Phoenix. I know throughout all of this, as you supported Governor Bush, you always told us how much you liked Vice President Gore. What did you think of him tonight?
I've never seen him better. You're right. He and I served together in the House together, and we've worked together for many years. I've never seen him look better, and his speech has struck exactly the right tone. And I think that this will set the stage for Governor Bush's speech, which I'm sure will be equally as magnanimous, and it'll put the country off on the right footing and on the right track.
Now we see President-elect Bush. We see, I think that's Lynn Cheney, the wife of Vice President-elect Dick Cheney, and of course Laura Bush. No, that's not, looks like Lynn Cheney, but it's not Lynn Cheney. But that's Laura Bush, the wife of President-elect George Bush. Senator McCain, do you share all this optimism that everyone is showing tonight about a coming together?
I do, but it's guarded. I think it's we're headed in the right direction, and I'm confident of Governor Bush's performance tonight will be equal to that of the Vice President's. But then we've got to sit down and we've got to settle on an agenda that we can agree on, and campaign finance reform has got to be the first one. It should be a bipartisan effort. We need to clean up this system, restore young Americans' confidence in government, and there's no better way than to do that. And then we need to set out on the rest of a reform agenda so we can reconnect the American people. All the ingredients are there. The question is will we be able to negotiate and come up with a proper agenda? And I think we can, but it's not going to be a day at the beach.
Would you include Senator McCain in that list, election reform?
Absolutely, but I would remind you that the fundraising begins before the election. So I think we ought to reform the fundraising first as well. But clearly we need to provide money for lower income municipalities and counties in order for them to have the same level of technology that wealthier areas do, so that every American has the same confidence that their vote will be counted in a fair and equal fashion. We need to do whatever we can to make sure that there's some uniformity in some of the other laws, but providing them with the assistance to upgrade their capabilities. Look, if you're a poor small town and you got $2 million, what do you spend it on? Build a new school or buy new voting machines? I think the answer is obvious. We need to help them out there.
You keep coming back to campaign finance reform. You don't expect President-elect Bush, though, to make that #1 on his agenda, do you?
Well, I hope he will. I think we could take it up immediately before the Bush legislative agenda is prepared, and we could dispense with it in 2 or 3 weeks, and we could set in a bipartisan fashion, and we could clean that up. And I intend to work very hard for President Bush's agenda. I hope he will work on this one with me. I promised millions of Americans, Larry, that I would do everything in my power to implement campaign finance reform and give them back their government, which is taken by the big moneyed special interests, and I don't intend to give up that agenda.
We're going to spend some more moments with Senator John McCain of Arizona, and then meet Lawrence Tribe, who unsuccessfully argued this case first time for the Supreme Court, and then check in with Pulitzer Prize winner Bob Woodward and Norm Ornstein, and then we'll hear from President-elect Bush. Right back with Senator John McCain after this.
Tired of juggling investments? Introducing the Orange CD from ING Direct. At 7.5% APY, it's the highest one-year CD rate available. There's no minimum deposit, and it's FDIC insured. Call 1-800-ING-DIRECT.
What counts in a mutual fund? Performance counts. The Kaufman Fund has consistently delivered. 10-year, 5-year, 1 year. What counts in a mutual fund? Experience counts. Kaufman Fund managers Lawrence Oriana and Hans Such combine over 70 years of experience. Performance, experience. The Kaufman Fund finding outstanding investment values for the aggressive portion of your portfolio. Call now for your free prospectus. 800-796-9334.
What would you do with a crystal face able to withstand 2 tons of unadulterated pressure? Or a tachymetric scale so precise it can survive 240-degree heat? What would you do with the world-renowned Alpha Expedition timepiece?
Well, you'd probably just use it to tell time. And at $6,500, that watch could cost you over $30,000 in retirement savings. We just thought you should know. Ask a financial advisor about Sun America, the retirement specialist.
Our company needed managed internet solutions. PSINet delivered.
We needed managed web hosting. PSINet fit the bill.
I wanted multi-currency e-commerce. PSINet was there in over 160 currencies.
We needed transaction solutions. PSINet executed the specifications on time.
Simply put, I needed everything, and PSINet gave it to me.
Your business internet opportunity is knocking. Open the door. Call or contact us today.
Tired of juggling investments? Introducing the Orange CD from ING Direct. At 7.5% APY, it's the highest one-year CD rate available. There's no minimum deposit, and it's FDIC insured. Call 1-800-ING-DIRECT.
Having a little satellite problem with Senator John McCain. As soon as we correct it, we'll get back to him. Let's get down to Miami, check in with Lawrence Tribe, the famed appellate attorney who argued the first time before the United States Supreme Court. What did you make of that ruling last night?
Well, it was obviously a disappointment, but I so much applaud the spirit of what the Vice President did this evening, which was to acknowledge that he thought the ruling was wrong, as I do, but to waste no time spilling tears over it, and instead to put all of his energy toward helping to unify the nation. And in your discussion with Senator McCain, what struck me in part was the reference to election reform. We've talked a lot about campaign reform, but one thing we've surely learned through this whole episode, an episode that I'm extremely proud to have been a part of, even though in the end it didn't succeed, is that we really need to take seriously the idea that every person's vote counts. And that really does mean better equipment and better methods of tabulating votes in poorer areas. It means using 21st century technology instead of punch hole ballots and chads and butterflies. And I think if we take that seriously, and if we encourage voting and make it easier and make sure that we don't simply fail to count people's votes, we will have made great progress, and this whole episode will have helped to advance the cause of justice and democracy.
Might we also need, Professor Tribe, more clarity in the legislative laws dealing with things like this?
Well, I think it helps, but I think it's an illusion to imagine that any legislature can see into the future and make sure that there are no ambiguities in what it writes and no conflicts. We will always have to rely on judges to reconcile those ambiguities the way I believe the Florida Supreme Court did. And we will always, I think, have to realize that the judicial process, even when we disagree with it, even when it's divided 5-4, is our surest path toward making a real basis for the rule of law to reinforce a constitutional democracy.
Well stated by one of our brilliant minds. Thank you, Professor Tribe. Now we've connected our satellite back into Phoenix with Senator John McCain. Senator, what do you think the future of Al Gore is?
I think he probably will have some competition. We've got Mrs. Clinton, obviously, as a very big figure in American politics. You've got Tom Daschle and Dick Gephardt, as well as others. So I think he may have some competition, but I think he frankly helped himself a lot tonight because I think Republicans and Democrats and independents were very impressed with his exit.
Would you want to leave the Senate if offered an appointment in this administration?
I would prefer not to, Larry. I think I have an agenda that I'd like to pursue and can most effectively pursue in the Senate.
Are you going to have a tough time since a lot of Republicans oppose your agenda? I mean, you know that going in, and you got a split Senate to begin with. Is it tougher this time?
I think it's easier. A number of the people who are defeated were opposed to campaign finance reform, and a number who have been elected are in favor of it. We have 60 votes now, Larry, so we can cut off debate, and that changes the entire dynamics. And again, I have every reason to believe that Governor Bush will work with us on this issue. I know that he knows that there are things that are badly wrong. And when you look at the incredible flow of money in this last election and all the negative ads and the so-called independent campaigns, that the time is right now to reform this system, as well as the fact that one of the reasons why we were gridlocked so heavily in the Congress is because the influence of the special interests which dictate the legislative agenda, which is tragic.
You expect a very good address in about 8 minutes?
I'm sure we will. I'm convinced we will. And again, as been mentioned before, Governor Bush has a clear record of reaching across the aisle. I'm sure he will do that this time, and I think that the center holds in American politics more than ever before, and he will govern from the center.
Thank you, John. Always good seeing you.
Thank you, Larry.
Senator John McCain. When we come back, we'll get the thoughts of Bob Woodward, the Pulitzer Prize winner, and the resident scholar of the American Enterprise Institute, Norm Ornstein. And we'll send you back for the speech by President-elect George W. Bush, and then we'll follow with part 2 of Larry King Live. Among the guests, Senator Bob Dole. Don't go away.
Between the travel and the tedium, training programs can cost real leaps in productivity. Go from training downtime to learning online, anytime, anywhere. Discover all that's possible on the internet. Cisco Systems, empowering the internet generation.
Leave the city behind. Leave everything behind. The 240 horsepower Infiniti QX4. Imagine the ultimate luxury vehicle. We have.
Around the world, mothers want to protect and nourish their children. So biotechnology researchers have developed golden rice. It will contain beta-carotene, a source of vitamin A. Golden rice could help prevent blindness and infection in millions of children. From medicine to agriculture, biotechnology is providing solutions that are improving lives today and could improve our world tomorrow.
What's the spin on the show that's got everyone talking?
Political talk of the frat boy variety.
Get real.
One of CNN's brightest new shows.
That's the ticket. The Spin Room with odd couple Bill Press and Tucker Carlson. Debating the day's top stories, exchanging barbs, and most importantly,
taking your calls, emails, and chat room comments.
and giving you a chance to voice your opinion. Check out The Spin Room tonight on CNN.
Now let's get some thoughts from Bob Woodward, the assistant managing editor of the Washington Post and author of the bestseller Maestro, the Greenspan's Fed and the American Dream, and Norm Ornstein, resident scholar, American Enterprise Institute. Norm, we'll start with you. What did you make of the Gore speech?
Oh, it was a perfectly toned and delivered speech, Larry. I mean, he was relaxed and did a terrific job. It will serve him well, whatever he does, although I'm not at all sure that he will start to resume a political career for quite a while.
Bob, did it surprise you at all?
Well, I think what Gore was really saying there was, I refuse to be a tragic figure. I'm going on with my life. I think on a scale of 0 to 10, it really was a 10. There was a lot of extra stuff in that speech. Not only did he refer to Bush as President-elect Bush once, he did it twice. On the Supreme Court's controversial decision, he said he disagreed, he was disappointed, but he said, I accept it, and then he went on to say, I accept its finality. He said in a very important way, there are duties much higher than party, and so he kind of set out this checklist of the perfect concession speech. He also made it clear he was conceding, and he said it is time for him to go. In a way, Bush ought to give him a big hug when Bush talks.
Norm, is this now era of good feelings about to continue?
We've got at least a week, Larry. And it'll be good. We will rally for a while. But remember, there are an awful lot of people who continue to feel outraged and bitter. It's going to be a challenge. And Governor Bush is going to have to, starting tonight, but certainly as he works through the rest of the transition, and then from the inaugural on, work very carefully to try and figure out how he can build some momentum at a time when momentum isn't going to be easy to come by and when there isn't going to be much of a transition or a honeymoon. You know, the electoral reform business is a good place for him to start, as many others have said, starting tonight, and it's got to include not just money for upgrading machinery. He ought to make a commitment to get the Justice Department to investigate some of these allegations of terrible problems in the African American community, and we need to move to, I believe, a election that's 24 hours over a weekend, a Saturday and Sunday, so that all the polls can close at the same time and we can get rid of some of these problems with exit polls as well.
Bob Woodward, we're showing you a tape of this was earlier, after Vice President Gore finished his short address to the nation. This is him hugging both Senator Lieberman, Mrs. Lieberman, and his family and Tipper. This took place right after Gore made his concession speech. Bob Woodward, are you very, very hopeful that we're going to get a lot of the same from the president-elect?
I am sure. I mean, everyone who praises Governor Bush or President-elect Bush praises that he has this political sense, that he knows exactly how to do the right thing, particularly at emotional moments like this. And this really is not just a political moment, it's a very emotional moment. And Gore handed him, I mean, you've talked about the bitterness and the division, and there is some of that, but Gore provided no fuel for continuing bitterness and division. And so now it's Bush's job to find some way to use that political ear people say he has and that we have frequently seen to strike exactly the right notes. And it's a very long dance he has to go through here, because the rhythms of a transition, as people who've assumed the presidency would tell you, it can really kill you. One bad appointment, one appointment that is stuck and you can't get out.
You know, Larry, one of the things he really needs to do is, as Bob said, is be very careful with his appointments. There are a few people who ended up being out front in the last few weeks who said some pretty volatile things. And it would not be wise to lead with some of those who will end up being held up by a succession of Democratic senators or who would rub some of these wounds raw. He's got to be very careful here on that basis.
Do you agree, Norm, that with Bob, that Al Gore handed him a pretty good platter here?
The best possible platter that he could get right now. Now he's got his own challenge, and he does. He's an immensely charming and magnetic man in a way that doesn't often come across on television, but it does in person. That will serve him well. But Gore has given him the best opportunity right now to begin to move forward, but no one should underestimate the challenge.
Thank you, Norm. Norm Ornstein, resident scholar, American Enterprise Institute. Bob Woodward will come back with us in the next hour. We will have part 2 of Larry King Live tonight. We're extended an extra hour, and we'll be on following the speech by President-elect George W. Bush. And our guests in the next hour will include Bob Dole, the former presidential candidate. We'll return with Senators Hatch and Breaux. Reverend Jackson, who has been heard a bit, will return with us. And Congresswoman Ilana Ross-Leviton will also join us. And then we'll have a panel of Barry Richard, Bob Woodward's return, Fred Graham of Court TV, and CNN senior analyst Jeff Greenfield. The Spin Room will air tonight at midnight Eastern. We're now going to turn it back over to our pals Bernie and Judy and the gang in Washington as they take you to Austin, Texas, and the speech by President Bush. Guys?
Thank you, Larry. We're a few moments away from hearing from President-elect George W. Bush. Earlier this hour, Vice President Al Gore bowed out of election 2000.
He made reference to last night's Supreme Court ruling, and he showed some of the fighting spirit that characterized his legal challenge. But he made clear this is the end.
Let there be no doubt. While I strongly disagree with the court's decision, I accept it. I accept the finality of this outcome, which will be ratified next Monday in the Electoral College. And tonight, for the sake of our unity as a people and the strength of our democracy, I offer my concession. I also accept my responsibility, which I will discharge unconditionally, to honor the new president-elect and do everything possible to help him bring Americans together in fulfillment of the great vision that our Declaration of Independence defines and that our Constitution affirms and defends.
Vice President-elect Gore is expected to meet with President-elect Bush Tuesday.
And the keys to the transition office will be given to Dick Cheney tomorrow afternoon.
Jeff Greenfield, moments away.
Yes, and you know, in some ways, the burden on George W. Bush is a little tougher than Al Gore. All Al Gore had to do was strike a graceful note and then leave the stage. But think, Bernie and Judy, the way we normally see a candidate for the first time as president-elect, having won a clear-cut victory on election night, surrounded by cheering supporters, confetti, balloons, the scent of victory, the clear assumption of power. George W. Bush is going to step out tonight in a very different climate. And one of the things I think we ought to look for, based on where he's giving this speech in that chamber, is I think the intention is to make it look more like a State of the Union speech, a much more presidential speech in terms of trapping than the speech of a victorious candidate, because that's not what George W. Bush can look like tonight after a victory solidified not by votes, but by a Supreme Court decision. So we should really see how they cast the speech in terms of setting as well as tone.
Well, speaking of how they're going to cast a speech, let's go right to Austin at this moment to CNN's Candy Crowley, who's been watching the Bush camp. Candy, what about that?
Well, they do know that the time for balloons and confetti passed on election night. And what they have, in fact, is Bush will be joined in the chamber by family, friends, staff, and some members of the Texas legislature. He's doing this on the Democratic side of the Texas legislature. He's being introduced by the Democratic Speaker of the House, and you begin to get the drift. This is about bipartisanship. This is his maiden speech for launching an end to the partisanship, which has become over the past 36 days an even more urgent need. When the guests arrive, there is a sign up that says, we need this tone to be respectful and dignified. Please be mindful of the fact that the entire nation is watching, and there are 4 rules to follow, one of which is no chanting and whistling, and no signs of any kind. This is not a victory speech. This is, as Jeff said, the first speech of the president-elect. Judy?
All right, Candy Crowley. And now to John King, who's been following the Gore effort. John, it may not have been the more difficult task of the two, but it was not an easy thing the Vice President had to do tonight.
Not an easy speech for the Vice President to step aside to say he strongly disagreed with the court's decision, but that he respects it, to urge his supporters to do the same. And now, after a campaign in which neither one of these men were viewed as great orators, this was viewed as a very tactical campaign. Vice President Gore trying to be a big man tonight. Now the burden in just a few moments on Governor Bush to be the same. And as Candy mentioned, we're told his biggest challenge now will be to reach across the aisle, reach out to Democrats. Time is short. This transition cut in half. Governor Bush is focused tonight not on winning an election, but on governing the country.
Bill Schneider, Vice President Gore preparing the stage for the governor?
Well, I think he did, because he essentially did not raise any questions about the legitimacy of George W. Bush's election. He called him the president-elect, didn't raise any issues about the fact that Gore actually won the popular vote in the country. There's a big question about Bush's mandate. The country is very closely split between the parties in Congress, of course, in the presidential election, everywhere. And even in the state legislatures, it's the closest balance between the parties that we've seen in almost 50 years. What kind of mandate does this give George W. Bush? He's going to try to define it in his remarks tonight.
All sorts of history associated with George W. Bush ascending to the presidency, only the second son of a president to move into the office of the presidency himself. You're looking at pictures of the Florida State House of Representatives. This is, I'm sorry, Texas. We've had too much Florida on the brain. Texas House of Representatives. This is the chamber where the governor's staff chose to make this important speech.
Look, listen to these statistics. Bush will become the 19th Republican president, the 17th governor to become president, the first Texas governor ever to become president.
This chamber is controlled by Democrats, and I think he chose it in part to make a statement about that. This is the chamber of the Texas legislature that is under Democratic domination.
Welcome to the Texas House of Representatives chamber. It was about this time, about 6 years ago, that we were preparing to inaugurate a new governor in Texas. Many of us wondered what kind of leader he would be. We wondered how he would bring everybody together after a hard-fought election. Tonight, many people in our country are asking the same questions about George W. Bush. When he became governor, he reached out to members of the legislature of both parties. We didn't always agree on issues, but we found we could have policy differences without having gridlock. We could have debate without bitterness, and we could reach agreements and solve problems without sacrificing our principles. Above all, we learned that Governor Bush is a leader you can trust and respect. It's my honor to introduce to you a man who has earned my trust and respect, the governor of Texas, my friend, the president-elect of the United States, the Honorable George W. Bush.
Thank you all. Thank you very much. Thank you. Thank you very much. Good evening, my fellow Americans. I appreciate so very much the opportunity to speak with you tonight. Mr. Speaker, Lieutenant Governor, friends, distinguished guests, our country has been through a long and trying period, with the outcome of the presidential election not finalized for longer than any of us could ever imagine. Vice President Gore and I put our hearts and hopes into our campaigns. We both gave it our all. We shared similar emotions, so I understand how difficult this moment must be for Vice President Gore and his family. He has a distinguished record of service to our country as a congressman, a senator, and a vice president. This evening I received a gracious call from the vice president. We agreed to meet early next week in Washington, and we agreed to do our best to heal our country after this hard-fought contest. Tonight I want to thank all the thousands of volunteers and campaign workers who worked so hard on my behalf. I also salute the vice president and his supporters for waging a spirited campaign. And I thank him for a call that I know was difficult to make. Laura and I wish the Vice President and Senator Lieberman and their families the very best. I have a lot to be thankful for tonight. I'm thankful for America, and thankful that we are able to resolve our electoral differences in a peaceful way. I'm thankful to the American people for the great privilege of being able to serve as your next president. I want to thank my wife and our daughters for their love. Laura's active involvement as First Lady has made Texas a better place, and she will be a wonderful First Lady of America. I am proud to have Dick Cheney by my side, and America will be proud to have him as our next vice president. Tonight I chose to speak from the chamber of the Texas House of Representatives because it has been a home to bipartisan cooperation. Here in a place where Democrats have the majority, Republicans and Democrats have worked together to do what is right for the people we represent. We've had spirited disagreements, and in the end, we found constructive consensus. It is an experience I will always carry with me, an example I will always follow. I want to thank my friend House Speaker Pete Laney, a Democrat, who introduced me today. I want to thank the legislators from both political parties with whom I've worked. Across the hall in our Texas Capitol is the state Senate, and I cannot help but think of our mutual friend, the former Democrat Lieutenant Governor Bob Bullock. His love for Texas and his ability to work in a bipartisan way continue to be a model for all of us. The spirit of cooperation I have seen in this hall is what is needed in Washington, D.C. It is the challenge of our moment. After a difficult election, we must put politics behind us and work together to make the promise of America available for every one of our citizens. I'm optimistic that we can change the tone in Washington, D.C. I believe things happen for a reason, and I hope the long wait of the last 5 weeks will heighten a desire to move beyond the bitterness and partisanship of the recent past. Our nation must rise above a house divided. Americans share hopes and goals and values far more important than any political disagreements. Republicans want the best for our nation, and so do Democrats. Our votes may differ, but not our hopes. I know America wants reconciliation and unity. I know Americans want progress, and we must seize this moment and deliver. Together, guided by a spirit of common sense, common courtesy, and common goals, we can unite and inspire the American citizens. Together, we will work to make all our public schools excellent, teaching every student of every background and every accent so that no child is left behind. Together, we will save Social Security and renew its promise of a secure retirement for generations to come. Together, we will strengthen Medicare and offer prescription drug coverage to all of our seniors. Together, we will give Americans the broad, fair, and fiscally responsible tax relief they deserve. Together, we will have a bipartisan foreign policy, true to our values and true to our friends. And we will have a military equal to every challenge and superior to every adversary. Together, we will address some of society's deepest problems, one person at a time, by encouraging and empowering the good hearts and good works of the American people. This is the essence of compassionate conservatism, and it will be a foundation of my administration. These priorities are not merely Republican concerns or Democratic concerns. They are American responsibilities. During the fall campaign, we differed about the details of these proposals, but there was remarkable consensus about the important issues before us: excellent schools, retirement and health security, tax relief, a strong military, a more civil society. We have discussed our differences. Now it is time to find common ground and build consensus to make America a beacon of opportunity in the 21st century. I'm optimistic this can happen. Our future demands it, and our history proves it. 200 years ago, in the election of 1800, America faced another close presidential election. A tie in the Electoral College put the outcome into the hands of Congress. After 6 days of voting and 36 ballots, the House of Representatives elected Thomas Jefferson, the third President of the United States. That election brought the first transfer of power from one party to another in our new democracy. Shortly after the election, Jefferson, in a letter titled Reconciliation and Reform, wrote this: "The steady character of our countrymen is a rock to which we may safely moor. Unequivocal in principle, reasonable in manner, we should be able to hope to do a great deal of good to the cause of freedom and harmony." 200 years have only strengthened the steady character of America. And so, as we begin the work of healing our nation, tonight I call upon that character: respect for each other, respect for our differences, generosity of spirit, and a willingness to work hard and work together to solve any problem. I have something else to ask you, to ask every American. I ask for you to pray for this great nation. I ask for your prayers for leaders from both parties. I thank you for your prayers for me and my family. And I ask you to pray for Vice President Gore and his family. I have faith that with God's help, we as a nation will move forward together as one nation, indivisible. And together we will create an America that is open, so every citizen has access to the American dream. An America that is educated, so every child has the keys to realize that dream. And an America that is united in our diversity and our shared American values that are larger than race or party. I was not elected to serve one party, but to serve one nation. The President of the United States is the President of every single American, of every race and every background. Whether you voted for me or not, I will do my best to serve your interests, and I will work to earn your respect. I will be guided by President Jefferson's sense of purpose, to stand for principle, to be reasonable in manner, and above all, to do great good for the cause of freedom and harmony. The presidency is more than an honor. It is more than an office. It is a charge to keep, and I will give it my all. Thank you very much, and God bless America.
From schools, Social Security, and Medicare to tax relief, foreign policy, and a strong military, Governor Bush saying tonight these priorities are not merely Republican concerns or Democratic concerns. These are American responsibilities. Whether you voted for me or not, I will do my best to serve your interests, and I will work to earn your respect. I was not elected to serve one party, but to serve one nation.
Jeff Greenfield?
Clearly, this was the speech that you would not have given on election night had you won an uncontested victory, a mandate. This is a speech by somebody who is speaking across the divisions that we saw election night, probably aimed more at the people who didn't vote for him than did. I was a little surprised to hear what we have sometimes called a laundry list of programmatic ideas. Normally, you save that for a later time. But I think what the president-elect was saying here was that, look, I have an agenda, but I'm going to describe this agenda in the broadest possible terms to suggest to you that I don't see this agenda as a cause of conflict. Now, we may well see in January or February how accurate that notion was, but clearly this is a speech pitched in tone to be cautious and to be conciliatory rather than victorious.
Candy Crowley in Austin, was that the goal?
That was the goal, and Jeff is absolutely right. This was aimed more really at the people in the party that did not vote for George W. Bush. This is their opening volley, if you will, in what they believe will be a long effort to try to pull the nation together. But what the Bush campaign knows, now what the president-elect knows, is that you cannot move forward on anything until the country is put back together. They have recognized all along from early on that the confetti and the balloons and the chants and the cheering, the time for all of that had passed, and what he needed to do tonight was to begin saying to the American people, I am here, I am the president of all of you, it's time to put politics behind us and begin governing one nation. Bernie?
John King.
Well, Bernie, obviously the election chapter closing tonight, both men, the Vice President and Governor Bush, trying to make that clear. Talk of bipartisanship, talk of reconciliation, talk of proving the system works. I think that's what both wanted to make clear tonight. This was hard fought, even went into the courts, both trying to make the case, but look, we will pass power peacefully and hopefully in a bipartisan manner. But I think already what was unspoken tonight is we're opening a new chapter. For 8 years, some Republicans in Washington have viewed Bill Clinton and Al Gore as illegitimate. Now some liberals in Washington will view George W. Bush as illegitimate. And the interesting question, I think, is can they actually reach to the middle and forge bipartisan cooperation in what is a very raw political climate here in Washington, not only after this election, but the legacy of impeachment still over this town as well.
Watching and listening very intently from San Francisco, Kenneth Kachigian, a former speechwriter for Presidents Nixon and Reagan, and here in the Washington Bureau, former Clinton White House spokesman Joseph Lockhart. Joe Lockhart, how did these words strike you?
Well, oddly enough, I think Al Gore did more for George Bush tonight than George Bush did for George Bush. And if he wanted tactical advice from me, it would have been to let Al Gore's speech stand on its own. I think Gore made the case more effectively that it's time to pull together and stand behind the president. I think Governor Bush got to it at the end when he talked about earning the respect and not just being a Republican president. But I think Gore's the one who can make the case more effectively. And I think when he looks back on this, I think he might have thought that it would have been better just to leave it there and speak tomorrow or later in the week.
Ken Kachigian, the speech, the message.
Well, the two words I pulled out of it were consensus and common ground, the two phrases. And I think this was an overture to his presidency. The thing I saw most, the theme, that the golden thread of this speech was he was reaching a hand across the aisle and extending that hand in cooperation, and that's a good thing. I think tonight he ended the talk of no legitimacy to his presidency. Today and tonight, he put that spike in the ground. It's going to be a legitimate presidency because he's willing to work, like he said, for consensus and across common ground.
Thanks very much. Judy, we began our election night coverage the night of Tuesday, November 7th, 5 p.m. Eastern Time. We stayed on the air until 6 a.m. the next morning. 36 days later, it's over.
5 weeks in a day, but who's counting?
No one.
All right, I guess that wraps it up for us, but now we want to go to our partner, our colleague, Larry King, to turn it over to you. Larry.
Thank you. The long haul, and you did a great job. We're going to have part two now of Larry King Live. We'll be with you right around the top of the hour, and then Wolf Blitzer will take over, and the Spin Room will air at midnight Eastern. Let's begin by welcoming a very familiar face to this program. Senator Bob Dole, the Republican presidential candidate in 1996, the majority leader formerly of the Senate. He spoke with President-elect Bush today, who you see now leaving the state capitol in Austin to head back to the residence of the governor. He'll be in Washington next week to meet with Al Gore on Tuesday. What did you make of both speeches, Bob? First, Al Gore.
I'd give him an A. I think he did a great job, an excellent job. And I'd certainly give him very high marks. And I think the same with Governor Bush. I think they both met the challenge, seized the moment, whatever the phrase may be, and they've started this sort of, I don't say partnership in the true sense, but they both indicated their willingness to do whatever it takes to start moving the country in the right direction.
What did he say to you today?
The governor? Yeah. Well, you know, you get calls from people, politicians and others, and you can sort of have the feeling that they're just calling to say thanks and goodbye, and they sort of want to get off the phone. But I felt today that he really wanted to visit about, not about me or not about him, but about certain people, and we had a very, very good visit, and I congratulated him, and I can't give you the details of the conversation, but I think he's ready.
Your thoughts on Al Gore tonight? You said you give him an A for the speech, and you thought it was good. You know what it's like to lose.
I know what it's like to lose. I mean, he still has what's 40-some days as vice president, and maybe that'll ease the transition. But when it's over, it's over. I mean, tomorrow's a whole new, not a new chapter, a new book, and it'll be the George Bush era beginning tomorrow morning. And Al Gore can still play a very vital role in American politics, American life. He's still a very young man. He's got great opportunities, probably, I don't know how many opportunities, but he can still have a very strong voice in the party, but more importantly, in the American policy, American life, whatever.
So you expect him to serve his country some more?
Oh, I think so. I mean, here's what... At his age, he has many, many years. I mean, and he may want to re-enter politics. When I lost in '96, I knew that probably age was a barrier. It was a barrier, but to any future campaigning or election or whatever political office. But there are a lot of things you can do, like serving President Clinton, as I've done in Bosnia and Kosovo, World War II memorial. I mean, Gore will have so many opportunities to be very effective and be very helpful that he probably won't be able to count them all.
Would it be wise then of President-elect Bush in this mood of conciliation not only to maybe put some Democrats in the cabinet, but to call on Al Gore for some duties?
Well, I would think so. I've always felt that people who have had that level of leadership, Vice President, President of the United States, should be utilized. Look what President Ford and President Carter have forged. They were like brothers. They're a team. They work together. And they've done a lot of good around the world. And certainly there are areas that I think if Al Gore is willing, he said he was tonight, President-elect Bush could reach out to him, reach out to President Clinton as well. I mean, this is about the United States of America. It's not about one person or one party. It's about our future, about our children, about our global responsibilities, and we need all the help we can get.
Now, in a country that's tied, in a Senate that's tied, in courts that were virtually tied, a tie, a famous football coach once said, is like kissing your sister. How's this going to work?
Well, it depends on, I think we had a great start tonight. I think Joe Lockhart said maybe Bush should have waited, but I think we've waited 36 days for this to come to an end. And I think, obviously, it was Gore's night in the sense that he was the one who was leading the race, but I think Bush, I think it was important that he follow on very quickly and say, this is what we hope to do in a general way. And I think this is the beginning. I'm an optimist. I never try not to look at the dark side. I want to look at the positive side. You know, the 50-50 split in the Senate, or whatever it may end up being, and the very close House division, and that might mean an opportunity for President-elect Bush, and it might be an opportunity for Republican senators. There'll be a couple on this program later, Senator Breaux and Senator Hatch, who have a reputation of working across party lines to get things done.
Earlier, when Sam Nunn was on with us, he talked about bringing people together and how this is the job that George W. Bush has to do, that the responsibility is going to lay with him. Do you think, though, that this mood of happiness can last? I mean, you know, no one knows it better than you.
It can last for a while. I mean, obviously there are going to be differences, and there are going to be elections up in 2002, and people are going to be campaigning in probably the next 6, 8, 10 months. There'll be all these campaigns that start over. But I think it can last probably 6 or 8 months, enough time to deal with prescription drugs and maybe Medicare reform, maybe tax cuts, whatever the priorities may be. But obviously we have different parties, we have different philosophies in a sense, but we also have this responsibility, wherever possible, when it's in the national interest, to work together. And the thing that struck me about Bush's speech, he mentioned race, I think 2 or 3 times in his speech. Yeah. Obviously reaching out to black Americans who voted against him, I guess 9-1, 90%. So I think he's made the right start. I think he got a great push by Vice President Gore at 9 o'clock.
One other quick thing: is Elizabeth interested in coming back to government work?
I don't know. I mean, she hasn't indicated that to me. I think she's looking for some mission field where she can be of some service to just generally, I mean, some humanitarian role she might be able to play.
Thanks as always. Great seeing you, Senator Dole.
Thank you. Good luck. More fun winning.
Senator Orrin Hatch and Senator John Breaux return with their thoughts on the Bush speech right after this.
Chrysler Town & Country. Re-engineered and redesigned with over 80 available safety and security features. Chrysler Town & Country. The best minivan ever. During the Chrysler Holiday Sale, get 4.9 financing on Town & Country LX or low lease rates.
The internet is faster because of us.
The internet is more reliable because of us.
The internet is growing because of us.
The internet is more exciting because of us.
The internet goes everywhere because of us.
The internet is better because of us.
Delivering the most content from the world's biggest network. Akamai.
Need extra cash for the holidays? Don't charge it on your credit cards. Get a second mortgage with no closing costs from Ditech.com. With a second mortgage, you can consolidate all your existing high-interest debts, get the cash you need for the holidays, and end up with one lower monthly payment. A second mortgage with no closing costs is smart money from Ditech.com. Log on now for fast online approval or call us at 1-800-71-FIX.
Does everybody know what this is? A heart.
50 million Americans suffer from high blood pressure. There are no symptoms, yet high blood pressure is the primary cause of heart disease. There are still millions who are unable to lower their blood pressure with medication. That's why we're developing this new medicine, and it has excellent effectiveness in treating blood pressure. Maybe by the time these kids are my age, we'll have found a way to prevent high blood pressure in everyone.
Beginning Monday, a dynamic new hour on CNN. At 8, Wolf Blitzer reports on the day's big stories on location, featuring the best of CNN's reporting, and Wolf going one-on-one with key newsmakers. At 8:30, get to the point with Greta Van Susteren as she takes on important issues in depth in her own feisty style to explain the problem and explore solutions in a way we can all understand. Wolf Blitzer and Greta Van Susteren, beginning Monday at 8 Eastern on CNN.
Now back with more of Part 2 of Larry King Live, and our dynamic duo returns. Senator Orrin Hatch of Utah, Senator John Breaux of Louisiana. They were with us in the last hour. Let's start this one with Senator Breaux. We asked Hatch first the last time. Senator, what did you make of the President-elect remarks?
Well, Harry, we saw tonight a great American tradition of burying the hatchet after an election, and not burying it in each other, but rather burying it for the sake of the future of this country. I thought both speeches were very good, right on target. I think this country is going to need some healing, however, for a certain period of time. This election has divided the country a great deal, and in the next few days, I think, are going to be about healing before we can start talking about legislating.
Senator Hatch, your thoughts on the governor and the president-elect's speech?
Well, both speeches were very gracious, and I felt like the governor certainly was holding out the hand of friendship. He was introduced by the Democrat leader down there in the state legislature, where he's been so effective in working with Democrats as well as Republicans and bringing them together. I think he's going to do that, and I really believe that he's going to be able to bring both sides together in good faith and get a lot done. But it is going to take a lot of effort on both sides to get together. And he covered an agenda, a general agenda. You know, he talked about Social Security and Medicare, education, prescription drug benefits, of course, tax cuts, and the military, all of which he would like to reform and strengthen and make better. And I think I can't imagine any Republicans or Democrats who will not want to work with him if he's going to embrace both sides and try to make things work.
Senator McCain tonight did speak of campaign finance reform. He thought that should be first on the agenda. 1, do you think it should be? 2, do you think it will be?
Larry, my advice to President-elect George Bush would be, let's find some areas where we can get an agreement. Let's try and show that we can work together, and that bipartisanship is not just a phrase, but it's a method of doing business. In that sense, I would recommend that let's not start with the things that divide us the most, but let's start with the things that we have a chance of coming together. I would prefer perhaps starting with education. We came very close to reaching a bipartisan agreement. I think election reform, as opposed to campaign finance reform, would be a better thing to try and bring and say, never again will we ever have an election in America like we just had. I think that would be something that there would be tremendous bipartisan support, so that it's more than just a phrase, but it's a way of doing business.
Senator Hatch, is election reform high on your list?
Well, election reform in the sense of what John is talking about here, John Breaux, I think it would be a terrible mistake to get into the very combative campaign finance reform issue right off the bat. I think the leadership will set a time where that can be debated, but it ought to be down the line a little bit after hearings and after both sides have had a chance to really look at it. Now, of course, John McCain will argue that we've been looking at it for a number of years, but that's not the thing to start with if we want to try and reach consensus and get people together and get things going. And I think it would be just terrible to start with that. So I do think the leadership will set a special time for that, probably 2 or 3 months down the line after hearings and after we've all had a better chance of seeing what we can do to really get together on those issues.
We asked this of others. Senator Breaux, everything's split in this country. The judiciary split, the Congress is split, the House, the Senate, the vote, the public. Does this mean moderation, we asked this of Senator Nunn, prevails?
Larry, I think that what we've seen in this election is a split on policy differences, but not on the things that I think that are really the most important about how we run our country. And I think that that is the fact that people have sent us a message that's pretty clear, and that message is they want us to work together, that they're tired of the bickering, they're tired of the fighting, they're tired of us playing the blame game in Washington of blaming each other for failure. But while there may be policy disagreements which showed up in this election, that there is one clear message that all of us should take to heart, and that is they want us to work together for the common good of this country. And I think that if we learn that from this election, we have gone a long way to healing this country and bringing everyone back together again.
Your optimism high, Senator Hatch?
It is high right now, and I believe that George W. Bush has a reputation for doing this type of bipartisan work and working with both sides, and I'm hopeful that he will. Look, we all know that we've got to strengthen the educational systems of this country. We've got to solve the problems of Social Security and Medicare. John Breaux on the Breaux-Thomas Commission has done a lot in that area, but we weren't able to get it done up till now. But I think we can with George Bush. There's no question that I think you got to combine prescription drug benefit program with tax relief. And we were just told today by Senator Domenici that there's going to be an extra $1 trillion there if we can keep the economy going the way it is. And tax relief's important in that particular end of things. And of course, the military, we've got to strengthen the military. We can no longer allow it to languish and go downhill like it's been going downhill.
Thank you both very much. Thanks for hanging tough tonight in both segments. Senators Orrin Hatch and John Breaux. And when we come back, Reverend Jesse Jackson will join us from New Orleans, and Representative Elena Ross-Lehtinen will join us from Miami. That's next on second edition of Larry King Live. Don't go away.
Join Bill Press and Tucker Carlson in the Spin Room by phone, chat room, or email. Tonight at a special time, midnight Eastern on CNN.
Ready to get interactive? Visit www.cox.com and log on to a new interactive shopping experience from Cox Communications. Go places only you can go for services especially for you. View your current charges, screen pay-per-view clips for larger-than-life action adventure, and browse the upgrade center for just the right additions to your viewing entertainment. Take control of your entertainment. You know the address, www.cox.com.
Now you're living.
Get to the bottom of the day's issues with Greta Van Susteren, weeknights at 8:30 on CNN.
What counts in a mutual fund? Performance counts. The Kaufman Fund has consistently delivered. 10-year, 5-year, 1 year. What counts in a mutual fund? Experience counts. Kaufman Fund managers Lawrence Oriana and Hans Such combine over 70 years of experience. Performance, experience. The Kaufman Fund finding outstanding investment values for the aggressive portion of your portfolio. Call now for your free prospectus. 800-796-9334.
I'm so excited about this. You know how easy it is to take your home videos and turn them into movies? Listen to this. You get an iMac, of course. Get your digital video camera, hook it up, and start iMovie. They've got effects in there now. You can, make it real fast. Ooh. Or get slow motion, make it dramatic. Or you can take a piece of music, put it under your footage, and all of a sudden, people are laughing, crying. I don't know, whatever you want. I've got cheesy ideas, but you'll do something creative that'll make you want to go, ooh, let's watch that again and again and again and again.
This is the hardest thing I've ever done. I mean, these people were like family to me. Remember I met Jeannie at the company picnic?
It was the best thing ever happened to you.
Yeah, taking the new job was a tough decision. Deciding what to do with my 401k money was another. I didn't want to mess it up. I called T. Rowe Price. You know, you told me about the mutual funds.
Uh-huh.
Yeah, well, they sent me a rollover kit, you know. Took me through it step by step.
I made it easy for you.
Yeah, piece of cake.
T. Rowe Price, helping people invest with confidence for over 60 years.
It's going to be a good job.
Yeah.
Welcome back. We now welcome Reverend Jesse Jackson, the founder and president of the Rainbow and Push Coalitions. He's in New Orleans. And in Miami, her home, is Representative Ileana Ross-Lehtinen, Republican of Florida. Reverend Jackson, you said earlier today that President-elect Bush was elected legally but doesn't have moral authority. Did he assuage that a little for you tonight by referring to black Americans twice in his speech?
First of all, he must be congratulated. He will be our next president. America is a great nation, and because we are also great with the responsibility, the political and economic stability in the world, we must find some common ground. That means reconciling the extremes and dealing with the issues that matter. Issues of campaign finance reform, so money does not displace common people. The issue of voter reform, Patients' Bill of Rights, issues that really matter must somehow bring us together. And then we must be tough enough and honest enough to address the unfinished issues that carry over. Because while we speak of healing, you cannot have real healing unless you get the glass out the womb.
But the question was, by referring to blacks, and he only got 10% of the black vote, did that make you think that he's going to be very constructive in that area?
Well, I would certainly hope so. But you see, in Florida, I'll be speaking tomorrow at Lorraine Motel in Memphis where Dr. King was killed, because we're kind of getting back to the civil rights issue, which is before us, because in Florida, many African Americans feel that he won at their expense. He must address that. I mean, 8,000 notices were sent to remove felons from the roll. 85% were black, but non-felons, they were misdemeanor. Many of them lost their right to vote. In Duval County, they removed 27,000 from the rolls and held them past the point of protest. 18,000 were black. So that point is there's a lot of pain, but I'm convinced that a president has the power, if he has the will, to help build these bridges.
Congresswoman Ross-Leighton, does what Jesse just said make a point with you?
No, it really doesn't. I mean, obviously, George W. Bush has been the governor of a huge state that has a lot of African Americans, and he's enjoyed a very warm working relationship with them, as he has with Hispanic Americans. And the state of Florida does not have a policy to disenfranchise anyone, any minority group. That there have been some problems with the ballots in Florida. Those are problems that will be addressed and properly addressed at the state level. Those are state issues, and I think that you will see Jeb Bush, the Governor Bush, address those in the state legislature. But I think that what President-elect Bush said tonight was very clear. He is a uniter. He wants to unify our nations, and he wants to work on common grounds. He needs to do that because the legislative session is going to be very tough for him. He's had that kind of record of unifying both parties in Texas, and he's going to do it in Washington as well.
Well, Larry, see, I think that he can do that, and he must do that, and we should work with him on that, because it is in our national interest to do so. After all, our national interest is greater than the White House. It's greater than the presidency. So we cannot become so landlocked in this tough campaign until we do not see the bigger picture of growth. But I submit to you tonight that what will bring us together in the end will be a sense that there's an even playing field, a sense that all Americans count and have a role around the table. It is he who must, in fact, provide that sense of a place around that common table.
Congresswoman, you serve with Jesse Jackson's son, the congressman from Illinois, and you have opposite thoughts on many things. Do you expect this Congress to work in the kind of harmony we've heard tonight?
Absolutely. I have every faith that Jesse Jackson, the Congressman Jackson, has that type of unifying spirit. And I know that President Bush is not going to sacrifice his principles, but he's also a practical man, and he will try to find that middle ground so that we can move the legislative agenda that he outlined: Social Security, Medicare, Medicaid, prescription drugs, education reform. These are all of the topics that he discussed for months and months throughout the campaign. He's going to make good with them, and I think that you will see the Democratic leaders, if they have their heart in the right place, and I know that they will, we will all work together to get the job done for all Americans. It's time to say the election is over. We want to fix the problems that occurred in Florida, but let's unite, let's work together, and let's get the job done.
Thank you both very much. We're out of time. Reverend Jesse Jackson, the founder and president, we'll see a lot of you, of the Rainbow and Push Coalitions, and Representative Ileana Ross-Leighton, Republican of Florida. When we come back, our panel will assemble, but we're going to begin by talking with Barry Richard, the Bush campaign attorney who's gotten very famous out of all this for arguing most successfully most of the time in Florida. And then our panel, and Jeff Greenfield will be right with me. Don't go away.
After a difficult election, we must put politics behind us and work together to make the promise of America available for every one of our citizens. I'm optimistic that we can change the tone in Washington, D.C. I believe things happen for a reason, and I hope the long wait of the last 5 weeks will heighten a desire to move beyond the bitterness and partisanship of the recent past.
A's, C's, G's, and T's. Hidden in all this genetic code is the genetic cause of disease. With microarray technologies from Agilent, scientists can now find those causes faster and start turning code into cures. It's a great time to be alive. Agilent Technologies. Dreams made real.
When was the last time you felt 284 horses tugging at your soul? When was the last time you immersed yourself in hand-tufted virgin leather? Can you really put a price on this kind of perfection?
Actually, you can. Because this $70,000 car could cost you over $326,000 in retirement savings. We just thought you should know. Ask a financial advisor about Sun America, the retirement specialist.
The largest airline on Earth isn't an airline. It's 14. Make that 15 airlines working together to make international travel easier.
Tonight, join Odd Couple Bill Press and Tucker Carlson to give us your spin on the day's hot topic. By phone, chat room, or email in the Spin Room. Tonight at a special time, midnight Eastern on CNN. Beginning Monday, a dynamic new hour on CNN. At 8, Wolf Blitzer reports on the day's big stories on location, featuring the best of CNN's reporting, and Wolf going one-on-one with key newsmakers. At 8:30, get to the point with Greta Van Susteren as she takes on important issues in depth in her own feisty style to explain the problem and explore solutions in a way we can all understand. Wolf Blitzer and Greta Van Susteren, beginning Monday at 8 Eastern on CNN.
In a moment, our panel will assemble on part 2 of Larry King Live. I want to get a few words in with Barry Richards, the Bush campaign attorney. Barry comes to us from Tallahassee. Guess what? Tomorrow night, Barry will be here with us in New York, and we're going to do a first of all the times we've interviewed him. We're going to take calls tomorrow night for Barry Richard. Ralph Nader will also be here. What does it feel like now to have it all over?
A relief. Relaxing.
Were you at all surprised in any aspect of the Supreme Court decision last night?
No, I wasn't really surprised. I anticipated that my expectation, although, you know, as I've told you several times over the last month, I try not to predict courts, but I anticipated that the majority would come down that way. I think most of us did because of the earlier rulings, and would have been surprised if it had not come down like that. I was assuming they were striving to get as close as they could to unanimity. I was frankly impressed that they were able to get 7 members on at least a portion of the opinion.
Do you think the legislature will have to look at its laws a little here because obviously there was confusion on everybody's part dealing with the court and what it had to say in 2 different aspects, right?
Yes, and I think virtually every legislature in the United States is probably going to be looking at its election laws, and I think Congress probably is, and we're going to probably see some changes, although a lot of the problem which stemmed from the punch cards might go away just because states stop using the punch card machines.
Barry, we look forward to seeing you here tomorrow night. It'll be nice to finally be back together again.
I'm looking forward to it as well. Thanks.
Barry Richard, he'll be here tomorrow night, and he will take your calls. Let's assemble our panel. They are in Washington, Bob Woodward. He's back with us in part 2. Assistant Managing Editor of The Post, Pulitzer Prize winner, and the author of the bestseller Maestro. Fred Graham's here for another evening, Chief Anchor and Managing Editor of Court TV, formerly with CBS and the New York Times. And our own Jeff Greenfield, CNN Senior Political Analyst, a veteran observer of the political scene. We'll start with Jeff. What did you make of the Bush speech?
I will be blunt with you. I was a little disappointed in it. There's nothing wrong with it, but I was surprised that there was so much leftover rhetoric. Leave no child behind, Laura Bush will be a great First Lady, Dick Cheney will be a great Vice President, the kind of thing you can say in a campaign speech. And I would have thought that after 36 days that have left all of us battered, that there would have been a completely new tone in the speech, recognizing what we've been through to a larger extent. I think toward the end of the speech, when he talked about reconciliation and bipartisanship, I thought he hit a stride, but I think they might have been better served to use a single line that they had used in the campaign, because this is such a different universe.
Bob Woodward, what's your reaction?
Well, I guess I kind of disagree, because the president-elect was trying to connect the campaign to the transition and what he's going to do next. It was a high-minded speech. It had a lot of anti-politics themes in it. I thought symbolically using the Texas legislature worked where there was a lot of bipartisanship, but the Texas legislature is to the U.S. Congress to a certain extent as ping pong is to the hammer throw. It is a very different forum. I recall a couple of years ago Bush's father, President Bush, writing me a letter saying that Washington is like Dodge, suggesting that they almost shoot you at random. It's a very hard place, and if you just look at Bush's father, when he became president, the first controversy was the John Tower nomination to be Secretary of Defense, which was very bitter. No one could disentangle it. It went on for months, and it was not until March, I believe, that of all people, Dick Cheney was picked to replace Tower.
Fred Graham, when we went off the air last night, we were awaiting that decision. Did it surprise you?
Well, you know, I got that one right. You asked me right before they told us that the decision was about to come out, what did I think it was going to be? And I said, well, I could never guess the configuration, but I thought it was going to bring finality. And I was right on that one anyway.
All right, are we, this merry get-together, Jeff, is it all going to work? It's also, except for Senator McCain on this program who said campaign finance reform, and the other senators kind of put that down. This is all like, we're buddy-buddy.
12 years ago, when George Bush, the father, was inaugurated, he used a line in his inaugural, we didn't come here to bicker, and he said, I'm reaching out my hand to you. Mr. Speaker, Jim Wright. And that lasts about, 3 or 4 days. I think if there were any time when you could legitimately think there might be a sense of bipartisanship, it might be now, because this election was so unusual, and also because the stakes are relatively small. I mean, for all that Washington people can make any issue World War III, there's not a lot on the table compared to other eras. However, against that, we have had 20 years or more of a steadily embittered, politicized Washington, where civility has been a sign of weakness, to quote John Kennedy. And I think when you look at the fact that Jesse Jackson yesterday or today said this election was stolen, Tom DeLay, the majority whip, said a couple of weeks ago, we're witnessing the theft of the presidency. I'd be very surprised if even this climate can damp down a 20-year habit on both sides.
We'll be back with some remaining moments in part 2 of Larry King Live. Don't go away.
It has arrived.
Listen to me. We have absolutely nothing to fear.
We're never going to survive this, none of us.
Something so powerful.
There's something wrong here.
Something so advanced that it knows no boundaries.
We've got to upgrade the server. It's our only chance.
Sun Microsystems presents The Dot. Your competition will never know what hit them.
Is my meeting today in the morning or the afternoon?
Afternoon.
My office.
Her office.
Good. Love you.
Electronic organizers, just one of hundreds of business gift ideas in Office Depot's Holiday Gift Guide. Pick one up at the Office Depot Superstore near you.
Oh, and it's your mom's birthday Friday.
Taking care of business for the holidays.
Have your bags been in your possession since you packed them? Did you know your company's stock just jumped 13%?
No.
Did you know Geldman got food poisoning and can't make the meeting?
What?
Sir, I'm going to have to ask you to check your email before you board.
How?
Here. It's the Sprint PCS Wireless Web for Business. You can access your company's network, use email, share information in real time. And the calls are clear.
Thanks.
Thank him.
The Sprint PCS Clear Wireless Workplace. Because business can't wait.
A 260 horsepower CL Type S from Acura.
A year ago, these internet whiz kids were riding high. Today, they're out on the street and picking up the pieces. Willow Bay asked some .com casualties what they learned, and would they do it all again? The Moneyline News Hour, tomorrow on CNN.
What's the spin on the show that's got everyone talking?
Political talk of the frat boy variety.
Get real.
One of CNN's brightest new shows.
That's the ticket. The Spin Room with odd couple Bill Press and Tucker Carlson. Debating today's top stories, exchanging barbs, and most importantly,
taking your calls, emails, and chat room comments.
and giving you a chance to voice your opinion. Check out the Spin Room tonight on CNN.
Bob Woodward, is this going to be a moderate administration? Are we going to see moderate appointments?
Well, he's almost pledged that, but you know, there is again this idea of that somehow he's going to change the tone of Washington. I think that would be a wonderful thing, but political fights are not necessarily bad things. My first take on all of the 5 weeks of the Florida mess is it was a political fight. No one died because of it. People learned a lot. People got to understand the intricacies of ballots and so forth. No one put a gate on the end of it. It never became Florida Gate or Ballot Gate. So I think it's sometimes it's good to have a political fight. The good news for Bush, I think, is he's going to have some people in his administration who have a lot of experience. Andrew Card is the White House Chief of Staff, apparently. Cheney is going to be there, and Cheney is as solid a rock as there is. Colin Powell's going to apparently come in as Secretary of State. So there will be lots of advice and people who have seen things come over the hill and know how to take them out.
Fred, are you, was it fair to say, are you optimistic?
Well, you know, I think that Governor Bush did a good job tonight, and I really don't agree that much with what Jeff said, that the divisions are going to break out right again. You know, it's extraordinary to see the kind of speech that he gave, the first speech as president-elect, and see so much of it was calling for civility and courtesy and cooperation, because you would think that everyone would just assume that that's the way you run a government. And yet we've had so much acrimony over the past few years that the public has risen up against it. And I think one thing that will be different, I think this is the area in which Governor Bush is going to be able to show that he can get results and make things work out the way he wants to. One thing that's happening is that he's got Congress, the same party as he is. So we're going to see an end to government by investigation. Those Republicans aren't going to investigate him, and the independent counsel law is gone.
Yeah, we're out of time. On a scale of 10, Gore's speech.
8 or 9.
Thank you all very much. Bob Woodward, Fred Graham, and Jeff Greenfield, they'll be on frequently, as they frequently are. Wolf Blitzer hosts the next hour. This has been a two-parter of Larry King Live. We'll see you tomorrow night with Ralph Nader and Barry Richard live with your phone calls. Good night.